What is up? Good morning. So this started earlier than I thought it was. I thought it was going to go 10. We missed a little argument, which was pretty interesting. I'm excited to stream this trial. Really just across. I've been excited about this trial. If you guys follow me on Twitter, you know. I think this is the biggest case going right now by far. I know Traconis is going, and we all want justice for Jennifer Doulos. This case is different. This case has this really has the potential to have a massive impact on our country moving forward. And I can't understate it enough. If people are just thinking that this is some annoying defendant lawyer and some shitty mom trial, think again. I mean, it's got much bigger ramifications potentially than all of that. So I'm excited to do it. So there was some early argument this morning, and it had a lot to do with the fact that it's really going towards the indicia of guilt, the fact that they considered both of the Crumbleys to have been in flight, like of trying to evade justice. So they've been trying to do this thing with, showing that they were basically running, and her lawyer has been putting forth the defense that they weren't running, that they were simply trying to get out of Dodge for a second, that they were already out of Dodge when they found out that the charges were being pressed, and that basically where they're at right now is that, look, they've retired, like they found out there's charges, they've retained an attorney, and the attorney's trying to work out whether or not or when she's going to turn them in, and which is not unusual. It's just not. I saw towards the end of it yesterday, Shannon Smith wasn't selling it real well in terms of, and I think she was really caught off guard. When they started talking about being able to put her attorney-client privilege text to her client because the door was open during her client's testimony, like that. I just wish I was doing it yesterday with y'all, because that is the nightmare scenario where your client unwittingly opens the door potentially to the state being able to get in things that they otherwise weren't going to be able to get in. And there's no walking it back. Like, there is no way to fix it. It's like you could prep your client all day. And as annoying as you all find Shannon Smith to be, she's a good lawyer. I know that I know her voice can be grating. I know that she's annoying in a lot of different ways. I know that she objects constantly. I know that she apologizes constantly. She's overly apologetic. Fact of the matter is that this is an intense trial that is super fact heavy, that there's a ton of evidence, and she's trying it on her own. To me, the biggest mistake that she's made is trying to try this case by herself without having a trial partner, because trying to keep your mind straight and focus on what's happening in front of you on the stand, and then trying to get through your discovery and trying to figure out what the state is using when they're questioning certain witnesses in terms of, I got to find what they're referring to. Like, trying to do that all by yourself is a nightmare. So I have a very different view of her. I can certainly see why people out there are annoyed by her. There's no question about that. I can see how she'd come off. It was funny. I was telling Allison about it last night, and Allison's like, she's like, that's why I'd never want to try a case on TV. Everybody'd hate me. And I'm like, yeah. Like, I see a lot of Allison in Miss Smith. I do. She she is really, really, really fighting hard. And I know she's bugging the shit out of people. I know that. And I'm so glad Jay was in here. Jay, I meant to text you this morning. I believe today is Jay and Shannon's anniversary. Jay, can you let me know that that's true? If so, I love you guys. Happy, happy, happy anniversary. I wish I could be with you to give you a massive hug and big kisses on the cheeks and take y'all out to dinner. But if it is, Happy anniversary, y'all. Shans, I don't know if you're up and about yet. We love you. Jay, obviously, I love you, brother. Happy anniversary. That's so exciting. I hope you guys are gonna take care of each other tonight, do something special because you earned it. You earned it. But Jay, I was gonna let you know I meant to text you when I thought that this was gonna start at 10:09 my time. I was gonna see if you wanted to jump on with me at some point today, but it's your anniversary, dude. So you already gave up a birthday to hang with Allie on that big Supreme Court day. So, dude, listen, man. I don't want you to feel obligated. I could definitely carry the load here today. But I'd love to have you on if you want to jump on for a bit. All right, so I'm excited about today. All right. There are a lot of issues going on that are really interesting. Um, kind of and I really wanted to cover this trial from the get. It's like Jay was covering Chaconis and Nerdy was covering Chaconis. I didn't really want to kind of jump in and step on toes. This thing today, I didn't care who was covering what. I was going to have to step on toes because this is just a very important trial because ultimately what happens is if Crumley and Sunny, when she was on with us, like her and I broke it down for y'all. If you like that video is my most favorite thing that I've done. Like all the bows know Sunny's as legit as it gets. And like the two of us together, just kind of like being able to like just talk that thing out, man, was like some next level shit. And for me, when I read her tweet, because I was originally going to have Josh on, who's a brilliant lawyer, man, and a great friend. And then he had to bail because he has his kid on Thursday nights. So he's like, dude, I'm like, that man, no excuse necessary. I get it totally. Like kids first, always, man. It's like that's my jam, dude. So so then I was going through the tweets and I saw like Sunny's tweet that she had tweeted to her LinkedIn. And I'm like, oh my God, like Sunny's like spot on. So like everything that I've been saying about what this trial means is like so on point. So I had her on and it was amazing. And I'm just suggesting that if you haven't watched it, you do, because if you're missing what the bigger picture of this trial is, I'm going to try to nutshell it for you right here. If she's found guilty, it then changes the way that the criminal justice system is going to treat parents moving forward in perpetuity forever. Because this is a thing where, look, and I like my needle has moved a little bit, like a teeny bit in terms of once I started hearing some of the evidence. Because look, I think they're oh, good, Jay. Give me a second until I'm done with this ramble, and then I'm going to shoot you an invite. Or Mandy, if you're in here and you could shoot Jay an invite, that would be beautiful, and I'd appreciate it. So once we get to, if there's a conviction, it's going to affect the way that all law enforcement all across the country and prosecutors are going to look at how to treat parents of children that commit incredibly violent acts such as this. And up until this point, now there's the Crimo kid, like, which was here in Illinois, the Highland Park parade nightmare shooting. Very similar circumstances in that they definitively knew that the Crimo kid had issues mentally, and the old man knew about it and then signed. In Illinois, you have to get a firearm owner's ID. It's called a FOID here, and you have to sign an application. Illinois is very strict about the gun thing. It's not Michigan. It's not Iowa, where you can just roll in and buy a gun. You've got to really kind of go through the process, which I appreciate. I'm not like I'm good with the Second Amendment. I am. But that's only like that's not because I want to walk around with a gun all the time. That's because I don't necessarily trust our government, and that's what the Second Amendment's really about. Like, if we have to take up arms against our own government because of tyranny, then I'm all for it. Like, I don't want them to be the ones that have all the guns. So that's why the Second Amendment exists, not so that people can have AR-15s and shoot up schools and concerts and shit like that. So let's just be clear about that. Like, if you want to get constitutional about it, and you want me to get on my Second Amendment rant, I'll do it. But that's not really, I mean, that's always an overarching issue in this trial, right? Like that's, we can't pretend like that's not why everyone's here, because it is. So yeah, I'm pro Second Amendment, but I'm pro gun control, because shit's out of control. And that's like, when I've got kids in school. So, if you want to talk nose to nose with me about how you want your gun and your AR-15, I'm happy to do it. Because while kids are shooting up my kids' schools and other kids' schools, and kids are dying, something's got to be done. Common sense dictates that. No one's trying to take your goddamn guns away. All right, enough. Okay, so I got a little off track there, but like I'm very passionate, as you can tell, about the gun thing. The gun control issue is something that strikes deeply. It's because I have kids. I have children that are in schools. Like, when I was in school, and for everybody that's around my age, we didn't have active shooter drills. Never heard of it. It's insane. What we had was, tornado drills, fire drills. If you're in California, you had earthquake drills. Now my kids are preparing, for the event that there could be an active shooter in their school. I mean, it's unthinkable. It's like the damage that does psychologically to children, in terms of them having to like, that's a thought in their head, that one day somebody could come in here and try to kill us all, is, it just sucks. Like, who wants that for their children? I know I don't. Like, that is not what I want for my children. Like, our country, I say it all the time. We were born out of savagery. We were born out of violence. We were born out of revolution, and we have not moved the needle at all. All right. So, hey, y'all, I see all you. Thank you all for coming. I'm super excited about kind of my first actual live stream of any trial. I jumped in and babysat for Jay with Murdoch, because he had some stuff to do that day, and then had a furnace emergency. So that was a situation where I was happy to jump in, and it was fun. I had a lot of fun. And this is going to be interesting. I bring a little something different to the table than a lot of our streaming homies. I could bring that legal analysis, and look, I'm not going to be defending Miss Smith's behavior, in terms of, because I watch her, and like, if I'm being honest, she kind of gets on my nerves too. But like, you have to be able to separate that from whether or not she's doing a thorough job. Now, she's made some blunders, no question. I mean, this thing where, if they're going to allow for her attorney-client privilege communications with her clients in order to get that particular stuff in. Oh, what's up? What's up? Let me see where Jay pops in. Jay, I got to figure out where to pop you in. Mandy, can you work on that while I'm talking? Jay just dropped in backstage. He's here. We're going to figure it out. Like, Mandy's trying to get me to quit StreamYard. I'm like, no, we're going to figure StreamYard out. We just need to figure this particular, we need to figure out the layouts, because I'm barely covering the law and crime thing there. So let me see, Jay. I want to figure out, let me see how this, I think see, that one doesn't work. Jay, do you know of a way to be able to cover that thing easy?
The law and crime. So
Yeah.
on mine, like, I don't know if they have that on your program. It's called an overlay. And
Yeah. Well, yeah, that's what this thing is. This is an overlay right here.
But like, do they have like I can just put up a little box as an overlay right over it. That's what I do. I put my logo right over the. So I don't know, like, is it just full screen, or do they have it so you could just put a little
I
logo
don't know.
over?
It's got like, It's got brands. Like, I can put my logo, but it pops. It's like it doesn't. Like,
You
it's
can't move
not.
it around, like, you can't drag it down?
I don't know.
There's gotta be a way, because I think other people there's gotta be a way
There's
to
got to be a way, dude. Because other people like StreamYard's the number one used thing. Here, let me show you this. Stevie made me this one. Sorry, y'all. I know you guys are getting some behind the curtain shit here. Check this one out. Stevie made this overlay.
Well, it blocks the logo.
I mean, it definitely blocks the logo.
Oh, look at Josh is in the chat. What's up, Josh?
Let's see. Stevie said he was going to be in here. Stevie, you know I'm tech ignorant, man. I need help blocking this thing. Or let me see. What else could we do? Like, if I could add you to this other side with me and put that overlay back on, we good. Because this overlay blocks it pretty much.
So you can't add me and, like, under you on that side?
I think I should be able to. Like,
When I was on, I could drag it. Like, I clicked on the box of the person. You could drag it. You can move it, but I don't know if it
hold on,
changes it from.
I'm gonna throw you. Like, I should be able to. There you are. All right. So let me make you about this big. Move you over here. Grab this guy. Wait. Okay, now I just want to move you. I want to try to move me up. Like right here. Look at this. You ever seen a tech guy like me, man?
This is impressive, bro.
Crushing the tech game. All right. Okay. I think
Sarah just gave out 5 memberships and Shannon got one. Oh, look, you did it. Look at Bob. Real time. Figured this out. Look at this.
Wow. Hello. All right. Hey, dude. Happy anniversary, brother.
Thank you. Appreciate it.
I'm so excited about you. Y'all gonna do some dinner tonight, I hope.
Yeah, we're doing a nice happy hour. Bob, I feel like I'm opposite from you, where I feel like you're probably very, you spontaneous. You could just go out, figure something. Like, I need to know the place, the time, the menu. Like, I've already scouted the menu. I know what we're getting. The happy. I know we're gonna sit. I'm very. I'm not good in social situations.
You're not Mr. Spontaneity is what you're trying to say.
No, I am
which is
not.
fair. There's a lot of advantages to that because I mean, you know what you're gonna get.
Right.
Like I've gone to places and been incredibly disappointed because I didn't do my research up front. You know what I mean? So it's while it's nice to be able to spontaneously do shit, it also can really, really bite you in the ass. So, it goes both ways, dude.
Yeah.
It's a blessing.
I'm glad we could talk about this because you are similar to me in that we both have kids. And I heard you talk it before I came on. We both have kids in school.
Yep.
This is my nightmare. Like, that something like this could happen. And like you said, like our kids from pretty much when they've been in kindergarten or a little bit older have had to do these drills. And, I was trying to think of an analogy because I was thinking about this trial. And, like, if we looked at another species and they had some, like a monkey or something, and they had some sort of like a rock that they could use, and they threw it and it would kill like a bunch of their kids and like a bunch of their baby monkeys, whatever. Right. We would look at and nothing changed, and they would never change because a few monkeys got a bunch of bananas. You know what I mean? Like we would look at this, we'd be like, what this species is not evolved. Why are they letting this happen all the time? Like, why are we letting this happen? It makes me insane that. And there's a famous tweet, and it was said something like, I guess we should have known after Sandy Hook, when all those kids were murdered, that if nothing was going to change then, nothing is going to change. Like, why is this not changing?
It's insane, man. Well, I mean, it starts with the NRA.
Right.
That lobby is ridiculous because they don't give a fuck about anything other than money. Exactly. Like them touting the Second Amendment. Like I said, if anybody wants to ever step to me and argue about the Second Amendment and why the fuck it exists, I'm happy to do it. Because it ain't this. Like we're given the ability to be able to like gird up arms against our oppressors. Like if a government tyranny, that's because remember the Constitution was drafted when the Brits were here and they were kicking in our doors and they were quartering in our homes and they were just running shit and primo nocte. We're going to mount your wife on the first night of your marriage and impregnate her so we get rid of the, I mean, that kind of shit, dude. That was the kind of shit we had to get rid of that's why the Second Amendment came about. So, yeah, obviously I'm with you, man. Like, and I'm not anti-gun. I'm massive gun control. Like that's what needs to take place at this point.
Regular people don't need weapons of war that can take out a bunch of kids in like
Dude,
seconds. It's insane that people
insane.
and I
It's
think
insane.
honestly, most people would agree if it wasn't for these lobbies pushing, most people would agree, this consensus of people would agree that people don't need these weapons to just go hunting or like you don't need these ARs. It's insanity.
What are you going to like just like riddle a deer with 75 bullets with your AR? Is that what you're doing? No, no one's doing that. They don't use it for hunting. Hunting weapons, I'm cool with, man, because most hunters are very respectful in terms of, that they're gonna kill what they eat. They really, it's a whole thing. It's a very spiritual thing for real hunters. You know what I'm saying? I mean,
Yes.
this ain't that.
No.
Like I'm not a hunter. It's not my jam. I can barely kill a spider, and I hate spiders. Like I'm not like a killer. It's not my thing. I don't like kill. Like I'll save bees. Oh, if you see a bee in a pool, I'm grabbing it out of the pool. Oh, it's like if we need the bees. If we don't have bees pollinating, we're all gonna fucking die. Just true.
It is true.
It's so true. So yeah, man. So I know you've been knee deep in Trichonis. Have you been kind of following this thing at all?
Honestly, I saw I clipped the Taylor Swift opening, where she quotes Taylor Swift. I
Yeah.
saw that, and then actually, aspiring court reporter Sarah's in here. She's like, "I'm gonna send you a bunch of clips because it's wild." So no, I have not really kept up, but I'm super interested to. The
Oh
law is what I'm
man,
curious. Like, if parents could be held responsible, it's a big freaking deal, right? But I
a
mean,
big
maybe
freaking deal, dude.
maybe
Like
they'll
so.
take a second to think about it.
Well, I mean, because it's always one of those things that you would think when you hear, like, all the way back to Columbine, and you're like, the first thing I was thinking, I was young when Columbine hit. I might have been just out of high school or just like, I think it was like,
I think it was 99. If I was like 19, I think it was a
was
freshman in
Columbine
college.
in
I could
99?
be wrong, but I feel like I was a freshman in college. I feel like I was in college.
Somebody like Dizzy or one of our mods, can you guys throw the like they'll figure it out
By
for
the
us.
way,
But
real quick, Bob, do you have the stream on live in case it goes live? Is it paused or is it
yeah,
on live?
I
Oh, okay.
believe so.
Just make sure the red button is on.
Actually, let me make sure. Let me check.
Because I've done that where I'm like,
Oh
I thought
shit. Am I behind? Okay. I don't think it's live yet.
okay, cool.
I'm hoping.
Yeah, you're good. Yeah, as long as the red button's on, you're good. The red
Yeah,
little live thing.
yeah, it says live down there, right?
Yeah, you're good. You should be good. As long as it's red. Yeah, you're good.
Okay.
Sorry.
All right, cool. No, thank you. The last thing, I mean, I think people in the chat be like, "What the fuck is on, dude? What the fuck's wrong with you, dude?"
They would.
So,
That's
like our people are good like that, of letting us know when we're making terrible blunders. So yeah, it could be huge, dude. I mean, I think it'll always be a case by case analysis. Like I don't think that it'll be an overarching thing, but once they break the cherry of saying, okay, we're now going to be able to hold parents accountable for their children's actions while they're out of their purview. You know what I mean? Because that's the thing. This is, and I was starting to talk about, and I kept getting off on rants, so I would never finish a full thought. Because then I started on my second amendment, my gun control rant. But like where I'm at, like my needle was buried on Crumbley should be held accountable because of that picture that she saw that was handed to her, where her son is writing "Help me" in all caps with a picture of a dead kid, a gun, a bullet, saying blood everywhere. If that's not a cry for help, I don't know what is. I just don't know what is. So I was buried deep. She's got to go down. Like I understand the ramifications it has for all of us as parents, and frankly, I think that we should have that responsibility. I'm good with it. I'm a really good dad. I am in my kids' lives. I know what is going on with my kids. I make it a point to know what is going on in my kids' lives. Do I, like with Cameron, my 17-year-old, am I all up in her shit? No. And that's That's the nexus. That's the X factor because we're dealing in this. It was a 15-year-old kid. I'm not going in my kid's room and going through her journals. Like I'm not going through like I have my kids on Life 360 as well, which she did, which the Crumbleys did as well. So there is that portion of a teenager's life where they do not allow you in, and you have to respect their privacy to a certain extent. But when so for that part of it, there's a little forgiveness for me in terms of her, and like a lot of the testimony yesterday when she took the stand, and I knew she had to take the stand. There's no way they're going through this thing without her getting her side of the story out in terms of, were you super neglect mom? Just not like you gave two shits, like all you gave a shit about was your horses. You wanted to be drunk horseback riding on, because like that's how the state was painting him. So I wanted to hear how involved, like people, like sitting on the lawn crime chat is hard for me as a lawyer. I'm sitting there like, oh my God, like people are like, I hate this woman. This woman's doing. And I'm like, oh my God, dude. It's like she has to object. They have to build the appellate record has to be. I tell people all the time when I'm streaming with you and when people are irritated by the sidebars and the objections and the talking objections or speaking objections is what they call them. It has to be done for the appellate record. She's got to preserve all of these issues for if Crumbley is convicted and it gets appealed, which it will, and so if it's not handled, it's waived. So that's why they do these annoying things that we don't like as trial observers, because it destroys the flow for us, but it ain't about us. Just let's always remember we're watching somebody's life be affected massively. We're watching advocacy for victims in real time, and lawyers are in there doing their jobs. And I've found the male state's attorney to be very condescending and shitty. And I'm very protective of women lawyers, obviously, because I'm married to one.
Well, when you were saying, you were talking about Allie saying that people would hate her, and you were talking about this attorney. Her name is Shannon too, right? Her name is Shannon.
Right.
Shannon was like, it's the patriarchy. Like the reason that everyone's giving her shit about her voice and etc. Like it's the patriarchy that you're not,
Exactly.
So
Exactly. Dude, and I ain't having it. Like, not on my watch.
I hear you, man. It's outrageous.
Yeah, I know, man. We're of the same mind. Dude, I was so bummed. I really wanted to watch Sarah with you last night. I thought I had the time right. I got all settled in, put it on, and it was like live.
Well, we got that. It's supposed to be got that hour difference. It's always like,
dude, I don't like. I understand the time zone. Like Allie doesn't. Like she doesn't get it. She grew up on the East Coast. She's like, wait, they're an hour ahead. I'm like, yes, babe. Like you lived in Illinois for 20 years now. They're an hour. But like for whatever reason, I thought that it was coming on at 7. I think did you come on a little earlier?
No, we were at 7. We were on 7.
So yeah, that was 6 my time.
Dude, but can I tell you first of all, Sarah's awesome, by the way, folks. If you don't know Sarah Turney, but the wildest part of the interview is when we're getting towards the end and she goes, we're talking about the trial, and she goes, I think I was watching you to make like I was watching during the Alyssa's trial, and then she's like, because I don't know if it was you, but you started yelling at the defense attorney for getting so close to me, and then I was like, yes, that was me. Like it was just why. And then she's like, but she was like, and I felt like it felt good, like to have an audience, like to her, like,
yeah,
to
know that you're being heard, especially by the people that matter. That's a pretty cool feeling, man.
It blew me away, to know that she was watching, and you were on with me. We watched it together for a little bit. So like
we did. I think I came on a couple days with that, and like that. Oh man, I felt like you could just tell right from the opening that state's attorney was not feeling that case.
Dude, like I think you said he grabbed the short straw or whatever. And
yeah, he was like, and I felt terrible for Sarah because she's been fighting so long to get justice, and like at this point, but like she turned that into, looks like it's gonna be showtime. She turned that into becoming a massive advocate, and because I'm gonna have, I was texting Julie, and Julie's super tight, and she's under the umbrella of Sarah's network with her new pod. So I'm going to be having her. I think I'm going to try to get her on next week.
She's
Yeah.
awesome. Julie is
Julie's
amazing.
amazing. And dude, you'll get to meet everybody. I'm super excited about True Crime Podcast Festival.
Yeah.
Like
Sarah's
everybody.
keynote speaker. She's doing a keynote speech.
Yeah. And it's great, man. You're gonna love that so much because it's really our vibe. It's
Awesome.
it's such a like super ethical, true victim advocacy type, you know, con, man. And everybody there is phenomenal. It's like I had
Awesome.
like a little meeting, like we have little meetings with like Lainey and like kind of like the main, like Charlie, who I'll introduce you to all the folks that you haven't met. Like Charlie Worrell is amazing. You're gonna love Charlie. She's got Crime Lines Pod. She's a creator. Like any creators you want, dude, you just text me and say, hey man, can you get me dude on? Like Tim and Lance, I could, like anybody, but like Charlie
Awesome.
Worrell from Crime Lines, like anybody you want for creators who crush. Just
Thank
let
you.
me know, dude. Like I'm in that game. You know what I mean?
Yeah.
Like, I'll be able to get you tons and tons of
Awesome.
creators.
Thank you.
Yeah, and they'll all be super interesting, I promise. But yeah, so like before she comes in, so basically where we're at, the direct went for probably about 3 hours, a little over 3. Shannon was able to get in a lot of stuff in terms of kind of like who she is as a mother, where she was in terms of did she really know that Ethan had like mental issues, that he was having these incredibly vivid hallucinations, and she was saying her thing was, look, when we bought this house, it was built in 1920. Ethan has always thought that it was haunted, and he used to go down in the basement with his one buddy that he had who moved away and like left this kid like with friendless. He then became the loner kid, and it's like they were down with the Ouija board, and like so he would text things like, oh, the spirits in here throwing bowls around, and she was thinking he was just doing his ghost shit, and then like so I'm really anxious to hear about the bird torturing though. Like if she was aware of this kid like cutting bird heads off, and like and the state's going to be getting into all this, is going to be a hell of a cross.
So let me ask you this. Legally, what does the state have to they have to prove that she was well aware that this was going to be an issue? Like that's that's the statute that they have to prove that she knew that this was coming, basically, that this was going to be a thing. Like
basically that basically she was aware that he was a threat to the health and well-being of the public at large, and that she just did nothing about it, that she was reckless about it.
So has this come up before? So this is like the first school shooting case this has come up, right? Or has this come up before?
Yes, dude, this is like, and I started to talk about this. So the criminal case, the Highland Park thing, were very similar, where dad definitely knew, and dad signed off on his kid's FOIA because he wasn't 18. The kid then proceeded to go get the gun and then shoot up a parade. He was charged with like fraud. Like they didn't charge, like this is the first case in American history where parents are where the state's trying to hold the parents responsible for the end result of what their children had done out of their presence.
So let me ask you this. So was this previously used for different scenarios, or was this specifically written for this law that the statute? Was it used for some other type of scenario and now they're using it for school shootings? Is that what it is? Okay.
Right. So they're trying to squeeze it in. Like this is really typically used for like most typically involuntary manslaughter is used in vehicular homicides, like if for like DUIs.
Okay.
Like somebody gets hammered, drives, and kills somebody. That's typically where the statute's used. So it's a different scenario. So they're trying to make it fit here. And ultimately for me, where this thing kind of like falls into, I think that she's got to be held accountable, is that meeting the morning of, like being handed that letter. I don't care what preceded it. I've been very clear about that. If it's one of my children and I'm called into the school, excuse me, and they hand me that, under no circumstances am I leaving my child at school. I'm instantly incredibly concerned. And I think that ultimately her downfall during her direct was her response to that particular math test. Now I don't like did you get to watch any of the thing with Sonny? I know you were in there for a while.
I
Did you
was part of
see
it, but I didn't see that part where as far as the
so I put up that document. It would be super cool. I don't know if I could share. Like I'm just so basically, it was a math quiz that he was given first thing in the morning. I think his first or second class was math. Teacher handed out a math test. Kid doesn't do any of the math test. Instead, he's drawing. He draws a picture of the 9 millimeter he just got 4 days prior. That was only supposed to be used for, the shooting range that he had no access to, that they had like a trigger wire on it, and that they were hiding the bullets. I mean, they took some measures. It wasn't like they just gave it to him, but the kid was able to find it, obviously, and obviously make it to where it was usable. And he ends up, going and doing what he does. But,
so
for me,
he writes that stuff on a test. The teacher gets it. The teacher, they call in the parents. Is that what? So the
yeah,
teacher's like,
so
"This
the
is fucked up.
teacher,
You got to bring
right.
the parents in."
And it goes like this, dude. It's like this is like, how memorable it was when you were in high school, elementary school, middle school, whatever. You take your test, you hand it up. So the teacher's looking through them in real time, sees what this kid has done, says, Ethan, I need you to come with me. She either messages or calls the front office. She's like, we need to talk. Like, Ethan just handed in this thing, and he'd had issues in the past. Now the school is, in my estimation, absolutely culpable.
That was my next question. That seems like they
100%.
should.
Like what has become evident is that they were not informed. Like, he'd had issues, other issues that they were concerned about, that they weren't letting the parents know, that there's no proof, that they were sending emails like, hey, we had this issue with Ethan today. You should take a look at it, blah, 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 blah. None of that stuff was, was made aware to the parents. So that it's an issue. It's a mitigating thing. It doesn't clear her at all, because again, for me, what it boils down to is being handed that paper. Dude, it said, the thoughts won't stop. Help me.
So they call
Blood
them.
everywhere. A picture of a kid like laying on the ground like this, bleeding,
Jeez.
pool of blood, bullets. Like my life is meaningless, and the world is dead. Like, dude, you see that? Like, are you leaving any of your kids in school? Like, I'm taking
No.
my kids out of. I'm taking my kid out of school, and I'm immediately getting them evaluated for their own safety first and foremost. And then obviously, once I've taken them out of the situation, I feel that I've done my job in making sure that other people are safe from my kid. But I'm getting them evaluated to see what the hell's going on with my kid, man.
Right.
There's like, so to me, that's where it lays. Like, to me, I just can't give her the pass. I just can't do it.
So
You
at
know?
that point that he does that, he he has the gun somewhere on him in school.
Yeah.
Like he doesn't leave and come back. He's already has it, and they call Jennifer in, and she's like, whatever, go back to
Both
class.
parents show up. Both
Both.
parents. It's an 11-minute meeting. It's got the school counselor and the principal in the meeting with Ethan, Jennifer, and James Crumbley. So all 5 of them are in this room, and Ethan gives some bullshit excuse of what it was, like why he drew it. Oh, I was just, it was just, whatever. I don't know what he says, and we'll never hear, because he's taken the fifth, which has been another interesting thing. He pled out, like he didn't go to trial, but he's still going to appeal, and ultimately his attorneys have said, look, he's going to take the fifth, which there's been this back and forth with the judge where, like, look, like, I'm not telling you that you can't call him. All I'm telling you is that the law, as it's currently situated, you can't put a client on the stand that is going to take the fifth, because there's nothing that you can ask them that will not trigger the fifth if they're taking the fifth. And she's like, And Shannon was like, I understand that. I just need you to say, and like, I'm sure people in the chat that didn't understand what was going on were getting super annoyed with the kind of the frivolity or, like it was a frivolity of that back and forth between the judge and her, where she's saying, I need you to make a finding that you're not allowing me to call him. And she says, I'm not allowing you to call him. I'm just telling you the law as it's currently situated states that you cannot put on the stand a person that you know is going to take the fifth. So it was like, she's like, I understand that, Your Honor. However, so she's like, Shannon was trying to get locked in to the situation that I'm going to have to appeal if he is going to be convicted, that I need that issue, that because she can't confront him. Like the confrontation clause, I'm going to be streaming, so no bedroom today. Okay. So, it's just one of those things where it's a really weird situation, because the confrontation clause of the Constitution says that you can confront your accusers. Now, what they've been able to do is use a lot of things that are statements of Ethan through his writings that have been introduced at trial, which she cannot confront him on. You know what I'm saying? So it's been a very, it's a super nerdy, law nerdy type argument, but it's like, it's been a fascinating aspect of this trial.
Can I ask a question? And
yeah.
Can I ask all right, because I'm new to this. So so they have that meeting. Here's my question to you about so it was up to the parents to be like, whether why wouldn't it, if I'm the principal or the guidance counselor, why aren't they like, get the fuck out of here?
Yes.
No, you're not. Like, can't they say that it's their fault? Like, why would they allow them to go back? Like,
it's crazy. It's crazy. Like, that's what I'm saying. The school is 100% on the hook here. However, you can't charge a school criminally because it's a institution. Right, it's not a person. Right. You know what I mean? So it's like, I'm assuming that the parents are all suing the shit out of the school.
Right. That's not civilly, right? Like, that's got to make this change for schools, get their money. That's where, like, just the reason that the guns are after. Get the money, get the money, right. And they'll.
That's the only way that we've been able to figure out. It certainly doesn't make anybody whole in a situation like this, but it's the only way that we've been able to figure out. But it's like, you have this issue where exactly what you said happened, where in the climate that we live in, where last year, I don't know how many school shootings, it seemed like it was every other day there was a school shooting, and I think that there's been, Dizzy says that they've tried. Dizzy said they tried to sue the schools, and it was dismissed. What? Oh man, I got to dig into that.
And that's why it won't change, because the school doesn't care. If they can't they can't. Oh man. I guess, is that criminally or civilly?
It was, I'm sure, civilly. I can't, like I'm saying, you can't.
Oh yeah, you can't.
Criminally, like who, who you. Right. I mean, I guess theoretically, maybe you can charge the principal, maybe try, which is that's a bigger stretch than charging the parents. Right. Try to charge the principal. So wow, that's disturbing. Well, that's kind of one of the arguments, Donna, in terms of why take the fifth, and the question is does it apply if he's pled and he's appealing? Like typically it's very, very difficult to be able to appeal a plea agreement, like, because there are no trial issues. Typically what you're appealing is trial issues. So like, it's got to be very specific things with respect to the plea, that they didn't explain things properly, that they should have gone for a mental defect defense. It's going to have to sound in ineffective assistance of counsel. So yeah, man, like ultimately that's what happens. The staff, the counselor, and the principal give them the option. You can either keep them here for the rest of the day, or you can take them back. I agree with you completely. I've been saying it. You say, get the fuck out of here. Take your kid and get him out of the school. Like talk about known or should have known from the school. I mean, how many school shootings? Like, my schools, if anything weird happens, they're locking it down. They're sending in all the families emails. Like we all know, they're like, hey, we just had a, somebody farted in class and we had to shut it down because somebody thought it was what I mean? It's like they're hyper vigilant, which I'm great with that. Be hyper vigilant because then you don't have this type of situation happening. So, all right, man, we're about to dig in. So, Jay, to set it up, yesterday they just finished the direct. This morning it's going to be the cross. I really hope it's the female prosecutor, not the male. The male prosecutor really gets on my nerve. He gets on my nerves. Like people are saying that Shannon gets on their nerves. Like he's just condescending and shitty to her. I feel like just giving him an open hand slap. All right.
Your Honor, calling people over Jennifer Crumbley, case number 22279-990 FH. Morning again.
Morning.
Good morning.
I have reviewed the instructions provided by the Middleton County Sheriff's Department and sealed envelope to the prosecutor. I reviewed all the texts. I made a copy for Ms. Smith. And Ms. Smith, do you have an objection to anything in the text chain?
No, I don't. I would ask that if the text chain is used, that it just be admitted as well.
Yeah, okay, so I am going to maintain a copy of the text chain in my own personal file. All right, and I'm handing a copy over to the prosecution.
Okay.
All right. So,
Adjustment.
can we continue the trial?
Absolutely. Can we have just a minute to look at it?
Okay, yeah, it won't take you more than a minute, but yes.
All right.
How's the judge, by the way, Bob? How's she doing?
I mean, in terms of the sniping going in, like a lot of people feel that like she's very passive. Like she's never lost her cool. And I think she's done okay, because she's had some very novel legal issues come up during this thing. And I think she's been decent. She's not Judge Newman. You know what I mean? She's not Judge Toll. So, but she's been.
Hi, this is Mark Barton, Sandy for Promise in Newtown, Connecticut.
What?
Hi, this is Nicole Hockley, also from
What
San
the hell is this?
And we wanted to bring your attention.
Like, why am I getting why am I getting commercials on this stream? Does that ever happen to you? Or is that just
Nah,
me?
you got premium? YouTube
Yeah,
premium?
of course.
No, that never happens.
It's weird. Maybe I'm not signed in on my premium. Huh. It's weird. I don't know. That means it's going to happen intermittently. It'll probably pop up like in the middle of like a really, I think that first break they take, I'm going to have to figure out to see if I'm signed in there. Because I usually watch premium on my phone. Like when you get on, do you go through the app?
Get on through like when I'm streaming?
Yeah, like through like law. If you're doing law and crime, do you use?
No, I'm on the website. I'm on the
YouTube.
YouTube.
Yeah.
Just yeah.
Yeah, it's weird because it's like I'm definitely subscribed, but I pay for premium too. I don't know. I'll figure it out. Hopefully, there's not like a massive like question on Cross and it goes to a horrible commercial. Everybody will leave like, oh, this guy. Better go over to Recovery Addict.
They'll skip it. We could skip it after 5 seconds, right? It will be fine.
Yeah, we should be all right.
Thanks for being here, everybody.
Yeah, you guys, we really appreciate it. Per usual, I gave you guys no notice. It's kind of my MO, though. And so one of the things, Jay, that they were arguing about this morning was the fact that, again, one of the things that the state was trying to use to bolster their case was the fact that, they said that these two went on the lam. Like after this went down, after they became aware of the charges, that they were on the run, they bought burner phones, they were hiding out. He's parking his car backwards so they can't see the plate. And then so, it turns out that it was a cop who said, look, we got to take your phones. I suggest you go buy burner phones, because she's like, how do I communicate with anybody? It's like our whole lives were just like literally in the blink of an eye destroyed. Like I've got to try to like deal with shit. So like that kind of excuses that for me, but like they're going to be trying to use text messages between Jennifer and her lawyer, because she opened the door yesterday, which is they're claiming was a privilege waiver. So it's like, this is going to be a hell of a cross. It's going to be a hell of a cross.
In their defense, at least they didn't buy a one-way ticket to Vietnam. So, I mean, at least they were.
Yeah. I think she was, I think she was going to dip off. And because where was her first stop?
Dubai, I think.
Dubai. Yeah, I think, because I don't think they have extradition in either country. I think she specifically looked for a spot where there could have been like two countries with no extradition. So when because clearly she had to know they were going to find out what her itinerary was. They're like, well, which country is she in? Is she in Vietnam or is she in Dubai? Yeah.
So let me ask. So when you say their text messages prior to the trial, they're trying to get those texts.
Oh yeah.
And the defense attorney opened the door to that happening.
Well, technically, it was Jennifer Crumbley who did it, because it was while she was on the stand, but it was during direct examination. She answered a question in a way that like, oh, well, you text me when you text me that we were going to go to that she considered that to be a waiver of attorney-client privilege.
Wow. So at that point, Shannon probably shit her pants and was like, why did you?
Oh yeah, dude. It's like I really do. I watch her and I feel like I'm watching Allie. Super thorough, but Jay, like the one thing that I keep trying to say, I don't know how she's doing this trial without a trial partner. Like the people that don't understand, who have never tried a case, how hard it is to be able to try a case like this without having somebody that's helping you go through all the exhibits, without somebody that's pulling things up that are going to be like brought up either on cross or direct, like where you're trying to do everything. It's really, really hard. And people keep calling her like unorganized. I'm like, nah, man, she's super organized to even be able to do this. Like she knows this case forward and backwards. I just have a very different opinion of her than the general public. And I get that like some people feel like she's annoying, and I just don't. I think that she's doing, you like I always say, Jay, you play the hand that you're dealt with your clients. But she's adamant about this. I mean, she's really fighting a much bigger fight than just for Jennifer Crumbley. She's really fighting for every parent on the planet, or at least in this country, that, could potentially be held responsible for shit that your kids do when they're not, under your watch, which is a scary proposition. Oh, wait, Sleuthy's talking shit. Bob, she often says, I haven't seen her. I don't know anything. That's true. That's true. She does say that.
I heard she said something about unaliving herself. Is that correct? Or something like?
Oh, okay. Yeah. She said,
don't say the word, but you don't want to say the actual thing that she said.
Yeah, no, she said something to that. Like she said, like in passing, like in like just as like, oh, that makes me want to blah blah myself. And like, so the state's like, oh my God, like in this trial, for her to say that is completely, so it was like, it was definitely shouldn't have said that. But it's like when you're in a trial like this, it's like, you're so engrossed in it. Like things like that just happen. It's not an excuse, but
you need to take care of legal issues. I usually try to do that while they're not waiting for us, but that's not always possible. So I appreciate your patience. And we are going to continue cross-examination. Right, Ms. Crumbley, could you raise your hand? you swear or affirm the testimony you're about to give is the true self of that?
I do.
If you could put your hand down, and could you state your name again for the record and spell your first and last name?
My name is Jennifer Crumbley, JENNIFER CRUMBLEY.
Go ahead, Lester.
Thank you. Mrs. Crumbley, I'd like to talk to you about your vigilance as a parent. But before I do, I want to make sure that you understood the oath that you just took.
I do.
Okay, you understand that you took the stand under oath and you have to tell the truth.
I do.
You understand that was the rules yesterday as well.
Correct.
All right, we're going to come back to that. Now, you have been described by your attorney as a hyper vigilant parent.
Correct.
Okay, do you agree with that?
I do.
In fact, you called yourself a helicopter parent before.
Yes, I was.
So you told us you spent a lot of family time together.
We did.
Now, I'd like to talk to you about what your digital footprint shows,
Okay.
what the evidence on your phone shows.
Okay.
Now, it's true, you agree with me that having horses is a quite time-consuming hobby,
It can be.
okay? It was for you,
It can be.
and that's what you said yesterday,
Yes.
okay? And you were at the barn for between 3 and 5 times a week,
More like 3 times a week.
3 times a week
Yeah.
for a couple hours a trip?
Correct.
Okay. It's also an expensive hobby.
It is.
So your banking records show that in the year 2021, you spent over $20,000 on the horses. Is that correct?
Probably.
Okay. And that's not including cash. That's just from Capital One and Flagstar Bank.
Correct.
In fact, you told a coworker that half of your salary basically goes to the horses.
I might have. Yes.
Now, except on rare occasion, you didn't bring your son with you to the barn.
He was not into horses. I would ask every time I went to the barn, but he didn't want to go.
So the answer was no.
No.
Okay. And at least as far as your horses being boarded with Kira Pennick from June of 2021 to November of 2021, your son never went with you. Is that correct?
I think he went once when my in-laws were in town and we met them at the barn.
Okay. But there was nothing stopping you from taking him.
No, he just didn't want to go.
Okay. It's a family atmosphere.
It can be.
Okay. Like the Halloween party that she had, that was for families.
Yeah, most of the kids there are young.
Okay. In the winters, you were on ski patrol as well.
Correct.
Okay. And that can be a bit of a time consuming hobby.
It can be.
All right. And you would be on ski patrol between 1 and 2 times a week,
It's a total of 10 hours a week.
10 hours a week. Okay. So how many days?
I did doubles on Saturdays, so 1 day a week for me.
Okay. So you told us jury yesterday, you depicted your affair with Mr. Malash as a 1 time a week meetup at a Costco parking lot. Is that your testimony?
Correct.
Okay.
Oof.
But it wasn't just that, was it?
Nope.
In fact, there are numerous photographs sent to Mr. Malash.
Okay.
Yes or no?
I'm sure there was.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday, was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included trips,
There were actual business trips that he met me on.
okay, and included other individuals.
Yes.
What's Adult Friend Finder?
So where you can go on and meet people who meet certain tastes that you're looking for.
This is 429. And you
Oh, boy.
had the app Adult Friend Finder on your phone.
I do not believe I had the app on my
Okay, it
phone.
was found on your phone.
Okay, well, I guess it was on my phone.
Okay, and there were messages from you to other individuals.
Correct.
Your Honor, I would object that this is going outside the scope of the affair with Brian, but.
I don't think the court's ruling on opening the door was confined to just her extramarital affair with Brian Walsh.
Well, I guess, with regard to Mr. Wash, I determined that the defense opened the door. I don't know, but I determined that the defense opened the door as to other.
And she depicted herself as having one extramarital affair for about a 6-month period of time, where she met with him 1 time a week. That was her testimony yesterday. We have evidence to the contrary, and I think it's important.
It's gonna get exciting. All
right, but
it is what it is.
all right,
Oof.
go ahead. But
I won't delve too far
Okay, yeah.
into it, Judge.
Really, this jury has been for a long time, and
I respect your time, Judge. I'll be brief.
We might all blush.
So Mrs. Crumbley, I'm sorry, this is not a laughing matter. Mrs. Crumbley, an adult friend finder, we see messages from you in at least of August of 2021, August the 4th, 2021.
Okay,
Okay, and you don't dispute August the 10th of 2021,
no,
August the 11th of 2021.
no,
And more importantly, November 21st, 2021.
no,
Okay, and more important than that, November the 28th, 2021.
no,
Okay, you don't dispute that evidence was found on your phone.
I don't dispute it.
Okay, and you don't dispute that it wasn't just you and Mr. Malash meeting after work hours. It was with you and Mr. Malash arranging with other individuals to meet after work as well.
No, I only met with Brian during work hours. The times that we were at the hotel, I was on business. We did arrange for other people to meet us there.
So Sunday, November the 28th, you remember that day?
Mm,
It was the day after you took your son to the shooting range.
I don't remember it.
You don't remember that day?
No,
2 days before the high school attack?
no, I don't remember what I did that day.
Okay. Well, you were pretty specific in what you did on November the 27th with the firearm. You remember that,
Correct?
all right? Now, on November the 28th, 2021, you spent your time arranging a meetup with somebody, an adult friend finder.
I never met anybody on adult friend finder that day.
Arranging a meetup.
Oh, okay.
I'm not just talking about the time that you spent physically with somebody. I'm talking about the time that you spent and devoted your energy to setting that up.
Okay.
And you'll agree with me, it's not just the time period at the Costco parking lot or the time period at the hotel or the time period on the trip, correct?
That's the only time I met with people.
Right. But that's not the only time that you devoted your own personal time and energy and focus to that, is it?
I guess I don't understand what you're asking.
Okay. Well, these meetups didn't just happen by themselves. You had to set them up.
Correct?
You weren't driven there. You weren't dropped off there. You set them up with somebody else.
Correct.
And that took your time and your energy and your focus to do so.
I don't believe it took too much time and energy, no.
Now, you told this jury that when your son texted you that he was seeing demons and bowls flying off the shelves, that was in the spring of 2021. You recall that evidence, right?
Correct.
You don't dispute that that was on your phone.
No,
And you don't dispute that at some point you read those messages.
no,
And you don't dispute that your son said at least one time, "Can you please text me back?"
correct.
You don't dispute that when you're at the barn, your other messages show that you can take pictures, send pictures, and receive pictures.
Usually I'm at the barn. If I take pictures and I try to send them, they don't go through right away, or I won't send them until I hit a spot where I actually have service.
So in Exhibit 423, the Facebook message chat between you and James, the chat that you deleted, there are a number of pictures that James sent to you from the barn of a horse in a conversation about that particular horse. Do you
Okay.
dispute that?
No,
Okay. And in fact, dozens and dozens of pictures of the like.
I'm sure, yes.
You're sure, okay. And those pictures were sent to you with a timestamp on that Facebook message chat.
Okay.
Do you dispute that?
No,
No. Okay. And then you responded in that same time frame. Do you dispute that?
no,
No. So that conversation with that picture that was taken at the barn was occurring while one of you were at the barn.
I'm sure it was.
Okay. Now, you don't deny that your son wrote in his journal that he asked his parents for help. You don't deny that evidence that was in it.
No, I don't.
Okay. And you don't deny that he wrote in his journal that he now had access to the 6-hour 9mm handgun.
I do not deny that.
And you don't deny that the 6-hour 9mm handgun was in fact the murder weapon.
I don't deny that.
And you also don't deny that that gun was gifted by you and your husband to your son on November 26th.
Describe gifted.
How about when you posted on Instagram his new Christmas gift?
Correct. And I explained yesterday that it was for him to use at the shooting range. We didn't just hand him a gun as a here you go, son. It was something he could use when we went to the range as a family together.
You don't deny that in April of 2021, you described your son as being depressed.
I didn't describe him as being depressed. I noticed that he was acting
You
depressed.
used the word depressed.
Yes, he was acting sad. He was acting depressed.
Okay. And you know what depressed means?
It means a lot of different things.
Well, to you, and meant depressed, and you wrote that.
Right.
You don't deny in April of 2021, the evidence shows that your son told his only friend that he had asked you for help.
No, I don't deny that.
Okay. And you also don't deny that he told his only friend that you laughed at.
I do not deny that.
Now, yesterday you told us that you took those messages in the spring of 2021, which, by the way, is at the same time you started your affair with Mr. Malash.
Around that time.
Okay. So in the spring of 2021, when you sent those messages, or when you received those messages, you indicated it was messing around.
It was.
It was messing around. In your mind, messing around. That's what your testimony was.
Yes.
Okay. Even when he said, can you please text me back?
I didn't see his text message, so I didn't text him back.
Even when your phone logs show missed calls.
Can you ask that again?
Even when your phone logs show missed calls from your son in that time period.
No.
Now, you said yesterday about these messing around texts. You agree with me that there's no indication in any text message, either between you and your son, or any Facebook message between you and your husband, in any of those exhibits, in fact, anywhere on your phone, that indicated that any of those messages were a joke.
No, there weren't.
There weren't. And we're talking about hundreds of messages between you and your son, and thousands of messages between you and your husband.
Correct.
And you don't deny that you never once took him to see a therapist or counselor.
No, I did not.
You did not. Now, you testified that, actually, Mr. Moss testified that you would meet during work hours, and we've established that it wasn't just confined to work hours, but we're permitted to leave as you please.
Correct.
Okay. And your boss actually testified that no problem if you needed time off.
Correct.
If you have a family issue, no problem, you can go.
Correct.
If you were sick, no problem, stay home.
Correct.
Okay. In fact, you could work from home on an as-needed basis.
Correct.
In fact, on November the 30th, you didn't even ask your boss if you could leave. You just told him you were leaving.
Correct.
And you told him when you were coming back.
Correct.
And you told him when you were coming back after receiving a phone call from the school asking for an immediate meeting.
Correct.
Because that was at what, 10:05 a.m.?
Around that.
Okay. Now, had you ever been called? You have the CD on, please, Mr. Williams. Had you ever been called?
It takes some time for all three of them.
Sure, Doug. I have a few more questions I can ask before we get to these.
Okay, go ahead.
Have you ever been called to the school on an immediate basis before?
No,
Have you ever been told that your son had suicidal ideation before?
I was never told he had suicidal ideation before.
Okay, that's your testimony. But you've never been called to the school once for a meeting. I need to see you now.
No.
Correct? Okay. So even before you would have made it to the school, you had told your boss when you were coming back.
Correct.
So you had already put a limit on that meeting.
Not necessarily.
Well, you said, I'll be back,
Okay.
right? Your words.
About an hour.
Yeah, those were your words.
Correct.
This is exhibit 74. Do you see it?
No, she doesn't.
Oh,
It's not on here. That's. Yeah, it takes some.
I will.
Donnie, you did
you
it.
see it?
Yeah.
Okay. This was sent to you. So Sean Hopkins called you at 9:24 in the morning, correct?
Correct.
Okay. You called him back at 9:27.
Correct.
You had a 5-minute phone call.
Correct.
And then in that phone call, he texted you the picture with it was drawn out. Then he emailed you this original picture.
Yeah, he texted me the modified one and then later emailed me this one.
Later at 9:32.
Yeah, like after I asked him for it.
We looked at it.
I did.
Okay. You told us yesterday you found it, I think your quote was a little concerning. What struck you about this?
Originally, when I saw the modified one, I was kind of angry at my son because we just talked about his missing assignments in geometry and his E the night before. Then when I got this one and opened it, it was concerning. I honestly thought the guy on there was a poor drawing of Batman, the way the thing in the cat. I thought it was a cape. I didn't know.
You thought that was the case?
I didn't. I didn't look at that
What did you think of
closely.
the gun?
I thought it was a gun.
Yeah. What about the fact that it is identical to the gun that you got him for Christmas a couple days before?
I mean, honestly, it looks like a gun to me. I didn't even notice.
Well, you took a picture of the gun. You posted it on Instagram. You know what it looks like.
I do, but I didn't analyze it.
You saw Sergeant or Special Agent Brandon's testimony. He described how it's identical. And you told us yesterday how your son was a good drawer.
He's a very good drawer.
Okay. What about the thoughts won't stop, help me? Did that ring out to you?
Yes, that was what was concerning to me.
Blood everywhere, and there's a bullet. And actually, you were the one who bought the bullets on November the 27th.
Correct.
You later came to learn that those bullets were used in the shooting.
I did.
So you said yesterday it was a little concerning. Yeah, you told your husband emergency in all caps.
Correct. That's why I left to go to the school and I
You said-
texted him.
and he wrote back, "My God, WTF."
Correct.
And then you told him he was distraught about last night.
Correct.
Distraught's an intentional word you chose.
Correct.
Not sad. It's not a little anxious about school or his future. It's not talking about a video game. Distraught has a meaning.
Correct.
And you chose that word to send to him.
Correct.
So you went to that meeting, and this was November the 30th of 2021. And at that point, you'll agree with me that you knew prior to that day, the November 26th purchase date, that your son was wanting to get a 9mm. That's what you said yesterday.
Yes, I knew that they were talking about getting one because they had
Okay.
rented it in the past.
And you knew that he had shot in the past.
Yeah.
Okay, and you knew that a 9mm is significantly more powerful than a 22.
I did not know that until I actually shot it.
Okay, well, your dad took your son with James to the shooting range when they visited in July of 2021,
Correct.
and they talked about how powerful the 9mm was because they rented one.
Okay. I don't know if
Yes
I
or
was,
no?
I don't know if I was part of that conversation, but if it was, it didn't register to me.
Okay, you knew at the November 30, 2021 date that your son's friend had been taken without notice to your son.
Correct.
You said, I'm sorry, incorrect? Or
I said correct.
correct. And you knew that when your son's friend was taken, your son was extremely upset.
He was upset, yes.
He didn't go to school for a few days.
I don't remember that.
Okay. Well, if the school records show that he was absent for a few days after that, would you deny that?
I wouldn't.
And would you deny that he missed school because he was so upset?
I don't know if he missed school because he was so upset or maybe he was sick. I don't know.
Now, you told us yesterday and you acknowledged that that individual, that child, was like a second son to you.
Correct.
So he was the only one that your son hung out with.
Outside of school, correct.
Okay. Well, who did he hang out with inside of school?
He named some names to me. I've never met them before, but he told me some group of kids that he sits and eats lunch with and he talks to in class.
Did he ever visit their houses?
No,
Did they ever visit your house?
no.
The only other peer to visit your house was this student who had left the state around Halloween 2021.
At that time, correct.
We're talking about that time in October, in September, in at least August, July, June, May, all
Of 2021, correct.
2021, thank you.
Excuse me.
Now, he left on Halloween, and you knew that your son was planning to hang out with him on Halloween,
Yes.
okay? But his friend didn't show.
I had texted his friend's mom the day before trying to confirm if he was still coming over. And that's when we found out that he was driven to Wisconsin and taken to that school.
Okay, so you're telling us you found out the day before Halloween?
Yeah.
Okay. But that didn't stop you and James from going to the Halloween party at the barn.
I don't believe it was on Halloween.
Oh, that's what curious.
It was the Friday before
If
Halloween.
there was a picture with a date stamped on it, would you deny it?
No,
Okay. And it didn't stop you from after you left that party without your son. You went to another Halloween party.
we did.
And your son was home alone.
Yes.
So you talked with a little bit about your son's hobbies in 2021. But in November of 2021, so we'll start with November the 1st, 2021. You know that those hobbies were non-existent. And I'll go one by one.
Okay.
So you told us about bowling.
Correct.
Bowling the team wasn't in session at that point in time, was it?
No, I think actually at that time he decided he didn't want to do bowling that year.
Okay, so he stopped bowling the
He did.
sophomore year.
He did.
And it wouldn't have been bowling season anyway.
I guess not, no.
So one hobby you talked about yesterday, that was not in existence in November 2021.
Correct, but we did still go to the bowling alley with him.
And you said that he worked, but would you be surprised to learn that he only worked a few shifts post-COVID?
No, not surprised at all.
So he wasn't at work every day?
No, he worked Tuesdays and Thursdays and sometimes Saturday mornings.
Okay. But not very often.
No, not very often.
A handful of shifts post-COVID, which of course, March 2020 is when things shut down.
He was working on a weekly basis.
And you knew that he didn't have any friends.
That's not the right way to put it. I knew he had friends, but no, he did not have many
You had
friends.
never met another peer his age who he referred to as a friend.
He actually had friends that used to come over prior to 2021 that he was still in contact
We
with.
went through defense exhibits yesterday from 2019 and 2020. I'm talking about 2021, at least from the time period where he sent you a message that he saw demons in the house.
Right. In 2021, the only friend that came to our house was the one that was
Right.
on the thing.
So you knew to be true in November of 2021 that he had no peer support.
I don't know what he had in school. He told me he had friends in school that he talks to.
You never met him.
No,
And he didn't have any clubs at school he was a part of.
no, not that year.
So you told us yesterday that your son wanted to design video games,
Correct.
okay? He wasn't in a robotics club or a coding club at the high school.
He did take a coding class prior to 2021, and he was in a robotics after school activity in middle school.
Talking about in
I'm
2020.
just telling you, he's been in that before.
Now, despite what you have called yourself as a vigilant parent and a helicopter mom, you never decided in at least November of 2021 to look at his phone.
No,
That's despite what happened in the spring of 2021, right?
what happened in the spring of 2021 did not concern me.
Okay. Now, the one thing that seemed consistent with your son, to you at least, is a desire to obtain a weapon. Is that right?
I wouldn't say that, no.
He had a consistent desire to obtain a weapon.
Not to me, he did not.
Okay. You didn't know about the 9mm?
Oh, I knew about it.
Okay. You didn't know about the 22s?
I knew about them.
And in fact, you posted on Instagram that he got himself a 22
Correct,
in June of 2021.
correct.
And from that time up until the November 26, 21 purchase, he was wanting to get a 9mm.
I know him and my husband had discussed getting a 9mm. I'm not part of those conversations.
But you knew about it.
I knew, but not that he was so, however you described it.
I said he consistently had a desire to obtain a weapon.
I know they consistently talked about it, correct.
They didn't just talk about this is a gun, he talked about how he wanted the gun. You don't deny that.
Oh, no,
In November 26, you said you weren't there for the gun purchase.
no, it's not.
Okay. But are you telling us you didn't know it was going to happen?
I did not know they were going to the gun store that day, no.
Okay. But you knew that you were going to eventually get him a 9mm.
No, I did not know that.
Okay, so you're telling us that there was a surprise purchase to you?
It was surprised to me that they went to the gun store that day.
Okay.
It was not surprising to me that they purchased a gun that day.
And it didn't upset you that it bought a gun?
No, it did not.
It upset you that they cut into your Christmas tree shopping time, but it didn't upset you that they bought a gun?
Correct.
And you told us that it was, in your words, James's responsibility to take care of it.
Correct.
Now, you don't deny that, at least according to the cell phone evidence, the photographic and video evidence, you're the last adult to have possession of that gun.
Correct.
You were with him at the range on November the 27th.
Correct.
You saw your son shoot the weapon.
Correct.
You saw him shoot the last practice round before the shooting on November 30th.
At the range?
Yeah.
Yes, correct.
You saw how he stood.
Honestly, that didn't mean anything to me at that time until this whole case came about and I've learned what a shooter's stance is. So
He knew how to use the gun.
yes, he did. He's used one before.
In fact, he showed you how to use the gun.
Correct.
Okay. And the stance he took, you saw from the Oxford High School video, was the same. You saw that, right?
I don't know. I can't compare it. I don't know.
But you entrusted this responsibility. You agree with me that owning a firearm involves a great deal of responsibility and trust?
I do.
And you entrusted this responsibility to your husband, James.
I did.
You look at Exhibit 423, that's the Facebook chat thread between you and your husband. It's pretty clear you didn't trust James with much. Would you agree or disagree?
Depends on what you're talking about.
Okay. Well, you didn't trust him to get out of bed.
Correct.
You didn't trust him to cut the grass when it was time to cut the grass.
He would cut the grass when it got to a length I didn't like. I didn't trust him.
You didn't trust him to update you on his whereabouts.
There's a reason behind that.
You didn't trust him to not turn off or turn on the Ring camera in your home.
Correct.
You didn't trust him to keep track of your son.
Oh, I trusted him to check my son.
And those messages that we'll see in Exhibit 423, asking him, where is your son, over and over and over again, does that signify trust or distrust to you?
That was when my son was walking home from school. Not that I did not trust my husband with my son.
Okay. And you didn't really trust your husband to hold down a job.
It's not that I didn't trust him to hold on a job. He had a hard time holding down one after COVID.
Okay. And in those messages, you are constantly asking him about work, how much money he's making, and what he's doing to obtain employment.
Correct.
Okay. But this is the person you entrusted with a deadly weapon.
I did.
Why did you buy the Patriot defense rounds?
Where are those are that's the ammo. That was the ones my son told me to purchase. I didn't know anything about it. I'd asked him and he told me to purchase them.
So you told the jury yesterday, I think you repeated it again today, that the gift was for target shooting only.
Correct.
Okay. Yet you bought 100 rounds of ammunition
Correct.
and you only shot 50 while you were there.
Correct.
And those 50, at least according to some statements you made throughout the investigation, you put some.
The box of them, yes, I did. I hid them.
Now, on November the 27th, when you came home, you posted pictures of the gun and targets to your Instagram.
Correct.
And then according to the location data, your location data, you left.
I think that's when we went, well, I don't know. I must have, yeah.
Well, you don't deny it.
I don't deny it.
And your husband James was gone all day, according to his location data.
I think so, yeah.
And you saw in the evidence that in the picture you posted, there's an ATF pamphlet on handgun safety for children.
Correct.
Did you read that?
I looked it over, correct.
Now, on Exhibit 74, I want to get back to this meeting. Exhibit 74, you don't deny that you could have left work for the day.
No, I don't deny that.
And you don't deny that you didn't tell the school officials, Mr. Hopkins and EJAC, about the gun purchase on the 26th.
No, we had stated that we went to the shooting range. I went to the shooting range with my son on Saturday.
You didn't tell them that you had gotten him that Christmas gift.
I didn't think it was relevant, no.
You acknowledge that you never told Mr. Hopkins and EJAC that it wasn't just a friend, but it was the only peer that you had ever met that left.
I probably said his best friend.
You acknowledge that you didn't go home to look for that firearm after the meeting at the school.
We wouldn't have a reason to.
So that the answer is then you acknowledge that.
No, I acknowledge that.
And you acknowledge that you had already made plans for the night to go to the barn.
Yes, I do.
Okay. And you acknowledge that you had the time to stop at your house before you went back to work.
I would have, but I didn't have a reason to.
Now, you had told us that you had never taken your son to any sort of mental health profession,
No,
but you know how to obtain that help.
correct.
In fact, you have prescriptions related to this.
I do.
So it's not that you didn't know who to call or how to call, you didn't.
Correct.
Correct, okay. Yesterday, you talked a little bit about how you express emotion.
Correct.
And in fact, the council asked you about your nerves when you testified. But you're capable of emotion,
Yes, I am.
right? Okay. And in fact, you had some explosive emotional fights with your husband.
What we did.
And that was in the home that you shared,
Correct.
okay? And with your son. We
Correct.
saw pictures of that home.
Correct.
And you told us that Your son was at an age where he wouldn't text you back, "I love you."
It wasn't a text me back, I love you. It's like in passing, like, hey, Ethan, good night, I love you.
Well, yesterday you told us your son was at the age where he wouldn't text you back, "I love you." Those
Well,
were your
that,
words yesterday.
yeah, but more or less like just saying it in passing. He wouldn't say it back. I said, good night, Ethan, love you. And he'd like, good night.
Okay.
For him to text me that he loved me was abnormal.
Yeah, normal.
Correct.
Okay. But you didn't respond to that text until 44 minutes later?
No, I was in a meeting at work.
Okay. And if you go through your entire text message thread between you two, the word love pops up how many times do you think?
Between me and my son?
Yeah.
I have no idea.
3.
Okay.
The first is in reference to the game chess about a year before.
Okay.
And the other 2 times are right before your son committed this act and after the shooting when you responded. Does that surprise you?
No.
I would just ask if there could be a foundation for the dates of those texts, because I feel like we got just a few texts.
Okay, well, I think he specified, did you specify the date?
I did, Judge.
Two of the times were before and after the shooting, and the other time was like
About a year prior. I could pull the date. Council will like it.
And I'm also wondering if what the data he's relying on is coming from Jennifer's phone where she deletes all her texts, or if it's coming from the shooter's phone. Because the prosecution's asking questions, I just want to know the foundation.
Oh, sure. Let me clear that up. It's from your son's phone. So there, all the messages will be contained there. You don't deny that that information will be in it.
No, I don't deny it.
Now,
What time?
you told us that
Well, he asked if the chess one was a year earlier, and the other two were.
It's a fair question.
Time.
Lay the
the
foundation.
day of the shoot.
Yeah, I know.
Yes.
Those have been
When
the
this text took place.
Okay, but he's asking about the text overall, which have not been admitted into evidence. And I don't know that the text chain has all the texts. There's no foundation that what Mr. Keese is looking
Judge,
at.
in the cross-examination,
Texts.
if
He's
the,
asked if is that law, would you argue with that? That's what he's asking. I mean, there are people.
I know, she just doesn't know what.
hold on, council can't testify.
Okay.
Well, there are people that have every conversation of what.
Yeah, I agree with that.
Okay, so, and there are people who don't, right? So he is asking what's normal for them, and would she be surprised that how many times that's here?
Yeah, I'm just asking, I get that, and I get that it's not common. I'm just asking.
Judge, this is an argument.
I'm
I'm looking to argue
what
whatever she wants to.
period of text this is from.
Well, you have to redirect.
Okay, well, she doesn't know what she's even basing these questions on.
How, okay,
Well,
it is inappropriate for council to
Okay, she
suggest
can say I
or
don't know.
she or does not know.
she can say, I don't know, but she can also say, I don't understand the question. You can say that too. If you, this is from, if you don't understand the question, ask Mr. Peace to clarify.
Okay.
All right?
All right, thank you, Judge. Now, yesterday, Mrs. Crumbley, you talked about going into planning mode.
Yes.
Okay. And that was in reference to council asking you about emotions and how you express them.
Correct.
So I want to talk to you about your planning mode and your priorities from the time that you were arrested.
Okay.
Now, your phone calls were recorded from the time that you were arrested until now. You know
Correct.
that? You
Yeah,
know that.
I knew that.
You know that. Okay. And your priority on your first phone call, December the 4th of 2021, was on your animals and the cash recovered from the art studio. You deny that?
I don't deny it.
Do you deny that it wasn't until 10 days later and 14 calls later that you even mentioned your son? Do you deny it or not?
I don't, but I was under the impression that I couldn't mention him because I could get flagged at the jail.
Well, you mentioned him in later conversations.
I did.
Okay. And in fact, in one, a year later, March 25th of 2023, you said he just needs to man up. Do you recall that?
I do not.
Okay. Do you deny that you said it?
It sounds like something I would say.
In December of 2021, your concern was about a GoFundMe. Do you remember that?
No, I do not.
I'm going to play this for you. Ms. Williams, can you have the volume up, please?
Is this submitted as an exhibit?
This is an impeachment, Judge.
Well, there's no, for that. So.
Okay, that was between you and your dad,
Correct.
okay? And you asked him to set up a GoFundMe to pay for the board of your horses?
I did, yes.
You were concerned about other things related to yourself around that time, weren't you?
Yeah.
Is it still planning mode?
I believe so.
Okay. And you were arrested December the 4th. This is going to be December the 22nd.
Okay.
Yeah, okay. How many calories in a bologna sandwich and white bread? Cheese. It was American cheese. Yes, mayonnaise on it? Jelly. Okay, so she's looking at bologna right now. Is that those your lunch and dinner? No, I don't have a lot. So, it's $140. $240. Yeah. Should I give a bunch of dollars?
Still planning mode?
Well, I wasn't planning there, no.
Okay. Now we're talking about how you describe planning mode. You described that in context to statements you made to the police on November the 30th, 2021. Right? That's the context you use the words planning mode in relation to.
Correct.
Okay. So you told us that the last phone call on December 31st, that was still you in planning mode. I'm going to make sure we get an accurate depiction of what that is. Now here's one from January 15th, 2022.
No, it's not an issue of that, it's an issue of, that thing's gonna be always, they've had issues with their online stuff, and they've had issues with, just all kinds of stuff they're going to come in, and these people, it's like, yeah. So, I don't, I just got, cause I lost access. For some reason, I don't know yet, but. Well, I had access basically to view only. And it's hard to see everything on there, but then also I lost access, and it took me. I lost access like days before Christmas.
Okay. Is that still planning mode?
We were talking about filing my taxes if you played the whole thing.
You were asking about your child tax
Correct.
credit. You're still going to get that $300.
My dad was doing my income taxes for me.
Now,
Private.
when we started,
Private counsel, Charlotte.
we confirmed that you understood the oath that you just took,
Correct.
and the same oath you took yesterday.
Correct.
Okay. And you don't deny that you had $6,000 in cash in your purse the night you were arrested?
No.
You don't deny that your purse with the cash and 4 cell phones were in a plastic tote?
Correct.
You don't deny that that plastic tote was contained in a different plastic tote?
Correct.
You don't deny that your backpack with clothing items was found in a different plastic tote in a different area of that studio.
Correct.
And you don't deny that you knew you had been charged with involuntary manslaughter.
Correct.
In fact, as early as December the 1st, 2021 at 6:10 p.m., you were talking about how you're being charged with involuntary manslaughter.
That was what I was being told by a family that was texting me. That's what the charges might be announced as, correct?
Okay, and one is to Mr. Malash. There's a text to your cousin about you are being charged with involuntary manslaughter. You don't deny receiving that.
No, I don't.
That's Wednesday, December the 1st.
Correct.
Right? And you sent your neighbor a message on Wednesday the 1st of 2021, 6:55 p.m. that you were reading, they may charge us.
Correct.
Okay.
The
Oh
government
my
is paying
God.
for people to go back to school if they're interested in healthcare. So due to a shortage in the industry,
Good God.
They're saying involuntary
Not bad. 1 an hour, not too bad.
manslaughter. And of course, you looked at different news articles about
Oh,
that
man.
the next day.
Yeah.
And later on that day. And then you texted after all of these messages and news articles, December the 2nd, 2021 at 2 p.m. We're fucked. You wrote that to Mr. Malash.
Correct.
Okay. And then you wrote announcing charges at noon on December the 3rd, 2021 at 8:17 a.m.
Correct.
And you wrote that to Mr. Malash, you wrote that to Kira, you wrote that to your dad, right?
Correct.
Okay, so you don't deny any of that.
No.
Okay. Now you told us yesterday that you popped 4 Xanax.
I did.
Okay, and your husband popped 4 Xanax.
Correct.
You said you went to bed about 11 o'clock.
It was around that time.
Okay, and the evidence that we have admitted show that you set your alarm for 6:30 a.m. and 6:45 a.m.
I don't know if it was me who said it, but it was set for that time.
And from the evidence, it shows when it was set too.
Correct.
Okay, and it was set a little after 11 p.m.
Okay. Correct.
Yes. Okay. So yesterday you said, I want to say it was after 11 about going to bed. I want to say it was after 11, maybe around 11 o'clock when we finally went to bed. I prescribed Xanax for anxiety, and we each took 4 because we knew we were going to turn ourselves in the next day, and we hadn't slept in 4 days, and we just wanted to sleep. The question was, okay, so you each took 4? Your answer, we did. The next question was, okay, so the next thing, the next piece of evidence we saw that was coming in that art studio, do you recall that? Your answer, I recall my husband screaming, "There's people with guns against interface officers." Question, what were you doing prior to hearing your husband screaming? Answer, we were sleeping. Question, okay, were you aware that there was anything going on? Answer, I was not.
Correct.
That's your testimony.
Correct.
Okay. And you know when you say something that isn't true, it's called a lie.
Correct.
Okay. This is going to be exhibit 430. Council does have a copy.
Is it
The entire thread.
perfect? No judgment.
There you go.
Oh, thank you.
Does the court have a copy?
This is today's,
Yes, Judge.
okay. Any objection?
No.
Okay.
Mrs. Crumbley, you knew the police were there.
430 is admitted.
Thank you, Judge.
Not until I woke up. No.
Not until you woke up.
Correct.
Now, we heard testimony yesterday throughout the trial that 911 was called at 10:43 p.m. You recall that?
Yeah, I saw in the video. Correct.
Okay, and on the video, the first officers arrived before 11 p.m.
Correct.
Okay, and either you or your husband, you couldn't tell from the video, but you tell me, was it you or your husband out there smoking?
That was my husband.
Okay, so your husband walks in shortly after the 911 caller walks in the building to call 911.
Correct.
That was on the video.
Correct.
Okay, and officers arrived. And then we've heard testimony from Mr. Kirtley, who had a studio there. We heard testimony from Sergeant Hendrick, who was in the fugitive apprehension team, as well as Corporal Shaw with the Detroit Police SWAT team about the amount of officers there.
Correct.
You recall that?
I do.
And you recall hearing the testimony that Corporal Shaw's team, their SWAT team, they actually used a 35-pound steel ram to bash in a door at the studio next to where you were at. You recall that testimony?
I do.
Okay. And your testimony was that you were asleep when the officers arrived.
Yes, I was.
Okay. But you had an alarm set for 6:30 in the morning on your phone, and that phone was found powered off, hidden in a tote, contained in a different tote, in a place away from the bed.
Correct.
You don't deny that?
No.
All right. And there are certain messages in 430. I'm going to go through them with you. This is actually to your attorneys. At the time, you had 2 attorneys. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. That's it. December the 3rd, 2021, 6:04 p.m. Do you recall that?
I don't, but I don't deny it.
Okay, you don't deny.
No.
Okay. Next message, the other phone broke. That's December the 3rd, 2021 at 6:04 p.m. The response was, when you can, we would like for you to call us. That was from either Ms. Smith or at the time co-counsel Mary Elaine.
Correct.
Your response. I'm sorry, this is from Marielle. Thank you. Shannon is calling you both short. At the top it says to and from. I'll make sure I'm identified for the record. From Shannon. Marielle and I are going to come get you guys in the morning. We do not think it will help to make a statement that you're coming back now or that it will be tomorrow a.m. We can say that we told everyone you were coming back, and as of tomorrow a.m., you are back. That's Friday, December 3rd, 2021, 7:02 p.m.
Correct.
Right? Okay. So that's after James had already moved the car around and backed into the parking spot.
I believe so.
Okay. From Shannon, we can show them that everything we said was going to happen did happen. That's Friday, December 3rd, 2021, at 7:02 p.m. Right?
Right.
Your response, okay, that's at 7:03 p.m. From Shannon, I'm going to drive home from my office right now and call you guys in about 40 to 45 minutes so I can get all the bond factor information written down from Marielle and me. That's Friday, December 3rd at 7:36 p.m.
Correct.
Okay. Your response, okay, we'll be waiting, 7:37 p.m. Shannon, I'm going to call in 1 minute. That's at 8:54 p.m. that Friday night. Your response was okay. You recall?
I don't, but I don't deny it.
But you don't dispute the record.
Correct.
The next message you sent was, think we might have found, don't know, just heads up, please check. December the 3rd, 2021, 11:14 p.m.
That was written, but I do not believe it was written by me.
Okay, you don't remember. Well, you told us you don't remember any of these text messages. You just
Right.
put them
I
up.
read through it, but
You don't deny that this was on your phone, what we refer to as your track.
correct. We were both using that phone at the time because my husband's broke.
Okay. And then you wrote in quick succession, don't know, 11:16 p.m. We might have been found, 11:16 p.m. Laying low, 11:16 p.m. You don't deny that these are the records?
No, I don't.
Okay. Response from Shannon, oh shit. Friday, December 3rd, 2021, 11:16 p.m. Now we know from all of the objective evidence, the testimony, the video, everything that the officers testified to, they were on scene before 11 p.m. You don't deny that?
No, I don't.
You don't deny that there were hundreds of officers on scene?
I don't know how many were on scene.
Okay. How many did you see when you got pulled out of the art studio?
Honestly, I don't know. It all happened so fast. I knew there was more. There was a few. There was more than a few, but
You
not
saw the
hundreds.
footage.
Right.
I do want to make a point so everyone's aware. This exhibit was just made admissible this morning.
Correct.
Okay. So we actually just received it this morning. And when you testified yesterday, you didn't know this exhibit was going to come into evidence.
Correct.
Okay. I want to talk to you now about the night before the shoot.
Okay.
November the 29th, 2021. You could testify that you got into a fight about grades with your son.
Correct.
Is that because you checked Power School?
Yes.
Okay. During that fight, did you lock your son out of the house?
We did not.
You don't deny that he was outside of the house?
He did walk out of the house. He was upset.
Okay. You told us that you took his phone.
We did.
That's not true, is it?
That is true.
On
We took it,
November the 29th, 2021, your son filmed a 19-minute video while he was outside describing what he was going to do the next day.
what time was that taken?
10 o'clock.
I don't know if he got it back. I know we took the shooting range away and we took his gun away. So I don't know if he got it back.
Now, all of the times that you were at the barn, there was nothing stopping you other than you told us he didn't want to go, right?
Correct.
There's nothing stopping you on November the 30th, 2021 from taking him home.
Correct.
Nothing stopping you. You know, actually, I want to go back to what you just said. You took his gun away.
We took the shooting range away.
You said you took his gun away.
No, I said we took the shooting range away.
Your son could have been with you those 3, 4, 5 times a week when you were at the bar.
He could have, yes.
Your son could have been with you on those times when you were with either Mr. Malash or somebody else.
No,
In the weeknights, he could have been with you after school, after work.
I wasn't with Mr. Malash at those times.
Okay, the other individuals.
I wasn't with them either at those
Well,
times.
According to.
I might have messaged people at those times, but I was not with anybody at those times.
He could have been with you on the Halloween party.
He did not want to go. It was a bunch of little kids.
And on November the 30th of 2021 at 12:51 p.m., you could have been with him
I could have, yes.
and you didn't.
No.
Nothing further.
Wow.
Mrs. Crumbley, I just have two areas of questions for you. Mr. Keys played some recordings. Who were you on the phone with in those recordings?
And my dad.
Okay, so you asked a couple of questions about calories, and then what was the other one?
I guess a child tax credit.
Okay, how often did you speak with your dad?
During the summer, it was every day. Then went back to work. It was just on the weekends. They're both teachers.
And how many hours a day do you spend with other people?
Sometimes it's none. Sometimes it's when they walk by my cell, I'll talk to them, but I'm locked down 23 hours a day. I get 1 hour out by myself. I talk to my clergy lady legally, so I see her. Sometimes I talk to the church priest, or I'll talk to my attorney. But that's about the most human contact I get.
So I guess one of my questions is, when you do talk to people, you talk about, are there more conversations than just those?
Right, there are.
And then that night on December 3rd, going into the 4th, after 11, there was one phone being used, is that right?
Correct.
Whose phone was being used?
It was my burner phone.
Who was using the phone?
My husband was using the phone.
Okay, were you also using it?
No, I was using my other phone. So he started using my burner phone. I used the one with our regular phone number to do anything on.
Okay, so these messages are from the burner phone
Correct.
to myself and Mario.
Correct.
So the ones after 11 o'clock, so at 11:17 or whenever these texts came in, what were you doing?
When I saw the video of my husband going to the car and having a cigarette, I knew I was probably sleeping at that time, because I did not like us not being together after what happened to us on the 30th when the police came to our house. So if he went out to have a cigarette, it was most likely because I was asleep.
Okay, when guns were in your face, we saw that on the video. Before that, had you been asleep?
Yes,
Are you absolutely sure about that?
I'm positive.
I have no further questions. Thank you.
I'm going to excuse you for about 10 minutes and we'll see where we're headed. Okay?
All right.
All right, so that was shorter than I anticipated. Now I saw, do y'all want me to try to rewind a little bit? Like it sounded like there was some portion of testimony that, does anybody know where it was?
And you know, when you say something that isn't true, it's called a lie.
Correct.
Okay.
Is this around where you guys want me to rewind?
It's going to be exhibit 430. Council does have a copy.
Is it
The entire thread.
perfect? No, just,
There you go.
oh, thank you.
Does the court have a copy?
Is this today's?
Yes, Judge.
Okay.
Further back, Charlotte,
Any objection?
Mrs. Crumbley, you knew the police were
or
there.
further forward?
Thank you, Judge.
Not until I woke up, no.
Not until you woke up.
Correct.
Now, we heard testimony yesterday throughout the trial
Forward or back, though?
that 911 was called at 10:43 p.m. You recall that?
Yeah, I saw in the video, correct.
Okay, and on the video, or that it will be tomorrow a.m. We can say that we told everyone you were coming back, and as of tomorrow a.m., you are back. That's Friday, December 3rd, 2021, 7:02 p.m.
Correct.
Right, okay. So that's after James had already moved the car around and backed into the park.
It was written by me.
Okay, you don't remember, well, you told us you don't remember any of these text messages. You just
Right.
looked at
I
the
read
phone.
through it, but,
You don't deny that this was on your phone, what we refer to as the burner or track phone.
correct. We
You don't deny.
we were both using that phone at the time because my husband's broke.
Okay. And then you wrote in quick succession, don't know, 11:16 p.m. We might have been found, 11:16 p.m. Laying low, 11:16 p.m. You don't deny that these are the records.
No, I don't.
Okay. Response from Shannon, oh shit. Friday, December 3rd, 2021, 11:16 p.m. Now, we know from all of the objective evidence, the testimony, the video, everything that the officers testified to, they were on scene before 11 p.m. You don't deny that.
No, I don't.
You don't deny that there were hundreds of officers on scene.
I don't know how many were on scene.
Okay. How many did you see when you got pulled out of the art studio?
Honestly, I don't know. It all happened so fast. I knew there was more. There was a few. There was more than a few, but
You
not
saw
hundreds.
them.
Right.
I do want to make a point, so everyone's aware, this exhibit was just made visible this morning. Okay, so we actually just received it this morning, and when you testified yesterday, you didn't know this exhibit was going to come into evidence.
Correct.
Okay. I want to talk to you now about the night before the shoot.
Okay.
November the 29th, 2021. You had testified that you got into a fight about grades with your son.
Correct.
Is that because you checked Power School?
Yes.
During that fight, did you lock your son out of the house?
We did not.
You don't deny that he was outside of the house?
He did walk out of the house. He was upset.
Okay. You told us that you took his phone.
We did.
That's not true, is it?
That is true.
On
We took it.
November the 29th, 2021, your son filmed a 19-minute video while he was outside describing what he was going to do the next day.
What time was that taken?
10 o'clock.
I don't know if he got it back. I know we took the shooting range away and we took his gun away. So I don't know if he got it back.
Now, all of the times that you were at the barn, there was nothing stopping you other than you told us you didn't want to go. Right?
Correct.
There's nothing stopping you on November the 30th, 2021 from taking him home.
Correct.
Nothing stopping you. You know, actually, I want to go back to what you just said. You took his gun away.
We took the shooting range away.
You said you took his gun away.
No, I said we took the shooting range away.
Nope, she said gun. That's what they wanted, Bob.
Okay.
Your son could have been with you those 3, 4, 5 times a week when you were at the bar.
He could have, yes.
Your son could have been with you on those times when you were with either Mr. Milage or somebody else.
No,
In the weeknights, he could have been with you after school, after work.
I wasn't with Mr. Milash at those times.
Okay, the other individuals.
I wasn't with them either at those
Well,
times.
According to.
I might have messaged people at those times, but I was not with anybody at those times.
He could have been with you on the Halloween party.
He did.
All right. So what did y'all think? I loved the chat, by the way. I thought you guys did a great job in the chat. We have some differing opinions in here, and it's that type of case. It really is. You guys kept it respectful. I'm super proud of all of you, each and every one of you, for doing that, because it's one of those cases where it kind of goes to some fundamental questions about parenting and how much we should be or shouldn't be involved in our kids' lives, especially teenagers. And it's tough. We're all individuals. We all have, every kid's different. Some kids, like, I was trying to put up as many comments as I could to kind of show where we're at with both sides of this thing. And we're the jury. That jury is sitting there, probably broken up the same way that we are. And it's curious. I'm curious to know if they are aware of just how important the verdict is beyond just Jennifer Crumbley, like, moving forward in this country. Because I'm like, you're hearing it here. And I'm telling you, in stone, if she's convicted, it's going to change everything in terms of every state in this country, in terms of every prosecution office in this country, in terms of them deciding this is how we're going to handle these types of situations. So, I mean, what did you think, Jay? Like, what was I thought she held up.
That's what I was going to say. I thought she wasn't, like, after watching Wendy Adelson lie so much, she didn't add extra details. She just answered the questions. I thought, whether she's guilty or not, I can't determine right now. I haven't watched enough, but I thought she did good on the stand. I don't think she added anything additional. I think she answered the questions. She didn't try to spar with him at all. She admitted things that he was trying to, it seemed like trying to get a gotcha moment, and she just admitted them. So yeah. I thought she did good personally.
I did too, and I mean, ultimately she understands that there's no point in trying to lie about shit, because it is what it is. This is going to boil down to, those 12 people in that box, whether or not they felt that she had enough knowledge going into the day of the shooting prior, and including the day of, when she's handed that, to me, that note is everything. Like, everything else, like what they did after they found out they were charged, big fucking deal. Them trying to get, themselves positioned to be able to get bonded out, turn themselves in. I mean, we do it all the time with our clients. If they know that they're going to be arrested and they've been told by law enforcement, I try to work out with the prosecutors and this, and law enforcement, hey, I'm letting you know we've been retained. We're going to turn our client in. Can we work and make this happen so that it's not a clown show? And typically they'll work with us, and that was definitely going on between Shannon and she thought the prosecution, and then they did a double move on her, and then they use it at trial. I don't think that that's pertinent at all. You know what I mean? I don't think that was indicia that they thought that they were guilty of anything. I think that they were just trying to get their lives in order for 10 to 12 hours, 18 hours, whatever the case may have been, because everything's done at that point. You've lost your kid. Your kid has done the most horrific thing imaginable. Your life as you know it is over. And, now you found out that you're going to be charged criminally with serious charges, like long prison sentence charges. And you got a lot of shit to handle. And, you just do. It's one of those things where it's easy to sit on the sidelines and be judgy, about what somebody's doing. But until you're in that position, so to me, that doesn't go to the weight. It doesn't go to the crux of the issue. The crux of the issue is whether or not they knew enough going into that day And then you compound it with the fact that they're handed that cry for help from their son that morning, and they chose to leave their kid there.
That was the question, by the way, that I thought was really telling when they asked, after you got that, did you go check for the gun? She's like, I didn't think I had to. What do you mean? You just got this piece of paper with a gun on it, and he's like drawn just like the gun you got for him, which, by the way, they bought him a gun. That's wild.
4 days prior.
He's 15. You didn't think, after seeing that, let alone, like we said, should have got him the hell out of there. You didn't think, maybe I should just go home and just make sure. Like, that was not a thing that made you think that immediately? I mean,
oh man, that's what I'm saying. It's like in jurors, I always tell jurors, I'm like, you have to use your own life experience. You know, I mean, in terms of when you're sitting here in judgment, you have to use your own life experience in terms of reaching your decision. And you know, when I sit here and think about being in that position, and I've said this on repeat about this trial, that math test with the words, I can't stop the thoughts, help me, blood everywhere. It's like there's just in no way, in no world am I leaving my kid in school. You know, for the safety of all the other children and for the safety of my own child. You know, and she, you know, there was testimony, Jay, yesterday during direct examination, you know, that like there were text messages that were going back and forth between her and Ethan where, you know, she's saying, don't do it. And this is after the shooting where she testifies, look, it was, you know, I know these situations because we all do. Typically the shooter kills themselves. That's typically how these end. You know, she's, you know, telling her son not to do it. Because at that point, she knew, they established it, that she knew that the shooting had taken place. She didn't know that anybody had been killed. I think that they got it in that she may have been made aware that there were people injured. You know, but it's like, man, it's such a tough, it's a really tough call. If you're asking what my gut is on this, all they need, as we know, is one for a hung. And, you know, when you read through the chat and you get the individuals in the chat that are of the mindset, man, you know, it's like, I can't hang that on the parent, you know, in terms of him being, you know, of the mindset that he's going to go do that morning. I mean, you can't predict it completely. I mean, no one ever wants to believe that their child's capable of that. Again, that's another one of those things that it's very easy to sit back ex post facto after the fact and judge. You know, it is but like the reality is you never would believe that your kid would be capable of doing that. You just wouldn't. You know what I mean? And unless they're in such a dark place, but then you've got the math test. Like, to me, the math test is everything. If the math test doesn't work, I'm probably not convicting her. I mean, she sounds like an average parent. She doesn't sound like a total piece of shit. She just doesn't. Yeah, she's having an affair. Yeah, that's taking up time. Yeah, she gives a shit about her horses. Yeah, she's, you know, basically, you know, ignoring her 15-year-old kid, probably as much as the kid wants to be ignored. You know what I mean? It's like, you got to think realistically about, you know, like Cameron, my 17-year-old runs hot and cold. You know, it's like, I always want to be in her life, but she doesn't necessarily want me in her life. You know what I mean? And I respect that. She's got her own shit going on. She's got her own friends. Her own life is happening. She's learning how to be an adult. She's figuring out who she is. And I respect that. You know, I try to give her a wide berth. I give her grace as far as that goes, you know, but I'm always vigilant. You know what I mean? It's like, I may be giving her plenty of space, but Allie and I are both pretty vigilant about knowing where she's at, knowing what she's up to, you know, knowing who she's hanging around with. If I get a sense that she's depressed, I'm asking her, you know. I think that, you know, for me, it's just, I'm that type of parent though. you know, and like we're all different individuals. I mean, people will come from families. I had friends growing up, you know, that would call their parents by their first names. And I was like, what the fuck? I'm like, you know, I'm like, that ain't me, man. I'm like, you know, and like, I know families that just don't deal with emotional things at all, you know, like just in general, like they don't address issues like that. They're sweep them under the carpet folks, you know, they just kind of bury shit. They don't really head on, you know, I mean, I'm Italian, Irish, and Allie's Jewish, and you know, we hash our shit out. You know, it gets hashed immediately, and they're like it's the same thing with my kids. You know, like I've raised my children uh as I mean, Mandy, you say that, how do you know? You know what I mean? I mean, you don't know every parent. I think that if we were to figure it out, I think that she would be about every average parent, to be honest with you. Like I don't like, you know, I don't think that every parent is a helicopter parent where they're in like just in every nuance of a child's life. You know what I'm saying? You know, but all of that being said, if I'm on the jury, I'm finding her guilty because of the math test. That's inexcusable. Like
Let me ask you this.
despite everything that took place beforehand, is of no consequence to me. That math test makes her guilty in my book because immediately, like, there is nothing that she could have said that was ever going to change my mind on that piece of paper being placed in her hands the morning of the shooting, and she chose to keep her kid in that school. Period. That's it. Do I think that the school should have said, get that kid out of here? Yes, I do. However, they left it up to her. And it like, no matter what she is as a parent, anybody who's looking in that at that particular letter and leaving their kid in the school is culpable. Period. That's my opinion on it. You know, like everything else to me is noise. That ultimately is the thing. And again, it's a much tougher case for me to get to guilty if that thing doesn't exist, because it's factual. The school was not letting the parents know the issues that he was having in there. And, you know, I've heard people say, oh, the school knows, you know, knows the kid better than the parents. Sometimes they do. You know, they're with our kids 8 hours, 9 hours a day. You know, I mean, like they're gonna know. They're seeing them interact with kids where we're not seeing that as parents. It's a very different thing. Like when my kids were in daycare, I always just wanted to creep in there and watch like through the window, and like without my kid knowing, I'd come like 10, 15 minutes early just so I could see her interacting with other kids. Because you don't get to see that like in a group setting. You know what I mean? We don't get to see that part of our kids' lives when they're at school. You know, you like if you're like you get the pat answer, you know, in terms of how was your day at school? Good. Did you learn anything? Yeah, no, maybe. You know, what'd you learn? You know, it's a but like trying to understand, like in terms of no, I'm serious here. Like we don't really get to see how our kids interact with other children in larger groups typically. It's different than when they have their best friends or their little buddies at school and there's play dates and things. That's a different circumstance. I'm talking about where you're watching them in an element that we typically don't get them, you know, within our purview. Like we just don't get to see it often, you know. So it's one of those things that it's just really hard to know, you know. And it's like you see a kid like this who's lonely, who's got basically one friend. You're concerned. You know, I mean, the kid, yeah, I mean, like kids are just so, like teenagers are just so hard to gauge. You know, they just are, man. It's like, it's easy to sit here and be judgy, but man, it's like, you know, my 17-year-old man, like when she was 16, it was like Cameron was tough to deal with. You know what I mean?
I
Like,
know what you mean. Trust.
you know what I'm
Ethan
saying?
is we sometimes we go at it. It's and sometimes like I think I know he's just trying to bust my chops. Like he's going out of his way to bust my chops to get the reaction from me. So I totally get it. I got a question for you, Bob. So that argument you were just making, Ken, about like this is going to set a precedent going forward. I assume the answer is no, but can the defense attorney make that argument in closing statements? Like, listen, you got to think long and hard about this decision, because the decision you're about to make is going to set, precedent. Can they? I assume no, but I don't know.
I
'Cause
mean,
that would be such a strong argument to make them really think about what they're about to do.
it's a really good question. I would try it if I didn't think that it were going to lead to a mistrial. Because like you can't, like, certain things you can't talk about. You can't talk about like the punishment, because you're supposed to stay to the facts. But like I think it would be disallowed. I think that, but it's such an important argument, though.
Yeah.
And it's like, and it really, like, the thing that you worry about is that it becomes a thing where it's not looked at case by case, because that's the only way it should be looked at, is case by case. It can't be across the board that parents are going to start getting charged and convicted for shit that their kids are doing outside of their presence. You know what I mean? It's like that's a bridge too far in my book. But when you have circumstances like this, where again, the day of the shooting, they were on notice. All of them were. Every adult in that room was on notice. And as much as I put it on the school that they should have not allowed him to stay, at the end of the day, that is the parent's responsibility. It is their child to recognize that their kid is screaming for help. Like that what was written on that paper cannot be construed any other way than as a cry. The words "help me," what else could they mean?
Yeah, she tries to spin it like, oh, it was Batman. Oh, no, sorry, madam. There's a gun on there. There's help me. There's there's bullets in someone. They're like, no, you can't spin that. I don't think.
Right. The thoughts won't stop. Help me. Forget the pictures. The thoughts won't stop. Blood everywhere. Help me. The world is meaningless. And I forget the other one. Like, my family is dead. Like, it's like 5 small sentences that tell you all you need to know. Like, if you don't have your head completely jammed up your ass, like, there's no way that you're reading that thing and not saying, oh my God. Oh my God. I'm in, like, Allison and I would be out of our minds. Like, we would have like grabbed our kid and like they had the backpack, like, in terms of
Point of me getting off.
yeah, if you want, dude, you're always welcome. People love to see you. Yeah, like, because I want to ask you your opinion. Jay asked a great question. Yeah, jump on. I'll send you the invite.
Got my team Allie shirt. Of course, we want Allie on.
Yeah, definitely. Yeah, man, it's just like I forget what I was saying. I was gonna make a good
Talking
point.
about the if you and Allie got that, if you saw that. And by the way, additional to that, like my kids aren't perfect by no means, but like I have never, I got 2 13-year-olds and a 15-year-old. I have never been called to the school to like go in the office of someone to like look at like anything for anything. So like just the call to me, she's like, you need to come down here, would have been enough to like, whoa, something's going on here. And then there's this document, like you said, like, how could anyone ignore that without their head up their ass? They'd be like, oh, go ahead, go back. Everything's cool. This is cool. Like, no, NBD, no big deal. Go ahead, go back.
That's what I'm saying, man. It's like that is like implausible to me. Like there's just, in no world is that happening. Like, it's just, to me, that is what cinches the thing, and the cross didn't go as long as I thought that it would, but I think it probably went as long as it needed to. You know what I mean? Like, I really anticipated that he was going to go hard at her about that math test. Like asking that, in what world do you think that it was okay to leave your kid in school after reading him scream to you, help me? Because the one thing that and the whole point of me talking about is like how they hand the tests in. Ethan Crumbley knew that was going to be seen by people that day.
Right.
I mean, he knew it was a literal cry for help. Stop me. I'm about to do something that I cannot control.
Right.
You know, and it's like they fail, like everybody failed that kid. And I mean, he's obviously the monster in the situation. And you know, I was looking in the chat, and it looks like, you know, he pled out ultimately, Jay. So I don't know, you know, what they did in terms of evaluating him mentally. You know, I'm assuming that for sentencing purposes that he went through some you know, mental health evaluations, but I don't know. I don't know.
By the
Yeah.
way, and I know I'm probably like people like I'm like a liberal cuck, but I can't even imagine like I can't like I don't even like when they go to Dave and Buster's for my teenagers to have like one of those guns that shoots like rubber bands. Like I can't even imagine buying and letting my 15-year-old use a gun. Like it's just I mean I guess there's places where that's normal, but to me that is just
I
beyond.
mean,
I
we're
don't
the
trust
same
him.
way. We're the same way, dude. Like we just never like Allie, like even a squirt gun. Like Allison was like I had to argue about like just squirt guns, and I wasn't arguing very adamantly. You know, Allison's gun is her position on guns has always been no. I don't want you playing with them. I don't want them to be normalized, you know, in our lives. Like, I mean, we don't own a gun, you know. I mean, considering what I think is going to be going on in 2024, I think it might be time, unfortunately, to get one.
You need one to shoot the robots, Bob. You need one to
Yeah,
take out
well,
the robots.
that's for sure. That's for sure. Yeah, if AI doesn't end it before that election thing in 2024, it's I'm concerned. But you know, I'm saying that in jest, but I kind of mean it too. You know, but yeah, we're the same way, dude. I mean, we just have never. You know, I grew up in a town, Oak Park, which was one of the only towns to actually ban handguns. I think it got overturned by the Supreme Court. Like, but Oak Park was no, you're not allowed to own a handgun in this town, you know. And at the time, and that was back when I was in high school. You know, they were like Oak Park is super liberal though. You know, Oak Park is like, and it's the first suburb right out of the city of Chicago. You know, I thought it was an amazing place to grow up, and I would have loved to have raised my kids there because I think everybody that comes out of that town is right thinking, man. When I say right, I mean correct. You know, so
I see what people are saying in the chat, like for hunting. I mean, I get that. Don't get me wrong. I just mean as far as like, I would be worried my 50-year-old will be taking the rubber band and shooting your eye out, like shoot your eye, like Christmas or you shoot your eye out, kid. Like I just don't trust. But I get
no,
it. It could be responsible and you can hunt. I get what people are. I see in the chat.
yeah, and I had my whole rant. Look, I'm not anti Second Amendment, but I also understand that, you know, the Second Amendment was drafted for a very different purpose than what it's been bastardized by the NRA now. And now we have legions of our children being murdered or unalived in schools. And, you know, it's very problematic. Like it causes me great consternation. It really, really upsets me. And, you know, it's a huge issue, you know, and I mean, like to anybody that's making arguments that, you know, is not taking into consideration what's going on in our schools. Like I ain't hearing it. Like how do you have an argument without taking into consideration what's going on in our society? Because as far as I know, dude, and I've been in the debates online on Facebook. You know, like there is no other country on the planet that has what's going on like we do with the schools and the children. And it's like, you know, and like, and it does boil down to, I just saw it. And Trish, you're 100% right. It is a mental health problem. But once we're aware that that is going on in mass, it does become a gun problem. It becomes access to that type of weapon in our homes to our children. It goes hand in hand. I'm sorry, but it does, in my opinion. You know, I just think it's one of those things that we do realize that this country has come unhinged, you know, and I don't know what it is. Could it be these things? Could it be the radiation that we're putting next to our brain? I don't know, but something is going on. Like, I don't know what it is, but something is happening with us fundamentally as a society that mental health issues are just massive and everywhere. I mean, like, and they're not being dealt with properly because, frankly, we don't know how to deal with it.
Yeah.
I mean, that's the reality of it. I say it all the time. It's like as much shade I can be known to cast on cops. I respect the hell out of their, what they do, and they're putting their lives out like on the line every single day. It's an incredibly dangerous job, and they're being asked to deal with issues that they shouldn't be dealing with, which is the mentally ill, addiction issues out there. Like they didn't sign up for that. That adds like a huge amount of other elements that they didn't sign up for to do that job, and they're not equipped to handle. Like, they don't know how to handle somebody who's dealing with an episode of some kind of mental health episode. It's like, they're trained to deal with disarming people, and if their life is in danger, they shoot first and ask questions later, man. I mean, it's like, and when they're dealing with somebody who's got an obvious mental health issue, and they're not trained on how to deal with that, because they shouldn't be dealing with it. It's just, yeah, I don't know. I mean, it's a super nuanced, complex conversation, which is why, this trial is so important, and because it's like, it's one of those things that there is no easy answer. There is no right answer. There is no, I'm right, you're wrong. There's like, we all have a voice in this. We all have the ability to be able to speak on it, and no one's opinion on it is irrelevant. You know what I mean? It's like I just wish that we could all try to work together somehow, which seems impossible at times, to try to figure out what we do. And I said this with Sonny on our live. I'm like, as far as parenting goes, we had to take a full semester of driver's ed. We had to have multiple hours of, actual driving experience before we could go into a state facility, take a written exam, take a driving test where we're out on the streets in the whip before they gave us a license to drive a goddamn car. But any idiot can have kids.
Well, also, I mean, Bob, that also goes to a gun. Like, not everyone's got to take a license. You know what I mean? Like,
No question.
Why does not everyone have to get a license? And why is that? And I think, one thing we talked about, I think that almost everyone can agree on is these freaking weapons of war that no one needs to have them. I think, or at least the majority of people in the United States, I think, can agree. No one needs these ARs. They're not hunting with ARs. You don't need that. I would hope people would agree.
I agree completely, man. Like I was saying, we were talking about it earlier. I don't know if people were later into the chat, but I like hunters. I've got no issue with that. Like, hunters respect the weapons. They understand and respect gun safety. What they're out there doing is a sacred event for them. They live for it. They eat what they kill. It's a whole thing for them. It's a spiritual thing. It's a very different thing. Like, and I'm in no way, shape, or form ever talking about that we should end that kind of thing. What I'm talking about is exactly what you're talking about, the access to weapons that are for all intents and purposes have no business being in the public's hands. Now, the counter argument to that is, in the event that this country goes up in flames, which is not beyond the scope of reason. I'm sorry, it's scary as that thought is. It's not. We have a very divided country, and not divided in terms of politics anymore. It like the schism between the left and the right is no longer a right and a left hand. It's fundamental opinions on how we should live. You know what I mean? It's a much deeper argument than I want to pay, like, I don't mind paying taxes for social programs, or I do. Now it's I don't want to live the way that you live. I don't want to have to curb the way that I speak because y'all are telling me to, or you know what I mean? It's like people just have very different thoughts on things, and it's an absolute divide that scares the hell out of me. because that middle of the road, the fence that where I wish everybody sat on, because that's where you can look at both sides and appreciate both sides of any argument. That fence is eroded and now it's two sides. That's the way it seems to me, you know.
And it's
And
never coming back. Like I feel like there's never gonna be a time where we can come back to where maybe I'm wrong. I hope I'm wrong, but just looking at some of the stuff I see, I feel like it's never coming back.
man, dude, I mean, I can't disagree with you, man. All right. Thank you much for that. The Royal We with $5 holla. You're right to place a gun in the hand of a mentally ill kid does not or do not outweigh my child's unalienable right to life, liberty, and the pursuit of happiness. Here, here. I could not agree more. I could not agree more. I don't think that there is any circumstance in which children should be walking around with weapons or have access to weapons. That's a whole different thing. You know, it's like, that's just something I'll never be on board with. You know, if that's the way that your family is and y'all are gun people. Hey,
there she is.
Hi.
What's up, beautiful?
I can't figure out how to.
It's Jay and Shan's anniversary. So
Happy
so you know.
anniversary.
Thank you. Thank you.
Yeah.
So,
Jay was kind enough to jump on with me.
sound
'cause I
like
was
you
gonna-
guys
I was
are
just gonna
wrapping
hang
up, so maybe I should hop
No,
out.
we need your opinion on this.
Yeah, so what you missed, babe, was the cross of Jennifer Crumbley. And Jay asked a great question. And because I've been talking about, to me, the biggest why I felt this trial more than anything going right now. And frankly, anything that I've seen in quite a while is going to potentially have such a big impact. And you and I have talked about it. But the fact of the matter is that if she's convicted, it is potentially opening the floodgates for every prosecutor's office in every state in the union to start charging parents for their children's willful acts outside of their presence. You know what I mean?
Yeah, it's crazy. And, sorry, Darren's not available and I can't move this microphone down, but
Here,
I
just
wanted,
just take it, and it's tight, but no, take the actual and just rotate it down. Like take yeah, there you go. Is that better, or did you want
yes,
the whole
definitely
arm
better.
down?
No, that's definitely better. Um,
She moved it right
I
back.
wanted to ask you guys since you saw it, because how'd they get over that picture?
I don't know who's they. Like Jennifer
Just
Crumbley.
fans.
There
Yeah.
is no getting over that picture. Like that's what I was just telling everybody. I'm like, like whether she was not as involved in her children's life as she should have been, if she was dealing with her horses too much, or her torrid affair with her firefighter buddy, or working, or on ski patrol, or whatever all that shit was, like, which I just don't think that, like, we do not live in the society anymore where mom is supposed to be at home taking care of the house and minding the children. That's not the world
Well,
we live
that's
in
for
anymore.
sure. But we are in a society where you see some writing like that.
That's the thing. That's the thing, because that's what I'm saying. Like, to me, none of that other shit matters. Like, that's just the world we live in. We're all too busy. We're all too busy, and we should all be paying more attention to our children.
For sure.
I mean, but when you're handed like that piece of paper is slipped into your hand the morning of the shooting, and you decide to leave your kid at school, you've failed. You've failed your child, and you've failed society. And
So there
I think
was no, like, not that it was an acceptable explanation but some explanation as to
No, she
why.
basically just said, he asked, he's like, well, when you saw this, did you think you should like check for the gun or do anything? And she was like, no. Like, she was very like, just answered very matter of fact. She did not go back and forth with him. And she kind of just, no, there was really no explanation for it. She didn't try.
what can you say? I mean, what can you say? Like,
I don't
it's
know.
and he did not go at her the way that I thought he was going to go at her on that. Because why? Because the thing speaks for itself.
Well, and he definitely doesn't want to be bullying her. Because like you said, the thing speaks for itself. So if he comes off too harsh, he can make her sympathetic.
Yeah, I mean, and she was very forthright. Like, they may like like some people towards the end of it were like, yeah, she lied about this or about like that. She was like, it was a mea culpa, I mean, she came off as like it is what it is. Like, you know what I mean? Like, yeah, like I was with my horses a lot. Yeah, I had an affair with this dude, and yeah, I was like
I could give a
with this
shit. I
right.
still
I
need the
mean,
explanation of why nothing
exactly.
happened after she got that math test.
That's it. That's it. That
So,
is
Ali,
so it.
can they make? That's what I asked Bob. We're curious your opinion.
This,
Can they
yeah,
make?
this is that
Can
was
they make? So Bob's whole thing was this is going to set a precedent. Whatever this jury, whatever decision they make, is going to set a precedent for juries throughout the country. Cases they're going to have all these cases if they find that guilty or either way. But in the closing argument, can the defense attorney say, "Hey, make that point that this decision you make is going to set precedent"? Can they make that argument in the closing argument?
No, not
right.
they could maybe intimate at it somehow, very non-obviously.
Yeah,
But
it's
no,
like
it would be it's improper. It's sort
mistrial.
of like talking about the sentence
Right.
or but
It's such a relevant thing. Like that is like one of the most
they're not
frustrating
supposed to,
things.
but that doesn't mean she can't figure out a way to it because
Right.
prosecutors do it all the time, even though they're not supposed to. Somehow they, talk about, like I'm reading an old transcript that involved, alleged gang violence. And there was definitely, you need to send a message to everybody, which is kind of like the same thing. But I mean, she could definitely say, something that implies that without using the exact,
Wow.
like,
All
to
right,
the
you
rest of the
form that
world.
question
Something
while I
like,
read
when you're
support and
back
stuff.
there, think about, yourself and all other parents around the world and how, you know, but not saying how your ruling here is gonna affect all of them, but say something else. You know what I mean?
So support with Steph, a $10 holla. Thank you so much. Let's read this. As a mom of a child with mental illness, it was 100% for me to listen, watch, because it was my responsibility to keep all safe. I have the right to judge this one. He voiced to his parents, period. I agree. I mean, it could not have been more evident. No matter what they knew or didn't know going in. Like if it was willful blindness, if it was neglect, I don't care. Once they're handed that piece of paper, it's unequivocal. Like your child is begging you for help, begging you, knowing that paper was going to end up in a teacher's hands and end up with a call to the house, or somebody is going to get him out of that school. It's like he knew. He didn't even try to answer a math test. He went right into, I'm going to draw the gun. I'm going to draw the unalived kid. I'm going to draw the bullet. I'm going to write the words. I can't stop the thoughts. The thoughts won't stop. Help me. Blood everywhere. I mean, what else? I mean, to me, that in and of itself is putting her down. Like her mistake was not everything that she did preceding, in terms of whether you felt that she was an awful mom, an average mom, a helicopter, whatever. That moment in time, that is where she failed society. That is where she failed her son. And that is where she became, in my mind, criminally culpable for what happened that day. It could have been avoided, period. Like if like, God forbid, if that was one of my kids and I saw that like, as soon as I saw that piece of paper, holy shit, Allison, you'd have to chain me down to like be going like over to, I'm like, what, like, are you out of your mind? You didn't take your kid out of school. You didn't take your kid to a mental health facility immediately.
Right.
It's unheard of. It's
Well,
crazy.
and I just have to say, I just don't like the concept of him being convicted. Not that he doesn't need to be,
Well, he pled out. You
I
talking about
just
the kid?
don't. I just don't. He could not have made a louder cry,
I mean,
beg,
I know.
plead for help.
I know.
It's
And like
so
you
awful.
didn't watch much of the direct yesterday, but there were these texts in March of the same year. So the shooting took place in November, but in March, it was, kind of a text thread between him and his mother where she wasn't at home. And he was saying something to the effect that the demon's here and it's throwing bowls. And she explained that away as, when we bought this house in
I
1920,
did
we thought
hear.
it was, right, it was haunted. He was down with his buddy, always with the Ouija board. So we just thought he was being Ethan being Ethan. I didn't think that he was being literal. You know what I mean? So it's like, but like, how do you not piece that together when you're handed that piece of paper? I don't.
I mean, I could see not piecing all of that together. What I can't see is not immediately getting my child and then immediately making sure that the gun's at home. I mean,
Yes,
you're telling me there's no explanation on the record as to what she thought when she read that piece of paper.
Not a viable excuse. Just kind of like she said, she first thought it was a picture of Batman. The child. She's like, I thought it was Batman, and then he said, "Well, what about the gun?" She's like, I thought it was a gun. He said, "Okay, and you just had seen it, or you just posted a picture of that gun on your Instagram 3 days ago." Like, he didn't make a great point there. Like, I thought he would have hammered it home. Well, what about where he wrote "Help me"? What did you think that meant?
But on direct, what I need to know what I'm gonna have to watch this because you're not explaining. She had to come up with some explanation.
Not really.
Why she left her kid in school after that?
Because she thought that it was like no big deal. Like whatever Ethan said in that room, which we'll never know because he took the fifth and they wouldn't allow it in. Like whatever explanation Ethan gave,
she could have given it.
They bought.
She could have given it its effect on the listener. It's a hearsay exception.
Like it would like they hashed it out. They wouldn't let it happen. Like it couldn't get in. Like if it got in,
or anything on a sidebar or pretrial, some sort of.
Well, I don't know. Like I'm interested to see who else the defense is going to put on.
That's the only thing that matters. That's the only thing that ever mattered.
I know
what happened when you read that letter, and why didn't you think it warranted checking for the gun and taking your kid out of school? I mean, either of those two things.
Right, but Karen, that goes to sliding the blame entirely on the school. You know what I mean? I agree that there is no way that the school should have ever allowed for that child to remain in that school on that day. There's no way. However, yeah, see, that's not adequate. Like the school gave them 40 hours to get help. Okay, starting now, take your kid and his backpack. And they didn't even look in his backpack. Like, how do you not check that kid's backpack? Knowing, why isn't she saying, well, let's open up my kid's backpack? Like, that's the first thing that you're doing, right? If you're not just immediately grabbing your kid and saying, we're going to the mental health facility over here, and I'm going to put him in a 72-hour hold so they can evaluate him. Because he's 15. He's got dark thoughts, clearly. Very, very dark thoughts.
And particularly, we talked about, this isn't 1999. I bet you that morning there was probably some news story about a different school shooting.
100%.
How could that not be your first free, in this climate, how could that not be your
It's
first?
Impossible. Right.
All right.
It's
I think that my first thought might have been, and what I was thinking she might have thought was that he was suicidal, not homicidal. But you're saying there was no. I mean, I understand if the school said, like, all right, I mean, he was there, he must have said something. The school said it was okay to stay. I still
Does
just
homicidal or suicidal matter? Either sidal is.
Well, I don't know, because maybe transferred intent as far as the law is concerned. But
No,
if
I'm
she
talking about as a parent.
Well, no, as a parent, no.
It doesn't
Are we
matter.
not, are we not lawyers right now? Is this hello, sir?
Yeah, but
Counselor?
we are lawyers, but we're also parents, right? Hello, madam. We are.
Oh, no, I know, but for
right?
all intents and purposes, we're analyzing a criminal case. So I was thinking from a legal perspective, and if she had reason to believe he might harm himself and then he harmed someone else, it might actually transfer the intent and be the same anyway.
Well, I mean, for
Um,
involuntary manslaughter, there is no intent element. You know what I mean? They don't have to prove intent.
well, they had to
If
prove
they,
that
if
they
they're-
knew information that would have led them to. I mean, I don't have it in front of me, but I just meant the information they knew. I guess not the intent, but the intent of the information they knew. But
right, I mean, but intent, if there's intent, then we're talking about straight up, you know, felony M word.
no, I know. I mean,
Can we
it's
say
got to
that
be.
word?
I mean, I think
It's.
so. I think
I
so.
don't know. I have no idea.
You never.
I've got to watch it on my own because when I was watching yesterday, I thought that she was um coming off. I don't think she's a monster like the
She's
state's
not a
trying to
monster.
portray her by
She's
any.
not like she's like a Midwestern mom who's like having an affair and like not happy
So
in her
what? Why is
marriage.
that even? I can't even
I'm
believe that
just
got
telling
in.
you, like,
Is that got into evidence?
oh yeah,
This
it
judge
got
is off. She's off the fucking. She's off the. I don't know the
well,
rails.
it got into evidence to show that she was non-existent in this kid's life, like that she was so wrapped up in her own shit that she wasn't paying any attention to what was going on right under her nose, like
Well,
that.
then you know what? I think the prosecution might have just shit the bed with that because if that's the way they came at this thing, like you said, there's a lot of loving, caring parents who don't have as much time as they should for their kids. And, I guarantee you one of those, how many men are on that? How many men are on that jury?
For
One of
real
them
though,
has cheated
for
on
real.
their spouse.
Yeah, well, she was the cheater.
I know, but I'm just saying, I'm doing the odds there on the men, but because
Yeah,
again,
no,
to me, all that matters is what happened when you saw that picture and what information did you know going in that affected the way you translated it. But um, I'm gonna have to watch it on my own. What are the people over here thinking that have watched it? Are they feeling the mom's
like,
culpable?
do we know how to do? Can we? I don't know how I get a poll up in here.
Like, so you got to go into the actual YouTube. You can't, at least as far as I know, from StreetBear. Go into YouTube and like the bottom button where like you normally do like emojis, there's going to be start a poll.
Okay.
You may have to do it from the studio. I'm not positive, but that's how I do it.
Let me see, because I'd like to get a poll and see where we're at with this. All right, this will be like a miracle of tech, like genius on my part if I can actually make this happen. Because you guys know I'm not tech savvy.
All right, so I'm dying to know because what I saw yesterday. So I was working. You guys had on this trial, and then you left, and like YouTube just kept playing it in different days. So I saw this whole thing where the defense was getting in her. It was interesting. I was hoping that people were watching the whole work product argument where the prosecutor was like, "Well, Your Honor, we were going through the text and we saw one from her lawyer, so we immediately flagged it. No one read it. We know it's work product." But she just opened the door by saying she was waiting for a call from her lawyer. And now we want we want to read all of the lawyer and her communications. Did that actually end up happening?
Yeah. Yeah, they came in. I mean, they didn't hammer it the way that they thought that they would, but they definitely got into it. So Jay, I'm in do I go into the control room? Do I have to go into the stream
So
itself?
all right, you're in studio.
Yeah.
All right, so did you go to content? Like on the left
Yeah, I'm
side
in channel content. Yeah,
Are
I'm
you
looking
guys talk to each other? I'll talk to the people.
Go to content, go to live where go to the stream.
Yeah.
And
Go
then there's
view in live control room.
yeah, and then
Okay.
go to the chat there, and there should be create a poll at the bottom.
Okay.
I don't know. I don't know if it's an unpopular opinion, but I'm just sorry. I cannot blame legally blame that child. Begging for help. Begging. I mean, you couldn't ask any louder and any clearer for someone to give you help. And he was hearing voices, and it's such a horrible, horrible shame. It's these kids didn't need to die. This child didn't need to lose his life like future as well. All of this could have been avoided, but the question on who to blame legally and morally is so difficult.
It really is.
I got a question for you. If she is found guilty, is there a mandatory sentence? What do you think the sentence will be?
I think the judge would see, I don't know, because of like the public eye, I really think that affects things, because I think that, it'll be, I think that in other situations, she might have been not having a jail sentence, may have been, 3 years stayed with like intense probation. I haven't looked at the statute, but it doesn't need to be a very long sentence. And I think if there is a sentence, it's going to be, short, but I don't know, because the whole public eye really changes the way what judges do. And in my mind, I don't know this for sure, but I just think that that's.
Yeah, I mean, all right. So hopefully I
Poll
don't
is up.
Pavitra. Yeah, the poll is up. I did it. $5 hollow plus a $2 hollow. Thank you very much. Honestly, I do not feel like she ever thought that he would do this. Have been watching you for a long time. Love your channel. Thank you so much. And we love you for being part of it with us. We appreciate you so much. And thank you for that generosity. We really appreciate it. Okay, we saw this one. Royal Galen, $20 holla. Wow. Personally, if I saw that math paper, it would be we are heading to the mental health facility.
I mean, I would have taken him home anyway. I would have made an appointment, took him. Like we discussed, we probably would have done the same thing, really, like taken him right away somewhere. But even something short of that, based on something he said.
Well, you and I had a little bit of an internal debate as to what we do. Like, I was like, I'm going right away to the mental health facility. And they're like, you're not. What? Like, what are you talking about? I'm like, yeah, no, we're going right, like, immediately. I think I turned you by the end.
I wasn't sure right away that I would do a 3-day hold. I felt like I might.
All right. Well, I would have kept putting that paper in your hand every time you were talking. Nah, I'm good. I'm like, wait here, just take another look at this paper. Okay, we sure just take a peek at that paper. Renee, yes, $10 holla. Thank you so much. Someday I'll have cool little songs like my boy Jay. Jay has all those cool little songs, and I could do my dances. And $2 holla from Maria. Thank you. People in other chats think
they want to see the poll with 3 guilty, not guilting, undecided.
So there's 124 votes right now.
Oh, yeah. You guys are right. You're right. I'm going to go back in.
What did you do?
I always get shit for that too. People always, when I do my.
I mean, but Bob should know better, because people are supposed to be undecided at this point.
Hung. We'll call it hung.
I guess it's like we're trying to say leaning towards, but undecided is still an important answer, because undecided tells you that the paper in and of itself wasn't enough. And I feel like you're not conveying to me enough to.
I'm going with hung completely on this. All right.
I mean, they only need one mother who. I mean, you
just need one parent who's like, what? Like, now they're trying to charge parents for the shit their kids do. Like, that's all you need is one parent who thinks that way. You know what I mean? Like, and believe me, I have seen in the chats plenty of people saying exactly that. All they need is one of those folks right there, and they're getting a hung jury.
What were the professionals bullying? The prosecution was bullying her. Oh.
Yeah, I didn't think he was overly rough on her, actually.
I agree. Yeah. I didn't think he was.
He was very snarky with the attorney. All right, so let me see. Can I edit that poll?
No, you got to edit it and start it.
Okay, so I'm gonna add that one. All right, y'all gonna have to vote again. Bye. I'm gonna start a new one.
And what's unfortunate in states where the law, it used to be for insanity that you could not control your behavior to the compounds of the law, conform your behavior to the law. Um, and most states now, it's just you do not know the difference between right and wrong. So, like, for example, you literally think you are killing demons or I mean, that one's actually even, I guess, questionable. But you don't understand what's happening. So you don't know the difference between right and wrong because you're not seeing reality.
Excuse me. Yeah, I mean, it's a tough case, man. It really is. Like, but it is and it isn't. You know, it's like in the scope of what it means for this country moving forward and parents being held responsible criminally for their children's actions, it's huge. You know, like for me, that's part of my analysis. I don't know that that's part of the jury's analysis because of
I'm
exactly.
sure they're
Okay,
thinking it not
maybe,
as
maybe not. Let me
not
like how many
as
of you in chat
concept-
were thinking of this trial in terms of kind of like a global view as opposed to like just the trial itself. Like how many of you, like, and honestly, like when you first heard about this and they were charged, was your first thought like, oh my God, they're going to start charging parents with like the shit that their kids do when they're not around their parents? You know what I mean? It's like, I don't think that everybody was thinking that way, babe. Honestly. Gypsy Soul, $10 holla. If your kiddo or any kiddo, write or say what Ethan does, believe them. Always err on the side of safety. Absolutely. Like, to me, that's just like unequivocal common sense. Like, I can't, like, anybody, like, it's such a hard argument for somebody to make, like what you're asking. Like, well, what did she say to justify not taking him out of school? And like, there is no right answer for it. Like, I just don't see how anybody could be there. And
So what's the statute she's being tried under? What's it say?
Involuntary. I pulled it up during the like the stat. It's not as easy. Try to look it up, like, because the way that it's a Michigan case. I pulled up the Michigan statutes. I had it up during our live with Sonny, and it's not clear. Like, they don't spell out exactly what the elements are. I mean, we'll have to wait until but it's essentially, knowledge and disregard, that you had knowledge, or or you should have known that that your action or inactions was going to result in great bodily harm or death. I mean, it's essentially.
All right. So the model criminal jury instruction in Michigan for involuntary manslaughter says.
All right, while you're pulling that up, missing and loss. What did you think about the defense and prosecution constantly interrupting each other and the judge not having control of the speaking objections? Kind of par for the course, to be honest with you. I mean, it was annoying for certain. I mean, you typically don't want to see that, obviously. And the judge was very lenient. Like, I agree. I think that the judge could have reeled that in. And to be honest with you, I think that there was a off-camera probably meeting back in chambers because the male state's attorney and Shannon were really going at each other, like a lot of sniping back and forth, and the judge can wrangle that in. Like Alice and I have had that where we're going with the state and we start arguing with each other because it gets heated in there. Like, you're in a moment, like you're not aware, like they're not remembering they're on camera. Like if people ever think that lawyers are doing things for the cameras, they're not. You're completely unaware of it in that moment because there's nothing more intense than trying a case like this. The only thing that you're thinking about is the things that are in front of you. You may be aware, obviously, when you're not on camera and you're not in trial, that it's being televised. So you're aware of that. You're wearing nicer clothes, getting your hair whipped, getting the butter whipped so you look good. But in terms of like in the moment, you're not thinking about it. You lose sight of it. So, yeah, it's the judge's place to shut that down. And it seemed to lessen when you look at the first couple of days of trial. The back and forth was unbelievable between the two of them. So I have a feeling the judge took him back and said, cut the shit. You know, like, I'm trying to be cool up on the bench, but you guys are acting ridiculous here. Did they take a lunch break? Because they've been on break for a long, long time here. I want to make sure that we're like somebody.
They're not down there.
It says live, so I haven't seen. Yeah, it looks like they're still on break.
Well, this says first that the defendant caused the death of so and so. I don't know. I might not be. I need to look at it to know under which part of the act to know.
Gypsy Soul with another $10 holla. And Shelby, thank you so much for your incredible generosity. We appreciate you. Believe me. Peace. Does that mean you're out? You out? You have to go do real work. You have to leave us and go do your real life.
Ooh, what was that?
I don't know. Wasn't me. Maybe it was Stevie.
I don't think so. Not if this is the way it's going down.
All right, Gypsy Soul, always $10 holla again. Appreciate you. Always believe the kiddo. If the kiddo is verbalizing or making reference to harming oneself, I'm assuming, or others, take the kiddo to a hospital immediately. They will have a licensed mental health professional assess. Absolutely. 100% on that.
Well, you were saying put them in for the
72-hour hold. Yeah.
Right. And I was just
do you trust anybody out there, like mental health professional, to like evaluate your kid for like an hour? It's got to be.
No, I don't mean that. I was just saying when we were kind of talking about it that I might be hesitant to do it like right away, depending on the circumstances. Like, yeah, home with us, making an appointment, but like just locking them up right away kind of scares me too. I don't know, like that's the.
I know.
Like if you're thinking like something like that with your own child, like
dude, like, right. The concept of us like walking out of that building, leaving our kid there is terrifying. I'm with you 100%. Like, I mean, that's like, I'd be like, can we stay here with them? like I'll sleep in the corner. Like, I mean, we wouldn't want to leave our kid behind. Like, yeah, I get that. But at the same time, it's like, you gotta do something. You can't just sit there and hope against hope. So Mrs. J, $5 holla. Appreciate that so much, that generosity. I hold anyone culpable whose gun is used and it wasn't secured. Anyone under 18 can't be the securer of guns. Agreed. We're certain. I mean, there's the gun safety issue, because you have two issues that are competing.
Maybe is it the involuntary manslaughter, failure to perform a legal duty? Is that the one she's charged with?
Read it again.
Failure to perform legal duty.
No, she's charged with involuntary manslaughter.
All right, we're gonna have this discussion.
Oh, you mean is that under the instruction?
I'm wondering under which part of the act she's charged, because there's different instructions.
Yeah, I can't remember it offhand. I might still have that. I don't know if I have that statute up. Let me see if I had it up on. Yeah, I don't know. I don't think I
that's maybe that's it.
If
that's it, they have to have willfully neglected or refused to perform their duty.
Yeah, I don't know.
Grossly negligent to human life.
All right, Kristen, $5 holla. You're not alone, Allie. It's so hard to feel sympathetic in these situations, but I do really feel for Ethan. I mean, you have to. It's like the kid was failed. Like, and it is hard because of what he did, but it's like undeveloped mind. Kids, like, I mean, if the kid is literally battling like psychosis or, some kind of like true mental illness and he's failed by everyone, I mean, how much can you blame the kid? It's like, that's what our role is as parents, to recognize that and to try to help them the best that we can. I mean, there's like, yeah, it's It's just brutal. It's brutal.
So if this is the part she's under which she's charged, you've got the first element. It says the defendant is charged with manslaughter resulting from the failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. One, that she had a legal duty, which she did, to take care of her child. I mean,
For sure. Which
and
brings
then-
up that interesting question that people keep asking that I want you to address. He was charged as an adult. Okay. And I was trying to explain to people that doesn't matter how he was charged after the fact. And people were wondering, if he's charged as an adult, how are they then coming at the parents for not treating him as a child? You know what I mean? It's like,
Well, yeah, then it's just the answer that they're not. It's not like they were emancipated before the fact, so the parents weren't responsible for them. One has nothing to do with the other, because one is just the way they're charging a child who a parent still is legally responsible for. But yeah, if he would have been legally emancipated before the fact, then that'd be a different situation. Okay, so second, that the defendant knew facts which give rise to the duty. So that's why I'm not sure this is the right one, but I mean, I guess it's so in this situation, I guess would be the facts that, the paper, the facts that let you know your child needed help. And then the questionable one here is that the defendant willfully neglected or refused to perform that duty, and the failure to perform was grossly negligent to human life. That part I think you could get to, was grossly negligent for human life. Willfully neglected the duty. If
it's
the
tougher.
school gave her the option of whether to leave, I
It's
mean,
tougher.
willfully neglected her duty. That implies like you, like
Purposefully. that
on
you
like
knew-
consciously.
The school
yeah.
was like, "Get the hell out of here!" And no, he's staying. Right? I mean, that
I
would
thought
be
somebody said something like the school gave her 48 hours or something.
to get him help, but not to take him out of school. Like,
So the
yeah,
school, I still don't get how the school tells you to take your kid home. You say no, and the kid stays.
they didn't tell him to take him home. They gave him the option that he
Well.
could stay here for the rest of the day, but you have to get him help within 48 hours.
Doesn't sound willful to me.
I mean, to me, like here at our school, that's automatic suspension immediately. Like there's no due process. Like your kids
Well,
suspended.
they don't suspend you for your thoughts.
That wasn't a thought. That was a threat. I don't know how you look at that as anything other than a threat. Fids, I love you, Allie. You're a strong woman. You are. Woman goal. You are. I love you too, Allie. You are a strong woman. And thank you very much, Fids, for becoming a member of the family. Family hug. Aw. All right. Let's see. Janet stuttered. $5 hollow. Personally, I think the school official who sent him back to class and didn't check his backpack should be charged.
I mean, the mom should have checked. The mom should have checked for. It's just,
It's
still
crazy.
can't
It's
wrap my
crazy.
mind around it.
It's very difficult to wrap your mind around it.
But
like I
she's
was
absolutely
saying, like,
right, Janet. I mean, absolutely right.
that's a harder
Under
case
no
than against the
circumstances, a parent might be, like blind to certain things when it's in their face because it's their kid. But a school, anytime someone draws a picture of a gun, the first thing needs to be to check their backpack, their locker.
Yeah. Mama K Marquetto, family hug. Thank you for becoming a member. We love you. We love you. Thank you so much. We appreciate you.
I'm gonna leave you guys.
What? No, but like hang out for a while. Dom's mom, 725, gifted 5 Defense Diaries memberships.
She's
we
done
have-
that before. I recognize her
She's
name.
amazing. She's
awesome.
She is one of our like always givers. I like to call them our always givers. We have a bunch of always givers that just give until it hurts. And we love you so much. And those five lucky souls that were gifted memberships, I'm sure love you as well. because they should. That's super, super, super sweet. And I saw my boy. Look at this. Look at this. Talk about the family. Fam coming through. I don't even like Steve's actually at work, so he's probably not in here anymore. But he popped in and gifted a Defense Diaries podcast membership. Steve-O, I love you, man. Thank you, brother. And Galen, boom. Look at that.
10. Wow.
Yeah, Galen's an always giver. Like Galen is one of our always givers. She's always incredibly generous.
You guys doing anything exciting for your anniversary?
We are going to a nice little happy hour. We're gonna drive there.
You're gonna trust the kids home alone?
Can you believe it?
Did they
yeah,
break anything last time?
No, yeah, they broke their bed, but no, that was a different time. That was not that time. We're gonna go there. We're gonna Uber home, and I was telling Bob, I'm not Mr. Spontaneity, so like I had to know the menu, I had to know the location, so we got that all planned out. So I'm very excited to get some margs and some apps and stuff. Where
what are y'all doing dinner wise? What'd you guys land on?
This place called Jack's. What'd you call it, babe?
You're gonna have the whole world know where he's at. He's gonna get stalked.
All his fans will be knocking on the window.
I'll have to no autographs. Yeah, I'll have to. It's gonna be good.
Luckily, Bob and I are both.
Well, I can officially shut down my YouTube channel. The entire purpose was for me to get Donnie to become a member.
Donnie boy,
it happened today. So I'm going to end the stream. I'm going to shut the channel down. Mission accomplished. Thank you, Donnie. You just took a whole bunch of work off my plate. You're a good man, Donnie. Thank you, brother. Appreciate you, man. And welcome to the fam over here, man. It's good to be members on all the extended family, and any of my people that are not members, and at the very least subbed at Jay's. Fix your life, get it right, get over there, do it. Ricky Kurbrak, who is Danny Boy, the other half of the gifted a 1 Defense Diaries podcast membership. Thanks, Dan.
Where'd that little sound come from?
It's got to be, I don't know. Maybe
I thought it was something you did because somebody gifted a membership.
It has to be Stevie or
someone else who knows.
It's got to be Stevie. Stevie's back here trying to work.
All right, I got a client calling from prison. I'll be back.
All right, sounds fun. Sounds great. Meg P gifted 5 Defense Diary podcast memberships. Meg, smooches. Family hugs to all the 5 new members. Ooh, thank you so much. Aww.
Who is doing that? I need to know.
I think it's got to be Stevie. Stevie, are you doing that?
Mandy and Stevie.
Got to be Mandy and Stevie. Shannon L gifted another 5 Defense Diary podcast memberships. Thank you so much. And like Jay, I was texting Stevie and Mandy, who if you guys love I know Shan's does your thumbnails, which are awesome. And so Stevie and Mandy do mine because I'm not able to do that kind of thing on computers. I don't understand it. I don't know where even start. Is there a program? Do I get a picture? How do I move things? So I come up with like a thought and then I throw it at them and then they come up with these amazing thumbnails. So they're handling all that stuff for me and they're amazing. And Mandy and Stevie are both mods and I love them deeply. So I was like texting them the other day and I'm like, you know what? I'm like, we really need to up the emoji game. I'm like, do we still just have like the 4 little things? And Mandy's like, what? She's like, do you know what emojis we have? And I'm like, apparently not. So she sent me like a screen grab. So she told everybody to throw the emojis in. So like our members have some pretty cool emojis. Like the shitbird one is just warms the cockles.
Mandy, she's the emoji queen. She is the queen of emojis. And they both, the thumbnail, Stevie and Mandy rock it.
Dude, man. Like I came up with the other day, like when on the Delphi thing with the when the state had filed their motion for contempt against those guys, I like immediately wanted like an Empire Strikes Back.
That one was so good.
I was like, I told Stevie and Mandy, I'm like, yo, Empire Strikes Back. I want like AT-ATs, maybe like a tauntaun, maybe like, where Han Solo saying, well, I'll see you in hell. That great scene. I remember when I saw that, like that was back before they swore like a ton in movies, and it was like that hit and like that scene. I was like, ooh, what an awesome scene! I'll see you in hell. All right, so wait, now this like Dara,
Dara like Sarah.
Dara like Sarah.
That's how we
Thank you,
learned on
Dara.
Steve's
And I
channel.
should
Dara like
know
Sarah.
because like Dara's always in all of our stuff, always giving. So I apologize, Dara, that I even had to ask. So please accept my heartfelt apology for not having that on lock. Thank you so much. Aw, family hug. Love it. I love all the family hugs. I like this many family hugs, Jay, is always good for us.
Always.
All right, is everyone making sure that this trial's not back on? I mean, this is a long break. This has to be
They have
lunch.
to be going on lunch, no?
I mean, it's got to be. Like the thing says, it's like it's got the little live, red live. I think I'm current time. I think it's still the state of Michigan seal. Somebody check somewhere, make sure that I'm not missing huge amounts of things because it's definitely possible. It's definitely possible. Meg P, again, you're so incredibly generous. Thank you. Thank you. Thank you. Thank you for being a member of the family, and thank you for gifting to bring other members of the family more family hugs. Aww. And then Dara Johnson, again, good morning. 3 months. She's an OG. Like her being like an OG was the impetus of me talking about having more emojis. Like, cause I started to get the multiple month member things. And I'm like, oh, well, they need something really special. So now I know. Now I know they have something special. So thank everyone that was so incredibly generous. Thank you so much. It's amazing. And thank you, my friend, for being with me today.
Of course. Thanks for having me on.
You are an incredibly wonderful human being who I love so much.
You are. Love you.
I'm close. I'm hot on Jay's tail. Jay crossed the 12K threshold, and it's like a great thoroughbred race, like two guys neck and neck trying to win the Triple Crown, and Jay's pulled ahead, and I'm trying to keep up. He just keeps killing the game with those videos, man. His Adelson videos are just crushing the world, which I love. They're so good. They're so good.
Thank you.
Yeah, and like, when are we doing?
You tell me. We got to do that because if we could do it,
dude.
we got to do a duel. We got to have them work on, like, I was thinking about this because I know Steven, they work on the thumbnails, some sort of thumbnail where, like, me and Shan are like attorneys and we're trying to fit you guys as like the judge or something where we're trying to convince
the jury.
Or the jury. Yeah.
Or the jury. Because my thing is, I 100% am in agreement with you that she is complicit. My thing is, do they have the evidence to get her? Like, because it's like, that's why I kept asking, like, when you premiered your most recent one, and I wasn't being snarky, I was asking like legitimately, like, I don't know. She was given some immunity. I don't know if it was use immunity.
Use and derivative.
So so like, I'm trying to figure, and like, she didn't really say anything that would hurt her being Georgia, in terms of being able to charge her where, okay, she said this at that trial, now I can't use it against her when I want to try to convict her. So I don't know that that'll be like a death knell to the case, but it's like, in terms of, I just think that she was smarter than Charlie and Donna in terms of what she was saying in chats and shit. It's like they need, like, because clearly, man, like out of every video you've done, the one that was most compelling to me was the map and her driving by, right
and
when
lying
it's
about it on 3 trials.
Exactly. And I mean, the timing of her being there obviously implies that she knew not only that it was going down, but when it was going down. So it's like, it's George's task is to be able to prove it beyond, because it's a really strong piece of circumstantial evidence. It is.
What about that she is at her parents? Because the whole thing in this latest trial, they made a big deal that their dad's birthday gift was essentially this hit. So here's my question for you, Bob. What about for the fact that she is at her parents' house when Charlie comes from Katie McBonner, the person that was the conduit to set up the hit.
Yeah.
He comes to her house, goes down to the birthday party, and they have a text message. They have Wendy pinging.
Hold on, I'm listening.
All right, so they have Wendy pinging at her parents' house for that party, texting Dan Markel, confirming he's going to be home the weekend where he's ultimately, unalive.
Yeah, I mean, that's pretty good. That's pretty good. So wait, so the text, so it's at the old man's birthday party. Katie's there.
Well, Katie's not there, but Charlie just comes from Katie's house. Like he's chinging how they're hanging out, comes down to the party. Then, like, basically the question is, how did the killers know that Dan Markel at that time? And then there's the whole call, 18 minutes and 17 seconds that Charlie and Wendy are talking that morning before that at like 11 o'clock.
Now, was that unusual, like in terms of pattern? Like
they haven't established that yet as far as pattern. I assume they're holding that for Wendy's trial.
Like if they can show that, like, over the course of the past couple of years, that might not be as damning. So, and I guess my other question would be, so Dan had just picked up or just dropped off the kids?
He dropped off the kids. He went to the gym, comes home. That's when they get him in the driveway.
Okay, so.
And he leaves her a voicemail. He leaves Wendy a voice. But Charlotte's saying, don't give all your information. When we have our argument, but when we have our showdown, he talks to her earlier in the morning. He leaves her a voicemail and tells her basically his plan. And all of a sudden she's calling Charlie 18 minutes. All of a sudden it goes down. Now, here's a question I have for you. Does it hold weight? Like, I think what the plan is, take down Grandma, take down Donna, and then boom, she's next. Does it hold weight for Wendy's trial? Can they use that as like argument that the fact that her brother and her mom are now convicted, or does that have to be completely separated? The fact that they were convicted for conspiracy and she's a co-conspirator.
No, I mean, it'll certainly be able to come
Wouldn't that be so much massive weight?
Yeah,
like, I feel like since it's so circumstantial, that's what she's trying to do. Let's get Charlie, let's get Mom, and now we got both of them. We're bringing her down.
I mean, that's 100% admissible. I mean, they're going to be hammering Donna with that, but like Donna's like her, like
no,
so
not Donna. I mean Wendy.
I know, but like at Donna's trial, just to give you an example of when consciousness of guilt comes into play, that you like comparing like Crumbley, like her flaking off, trying to get her life in order and try to get a lawyer in place and raise bond money if she can for 24 hours in terms of consciousness of guilt, compared to Donna. That is consciousness of guilt, plus the recordings. I mean, like, she's done. Like, I agree. I don't understand how she's going to trial. Like, I don't know on what world she thinks that she has a chance to win a trial. Well, she's like beyond done.
Are you familiar with Lord of the Rings? There's the one king who, like, there's a guy in his ear and he's like just convincing him the whole time, and like he just listens to him. Rauschbaum, I feel like he's convincing Charlie did a good. After Charlie, she goes and gets him now. Like he's convinced them that like he's got the plan when it took less than 3 hours to convince Charlie.
So did you watch Joel's thing with Rauschbaum? Like, how was it?
I did.
Did he give him the business at all? Or
Joel absolutely was not giving him an inch at all. He did kind of bring up everything. I mean, the biggest thing that was upsetting to, I think, most people was Rauschbaum kept bringing up Dan Markel, the fact that he was like a criminal defense attorney, and kept saying like, this is what he would want. He would want this kind of defense. This is what, and everyone's like, I mean, you just represented Charlie, who was convicted for his murder. Like, maybe keep his name out of your mouth. That was to me, the most upsetting thing. But I thought Joel did a good job. In my opinion, he kind of stuck it to. I thought he didn't really give him an inch when he was asking him all the questions.
I'm surprised that Rauschbaum came on there, man, to be honest with you.
Like,
in light of the fact that he's now repping Donna.
Yeah.
Like, I mean, it was a great get by Joel, no question. Yeah. But like, in terms of, it surprised me that counsel would come on and do that. It's like I don't
What would
know.
be the other than PR? Like, what's the reason? Someone's saying check the courtroom now.
Check the courtroom because I think he is. Let me see.
Todd is saying check courtroom feed! Exclamation point.
I'm still showing. I'm still showing that it's. Oh wait, let me see.
Dizzy says not back till 1 p.m.
Oh, 1 p.m. Okay. I don't even know what time it is. Oh, we're 12:40. Yeah, it seems to me like what they might be doing now, because I don't know how much she's gonna put on. Like, I don't know. Excuse me, man, dude. I've had this head cold for like 3 weeks.
Oh, it's the worst.
Oh my god, I can't shake it. It's brutal. I think what they might hold on. I'm gonna use cough button so I can really, really hack violently. And not really gross everybody out.
Well, while Bob does that, would you guys be interested in we do a dual live stream where me and Shannon try to convince Bob and Allie, and we'll do it from both channels? What do you guys think about that? I think that would be awesome. Babe says Joel said he approached him in court for the interview. Wow. Yeah.
Yeah, that was the story I heard as well.
Wow, he was the one that that's insane.
Takes balls. Gotta have some balls. Gotta have some sack. Hey,
by the way,
I'd like to have you on my show.
On my anniversary, I would be remiss if I didn't say, if you're not subscribed to my wonderful wife's channel, please give it a subscription. She's doing great work on this. She just did a show with Chris Duet that was amazing. Mindful Crime Couture. Please give it a sub. She's amazing. She deals with me just for the fact that she has to deal with me 24/7, folks. Give her a sub, please. I think you'll love her channel. If you like our channels, you'll love her channel. And I love her, and she's the best. And she's letting me do this right now on our anniversary. So
damn,
she's
man,
the greatest.
Jesus.
You're all right, dude?
Dude, I'm like, I think I might actually be losing my voice, which would be catastrophic. Yeah, no, that live with Chris the other night was phenomenal. I was like all up in the chat, and it was phenomenal. So like on my so I copied your lead, and on my channel I put like all the homies, like all the fam.
Oh yeah, nice.
Anybody who doesn't know where Shan, like I've got a link to Shan's channel, obviously Jay's channel, Joe, and Publicly Buzzed. If you guys are having a hard time finding that. Let's see what else we got here. Yes, Jedi. This is the verdict, actually.
Bob, I came in before and I was asking that, and a couple of people I think got angry. They're like, "This is cross-examination. This is not the verdict." You can't explain to the people that don't know the inside joke.
Yeah, it's an inside joke. And Jay would like it. So, what case was that? I can't even remember what case it was. I can't even remember what you were streaming. It was some case, and excuse me. Hold on, I gotta go get a cough drop. Talk.
Well, I'll tell you guys, this was the deal. I was giving a heartfelt speech to Bob and Allie because we had an issue that came up that we needed some like legal advice on, and they like dropped everything they were doing. And I was giving this speech about what awesome people they were. And as I'm trying to give this speech, someone just keeps spamming me in the chat. Is this the verdict? Is this the verdict? And it wasn't even the verdict in the case. It wasn't even close. So that's why me and Bob always comes in our chat and says, "Is this the verdict?" And despite it not being even close to the verdict in that case, guys, I talked about this yesterday. Shannon and I, both have gone through some contentious divorces, which, by the way, is one of the reasons that I'm so into the Dan Markel case. And babe, you know what I thought of the other day? Not only did I have two young sons who are very close in age to the Markel sons, and it was a contentious divorce. Are you there, babe? You know what I thought of that I never thought about before? The fact that my ex also has a brother that no longer speaks to their family? And a missing family heirloom. Yes, a ring from my grandmother that I don't have anymore. So, yeah, there's I don't think it all clicked to me until recently, but the case is very similar to my, which I think is my thumb. What? Sorry, I'm doing hand signals. I'm sorry. I don't know why I was doing that. Anyway, I'm not crying. I just that's that. I think that other than my pure hatred for Wendy Adelson, which by the way, folks, I'm gonna have a new premiere I am working on. Oh, did the thumbs up thing happen again? Oh, it did. Oh boy. I'm working on a new premiere on Donna Adelson. So look out for that possibly this weekend. I'm not sure. What? I can't do it. I can't do the heart. Babe is giving me shit for the heart. I'm not doing it right. What are the other things? There's this one, this one. Is there this one? The thumbs go down? Oh, there we are. I did it, babe. Oh, and it has a sound effect too? Or is that's not from me, is it? Who's playing the music? Who's playing the music right now? I feel like there's another one. There's like a laser one. What's that one? I've never seen a heart. No. I'm done with that. God, for all the people who have no idea who I am, I'm so sorry. For all the people who are here on Defense Diaries, Bob and Ali Matas, and all of a sudden they see this jabroni trying to make hearts. I am so sorry you've been subjected to this. I am so sorry that this happened to you. This is terrible for you. I'm so sorry. There are people right now who are unsubscribing to Defense Diaries. This is my plot to keep my lead on subscribers. I'm gonna just have everyone leave Bob's channel as they watch me. I'm so sorry.
Wait, is Chase plotting against me?
Well, I was just saying, Bob, because I have this thing that I turned off, but apparently is not turned off. I got all these effects going on, and I'm like to anyone who's coming on to Defense Diaries and now looking for Bob and Ali, and then they see me full screen trying to make a heart, so hearts come out of the screen. They're all like leaving now. So I'm so sorry, everyone that doesn't know who I am and has no idea. Like, what does
How
Bob
do you turn
and Ali
that feature on anyway?
It's under like the FaceTime thing. It's like you don't want to turn it on. You don't want to be. Trust me, you'll be in the middle of an interview and then you'll see a thumbs down on your screen. You're like, what the hell did I do wrong?
And for as much as I hand talk, it'd be a nightmare. Like, I am a hand talking dude, man. Debbie, $5 holla. Love you, Debbie. Appreciate you. Missy Mayhem. We love you, Missy Mayhem, who is a mod to both of us, a wonderful human being, and who has her own channel going.
And she's monetized now, folks.
Oh, woo!
I was
on last weekend. I was in Costco and I was checking out Missy's stream, and I really wanted to gift. And I'm like, why can't I gifty? And like, she wasn't monetized yet, so I'm definitely coming back, and I'll be giving out some memberships. I love to give out memberships on my homies' streams. It makes me so happy. So thank you, Missy, for being a member for three months. Beyond that, for everything else that you do. Truly. Ginger Snaps, another 3-month member. Woo! Family hug. Also, there is an
new Delphi.
No, where is Sleuthy? Sleuthy, what is it? It's got to be, if I had to guess what the new Delphi doc was, I would guess that it is Judge Gull denying the defense's motion to recuse. That's what I would guess. That's what I would guess. All right, let me see if my texts are blowing up with people. Oh man, dude, that case is ooh, so much. Such Diamato. Let me see. I'm not seeing any kind of. Is Sleuthy still in here? She knows. Rosie filed for a continuance in the Delphi case. Continuance of what?
Of February 12th hearing, Fulfa says.
Oh, thank God. Like, she makes the hearing the day after the Super Bowl. It's like I'm traveling. I'm like, oh, great. Now, I'm gonna be in Tennessee. So now I have to try to find a flight. Like I'm gonna have to leave the night of the Super Bowl so that I could be in Allen County to watch this absolute that case, dude. I've never seen anything like it, Jay. I've never seen anything like it.
Since I've known you, you've been calling that case
oh man,
on another level.
Dude, it is. I've just procedurally, I've never seen, and what's getting lost are the victims and the defendant in the whole thing. It's like the victims' families and the defendant are just embroiled in this this huge pissing match between the judge, defense counsel, and the prosecution. It's and it is and I'm not blaming the defense in terms of continuing to pile on. I mean, I certainly think that the sloppiness that was involved with the leak happening, coming out of Andy Baldwin's office, there's some culpability there, but in terms of it just snowballing into what it's become, it's and I thought, I was really hopeful coming out of that Supreme Court thing that it was coming. What are you doing?
I thought maybe they came back on.
Oh, why don't you jump on? Why are you going to sit here like you don't have your own setup?
Because I need to be working, but I figured I'd pop in.
I think you need to be done with that thing. All right, so I'm going to do another poll.
Oh,
who thinks that Allison needs to be done with this PCRA that she's been working on for 3 weeks? Talking about, I'm not trying to make light, but talking about Allie being oblivious to the family. That's been Allie for 3 weeks, sitting behind her computer. I've been able to pluck her away twice, I think, for lives, but
people can attest to more than twice.
I can't record the Garcias. I can't do any of the because I need the time, and I haven't been able to pull her away. So everybody was really pissed about there not being Garcia. It's her fault.
By the way, Allie, if there's any more, if you got any more, open invite. If Bob, your boots on the ground and Allie needs a co-host, just let me know on any of those upcoming hearings.
Oh, totally, dude. Yeah, that was a blast. You guys crushed it. I went back and watched it. It was awesome.
I just was laughing at how you dropped all the.
Oh, what I aced? I just unceremoniously killed the stream with our all-time peak number. It was awesome, and it'll be a day that'll live in infamy. I mean, it's kind of on brand for me, though. It's it's legitimately I am the caveman lawyer. I don't understand your modern world. I don't know. So modern.
I'm gonna go watch the cross-examination so that later, if you do want to do another live, I can be educated.
Oh, okay. All right. So yeah, let's talk a little bit about the trial. So I don't anticipate she's going to put many more witnesses on. To be honest with you, I was shocked to start her case in chief that she would have started with the defendant. I was not at all surprised the defendant testified. I thought that she would 100%. I think that she had to. It was mandatory. In terms of, what else or who else she can put on to try to mitigate that math test. I don't know. I don't and I do want to discuss, I do want to discuss, Shannon Smith and like her lawyering, because I have seen when I was on the law and crime chat, I mean, people were just giving her the business, man. Like giving her the bill. Like, I can't stand her constant whining. She apologizes constantly. Like, what the objection? She's in it was just like a constant stream of, and I couldn't help but feel exactly what you said, that there's that element of just, I don't want to go so far as to call it misogyny or the patriarchy is probably a better call for it, but just that, yeah, like if you have if you don't have a woman who has a deep voice and is acting like a man, they're like, I don't know,
I'll
man.
say this, Bob. While you talk about we got to thank our people, both on my channel, your channel. You talk about the law and crime chat. Our people are so awesome. Like they come to our chat because it is in those law and crime chats, it is a mess. So we got to thank you folks for always
Oh my
in
God,
Bob's
guys.
chat, our chat. Like we appreciate you folks for being respectful and kind and not just
And
adequate.
smart and so smart. Like
Funny.
that, like that's the thing. Like we've got like our chats are just the people that like probably,
If you're paying over $80 a month for car insurance and you don't know this, I
ad
guarantee you're losing
time.
money.
It's ad time,
So there's a
everybody.
comparison shopping site that finds
And the
you
mods, absolutely the mods. We
based
couldn't
on
do
your
this without
info.
them.
Oh my
You
God.
just put in
mods
some
are
information
everything.
that the site needs to find you lower
I
rates.
can't even find
Stuff
that
like
skip
where
button.
you live and your driving history. Then boom,
Oh, there it is.
you get recommended.
Yeah, I want to know why in the world, like I am definitely subscribed as premium. Like, game time. We have movement. We have movement. All right, I'm gonna pull him back up. See what's going on. Crumbley's back in the room. Oh, wait, I'm in the wrong thing. Which one I was in before? We don't want to use that one. Oh,
That's good. It's hidden.
Stevie.
Good job.
Stevie. Stevie. Behind the scenes, the wizard.
Wow, you're not kidding about her doing this by herself. Look at all those pages that she's going to do by herself.
I'm just trying to say, man. I'm just trying to say.
The one thing I noticed about this defense attorney today, because I haven't watched her, body language wise, very animated. Like she's crossing her very like I guess into, I don't know what but I noticed during.
Let me ask you, does that affect you? Like if you were, do you think that would affect you? Because I always wondered that. Like I would always want to poll jurors after a trial because I'm a very animated lawyer. I'm not stands out. Like I'm a hand talker. I move around a lot. I'm very
honest. What more bothers me when I watch these cases, and people could probably go test to this, is when attorneys are like belligerent. Like there was when Harpootlian was like just being like, so when they're trying to make a point, they're trying to go over the top and they like are almost belligerent. That really bothers me. But I mean, generally speaking, I don't like that. Didn't bother me. Her being, I just noticed it, but it didn't bother me. But being disrespectful bothers me, and
some people hate animated lawyers. Like they would have hated Alice and I. Like we're so like we're both just passionate people, and like we don't check that at the door when we're trying a case. We're fighting for people's lives. It's like, I mean, we're always respectful for the judge, but
a set of final jury instructions that I believe both sides agree to. Yeah. But I just want to briefly go over the instructions that we're given, find out if there's any fill-ins. And then we'll have a final set of jury instructions. I'll provide this to the jury. Okay. So we're going to do 3.1.
Okay, just so y'all know what's going on right now, they're having what they call the jury instruction conference. Each side submits a set of instructions that they want read. And if you all aren't aware of how important jury instructions are, next to the jury, they're the second most important aspect of any trial, because it's literally, and it goes to just the parsing of the English language in the law, and it's what we do for a living, and every single word matters. Because what happens is the jury, when they get sent back, they're going to be set with the set of jury instructions that were agreed upon by the parties. Most states have uniform jury instructions where they're kind of out there.
It doesn't matter to me. Normally,
She'll be arguing about all kinds of shit during this. I predict a lot of arguments from defense counsel.
Does this mean she rested, or are they doing this before she calls additional witnesses?
No, it doesn't necessarily mean that she's rested. But it means it's getting close. Like, she's probably advised the judge that she's like within one or two witnesses away from ending the case in chief. And then, of course, the state has the ability to put on rebuttal witnesses. But remember, a rebuttal witness isn't just like additional witnesses. They literally have to put on a witness to rebut something that came about during the defense's case in chief. So it's not a free for all.
Chat's saying they rested.
They did. Did they rest?
That's what it looks like.
Who said that?
Someone in chat. Looks like they said chat was saying defense rested. Court TV said it rested. I don't.
Oh.
Lizbeth tweeted she rested.
Yes, Judge.
We stipulated to their autopsy reports.
Oh,
So
you bet, Donnie.
Yes, Judge.
For as much Jay watches Donnie's OnlyFans, and he's constantly texting me about how great it is.
It's
I'm
the
dude, I
best.
gotta go check it out.
$349.99 is a steal for a month. Let me tell you, folks.
I mean, all right, so it's strange that they didn't rest like while the cameras were running.
There's a unanimity instruction that is
She was
based on.
she was going to call the grandparents.
A non-standard civil jury instructions, and the parties agree to that instruction.
Yes, Judge.
Correct?
Yes, Judge.
Okay. 16.13, involuntary manslaughter, failure to perform the
Agreed.
as count 1, 16.13 as count 2, 16.13 as count 3. 16.
See, Sarah is not a Shannon Smith fan.
16 as the count. 16.15.
One instruction for 1650.
Say again?
Just one instruction for
Yeah.
1650.
I was trying to see, I think there were some things added, there was a foreseeability excerpt.
Yes, Judge.
Agreed upon.
Yes, Judge.
Yes.
Okay. That's non-standard agreed to by both sides. 16.18 gross negligence. There's an instruction about not using the shooter's name. Maybe they should get rid of that one. 3.11 deliberations and verdict. 3.13, which is possible penalty. 3.14, treatment with the court. 3.15.
I've got the volume cranked as high as it goes.
3.16, written or electronically recorded instructions. Material. 3.20, simultaneous multiple counts, more than one wrong act. 3.23, with regard to the verdict form, and then there's the verdict form that's standard, right?
Yes, Judge.
We have obtained a computer.
See, the problem is the judge doesn't have a mic.
The thumb drives. That's going to be in the jury room.
I'll have to give you the. I got a volume booster for Chrome.
Don't think so.
Oh, you do?
I don't have.
Yeah, I'll show you how to do it.
I just have mine. I just have a hard copy.
That's it. We'll send it on. Okay.
See, my challenge is I have to use Chrome for StreamYard,
Anything
so
else?
I have to use Safari for my stream. So I haven't been able to figure out how to use,
No, I don't think so, Judge.
like, is there a way I could be using Chrome for my StreamYard and using Chrome?
Okay.
Yeah.
There is?
Oh yeah.
Back down and then they say-
There
It
should
doesn't
be.
give it doesn't give me the option to like I don't know how to get it to
Okay,
Do you create a completely new tab for it?
on each copy of your instructions, just to be sure that we have.
Let me see.
All right, and these will be the instructions that go in with the juries.
Thank you, Judge.
oh god.
At
Damn it,
the
you're smart.
moment,
New tab to the right.
is-
Oh, Jay, I love you. Love you, man. So many tips that make my life easier.
I think with your puzzles, then we could start deliberating.
I'm concerned about that. Are you not concerned about that?
No, Judge.
I'm gonna approach you.
Concerned about what? I was
I
talking.
don't know. I missed that. Hit the rewind.
All right, let's see what's up. Let's see what they're concerned with.
Anything else at this time?
Not much.
I don't think so, Judge.
Okay, so we'll be back in about. Well, we're gonna take her back down, I think. Okay. We're gonna take her back down and then ask her to bring her right back up. It won't take long. Okay, yeah, the jury instructions are ready. But I think I'm gonna give you each copy of the jury instructions just to be sure that we have it. All right? And these will be the instructions that go in with the jury.
Thank you, Judge.
Okay. At the moment, after closings, I'm going to eventually instruct them. I am going to have all 7 to come back. Right? Does that make sense to you?
I think with your puzzles, then we could start deliberating.
I'm concerned about that. Are you not concerned about that?
No, Judge.
I'm gonna approach you.
Interesting.
What is she concerned? I still didn't get it.
So, what she's concerned about is the dreaded Friday afternoon start of deliberations.
Over the weekend.
Yeah. Well, that and you've got a jury that's been in trial for a week. And I'm always concerned with the Friday deliberation starting like late afternoon because you worry that they're like, yeah, I'm not coming back on Monday. So we need to figure this shit out now.
Right.
You know what I mean? And that's a very real thing. Like we actually bring that up during Vordaer all the time. You know, like if this is because we'll ask if people are going to be able to stand up to resistance during deliberations. If they've got a different opinion, are they going to be able to withstand people coming at them, which is allowed. We know from the Becky Hill thing, like that's not a thing. You know, jurors are like 12 angry jurors is a thing. You're allowed to go at it back there. You know, you're allowed to try to like adamantly convince somebody to change their vote. So I think it's interesting. The judge is concerned. I'd be concerned too, to be honest.
Well, you can. All right, you want me to bring the jury in now?
Yeah, please.
Let's go to closings.
One more, just wait.
What Taylor Swift song will she use in the closing?
I'm just going to print a copy of the jury instructions for you, just to be sure. Okay?
What's that?
We're gonna print a 7 jury
Oh,
instructions, and I can review those, just to be sure that they're accurate before I send them.
And thank you for all our beautiful subs that let us know that the jury rested. I had no idea. I don't know how y'all knew that. The defense rests. I like to hear it. I didn't get to hear it. All right, so it looks like we're going right into closing arguments, which is exciting. So we're going to be on verdict watch. It's exciting.
I mean, to me, I'm sure this is not what the prosecution is going to do, but I feel like your argument is the best argument, which is throw away everything. Like, what is the most important thing we have to focus on? This piece of paper, how could you ignore it?
100%. I mean, that's it. Like, that's the whole thing.
Ladies and gentlemen, you may be seated. Ms. Smith, am I correct that you just?
Yes, thank you.
Prosecutor, any rebuttal?
No rebuttal.
There they rested.
Ladies and gentlemen,
That's how they rested on the
evidence in this matter has been concluded, and now that we hear closings, I want to remind you that closing arguments are just that. We are, each side sees the evidence in the case. The closings themselves are not evidence. Because the prosecutor has a burden of proof, the prosecutor also has a right to rebuttal after the defendant's closing. All right. I think you're going to hear certain elements again of the crime charged, the crimes charged, and I'm going to be giving you written jury instructions that list those just so you know. All right. Prosecutor.
Yeah, that's fine.
All right. Here goes. Love closings.
It always seems like a good idea.
I love the way Donnie spells Julio. That's what I love.
All his words are just, you can't beat them.
They're special. Special words. Donnie's spelling and Steve's reading of new subs names and like gifts.
Can't beat that.
Dude, it's appointment television. That's all I can tell you.
Sorry, you're doing my-
This is go forward.
Fair enough, brother. Oh, good. I'm glad she's giving the closing. That dude got on my nerves. You know,
Thank you. Good afternoon. We told you in jury selection it was going to be 3 weeks, and it's now been 2 weeks, so we're a little bit ahead of schedule. This is our time for our closing argument, and I'm going to spend some time going through the evidence, and I'm going to spend some time going through the elements of the crime. I want you to know that I have been watching you diligently, taking notes and listening. So what I'm not going to do is spend a lot of time repeating everything that was said from the witness stand, because I know that you all listened, and I also want you to know that I really appreciate that, and I know the court does too. I told you during jury selection that it wasn't going to be easy, and it was not easy. Listening and watching and thinking about 4 young kids being gunned down in their school is not easy. You listen to every witness, you examine the evidence, and I suspect that many of you feel the way that we do, that it's difficult. But we owe it to the victims and their families to say what really happened. And you've listened and you've done that. In our system of justice, we have different roles to play, and each role is different. There are people who think it's the prosecutor's job to convict people. I don't think that's the prosecutor's job. I think my job and our job is to present the evidence and the facts and tell you the truth. And telling the truth sometimes means showing you things none of us want to see, some of us don't agree with, some of us don't like. But I believe that that's my job. We don't pick or choose the very best things, because I believe that you should have the truth. And I believe that it's not my job, nor is it right, to sanitize what happened in that school that day. Because if we don't tell you exactly what happened, then you don't know all the facts and you don't know what the truth is. My job here, our job, that I believe we have done, is to meet our burden to prove that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter. The burden is high. I told you that during jury selection, but we embrace it. And I believe that we have met that burden. It means that you've had to sit and listen to a lot of very emotional things, a lot of emotional people who sometimes aren't emotional, but we're emotional for this, because what happened on that day, every single person in that building had never experienced anything like that in their entire lives. And I hope to God they never do again. So you did see a lot of people, including law enforcement, become overwhelmed with the emotion of it all. That's not a show. That's just how that was. That's how it felt that day and every day after. So I want you to know that there was no picking and choosing the very best evidence to give you. There was no filtering things out that didn't help our case. I showed you everything. And I called witnesses to the stand to say things I knew you probably wouldn't like. But my job is to give you all the facts. But my job is also to prove beyond a reasonable doubt that Jennifer Crumbley is guilty. And I believe we've done that. The defense also has an important job: to advocate and argue for their client. And they decide how they want to do that. And of course, the judge plays an important role. Her job is to call balls and strikes when 2 sides disagree to make a ruling, and then to tell you what the law is. And she's going to do that as soon as we conclude here. And then there's your job. Your job is to decide what the truth is, what really happened, what are the facts, and then take those facts and find the truth and apply the law. The judge is going to give you instructions about the law, but I want you to go over what you now know, and I want you to think about it. And we're going to go over some of the evidence. But I also want to remind you that you're allowed to use your own observations and your own insight. And if there's something that you notice from the witness stand that I didn't say, you should rely on that. We can't possibly tell you every single little thing. And sometimes, ladies and gentlemen, the most important things are the things that don't get said. The most important things are the way the victim or the witness spoke, the way they answered a question. And I encourage you to rely on your own perceptions of that. I want to start out by talking to you about the elements of the crime. Involuntary manslaughter, she is charged with. This case is based on 2 theories. You're going to have all this in the jury room, but hopefully I'm going to explain it so well you will have no questions. These are dependent on 2 specific theories. One is the gross negligence in the performance of a lawful act, and that gross negligence caused death, and in doing so, that act that caused death, defendant acted in a grossly negligent manner. The second is the gross negligence in failing to perform a legal duty. One, I have to prove that she had a legal duty to the victims. 2, she knew of the facts that gave rise to the duty. 3, she willfully neglected or refused to perform that duty and her failure to perform it was grossly negligent. That the Defense Act made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's actions. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Muir, Hannah, and Justin. And as previously noted, there may be more than one cause of death. And defendant's acts or inactions need not be the sole cause of the harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting these four individuals was reasonably foreseeable. Now you look at that, all of that I have to prove. And it seems a lot. It seems like it's going to take a pretty strong case to prove that. It's going to take some pretty egregious facts, some unique, egregious, incomprehensible facts. And that's what we have here. Gross negligence means more than just careless. It means willful disregard of results to others that might follow from an act or failure. In order to find that the defendant was grossly negligent, you have to find the following three things. One, that she knew of the danger to another. She knew there was a situation that required her to take ordinary care to avoid injuring others. And second, that she could have avoided injuring another by using ordinary care. Third, that she failed to use ordinary care to prevent injury, and to a reasonable person, it would have been apparent that the result was likely to be serious injury. I told you I have two theories. We're prosecuting and charging based on two theories. They're both based on a legal duty. What's a legal duty? In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, to prevent that child from intentionally harming others, or prevent that child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. We talked about there's two alternate theories. Both of those theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven. And as long as you all agree that we've proved at least one of those theories beyond a reasonable doubt, you can find her guilty. I want to take you through the testimony. I'm not going to get into every single detail of each of these witnesses' testimony, because I know that you were listening and you were writing. You heard from Molly Garneau. Molly was a teacher in the school that day. She was in room 224. And she saw the firearm when it was raised, shoulder height, pointed directly at her. And what she noticed was there was no orange tip. You also heard her say that she locked eyes with Jennifer Crumbley's son as he was taking that stance. You heard her testify that she jumped to the right, thank God, just in time, because the shot in her shoulder that she sustained was only inches from her heart. The next witness you heard from was Christy Gibson Marshall, who's the assistant principal at Oxford High School. I don't think there's one of us that would disagree that Christy Gibson Marshall did the most dangerous thing she could do. And she did not follow the protocol. It's probably one of the most courageous things I've ever seen. She walked to the shooter. She saw a student on the floor. And then, when she finally came face to face with the person who had shot this student, she didn't move. She just stared at him. And he didn't shoot her. He testified that she knew him. She was his principal in middle school. And she just couldn't believe that he would do something like that because she knew him when she was in middle school, when he was in middle school. You saw the video of that day and what happened. And he just kept going. And even after he left and she had no idea where he was going, she didn't go hide anywhere. She didn't keep herself safe. She bent down to render aid and assistance to that student. And when she rolled him over, she realized it was Tate. We all know that she didn't and wasn't able to save Tate. We heard from Tammy Batt, who sold the Caltech and the Derringer to James in June of 2021. She also sold the 9mm 6-hour to James with the shooter present on November 26th, the day after Thanksgiving. She testified that James came in and pointed right at the SIG and said he's had his eye on it. She walked us through the process of purchasing a firearm. She talked about the trigger lock statement provided to James upon purchase and the cable lock provided with November 2021 on that gun purchase. Next, we heard from Special Agent Brett Brandon, who's sitting right here. You heard that when he was informed about the Oxford shooting, he left so quickly that when his partner came back, his chair was still spinning. And he raced and drove up there as fast as he possibly could because it was very much his own community. You heard he went right in and he found Lieutenant Willis and he said, do you know where the gun is and do you know where it came from and do you need help? And so he was responsible for finding out where that gun came from, which he did. He was also responsible, because he chose to be, and watched the surveillance of the video and helped prepare search warrants. And you heard him testify that as soon as he saw that surveillance video, the one thing that stuck with him is this is not an inexperienced shooter. This is a shooter that knows that is proficient with a firearm, knows what he's doing. Taking shots, a lot of people wouldn't. And what he did was start going to gun ranges and ask people to say, what he was thinking was, who taught that kid to shoot? He must have been to a range, and he was right. And that's how the investigation led to where Jennifer Crumbley's son learned how to handle a firearm that eventually resulted in killing 4 students in Oxford High School. You can go back to that. Special Agent Brand also testified that and showed the purchase and we showed you each one of those guns. He testified that there is a distinction between a Derringer, a Caltech, and then the 9mm. And what we really heard from him was that 9mm is a much more dangerous gun. It causes more damage to whatever it hits. The bullets are a larger caliber, and it's a very dangerous weapon. He showed you what comes with every gun purchase, which is the ATF pamphlet. He read to you about the warnings. There's a reason they put it in every single gun purchase. And its sole purpose is to protect kids from gun violence. He talked to you about what a trigger lock is and the trigger lock statement. He showed you the Instagram post that's unforgettable. We don't have to really argue about whose gun that was. Jennifer Crumbley told us whose gun that was. She told us when she posted on social media, it was his Christmas present, and she told you in this trial, that weapon is not just that weapon. It is the defendant's son's gun. It was gifted to him. And not only was it gifted to him, she bragged about it on social media before the shooting. Special Agent Brandon also introduced all of the surveillance and the videos of the shooting range. And you got to see with your very own eyes the training and the preparation that the shooter ultimately used to kill 4 of his classmates. We all saw that. We actually saw the last day he was practicing to kill 4 of his classmates. And there was only one person with him, ladies and gentlemen, and her name is Jennifer Crumbley. And I want you to remember that video. And I want you to remember the look on his face when that target comes back in and he looks at it and he's smiling. Special Agent Brandon also introduced the worksheet. You've seen the worksheet a lot. I bet you that worksheet's burned in your memory and I wouldn't even have to show it to you. But what Special Agent Brandon testified to and showed you is that that wasn't just a picture of any gun. It was a picture of his gun, which was the murder weapon. And he showed you the details, and we're going to talk about that later. And next we heard from Ed Robrowski. We now just call him Ed.
Where'd the captions go? Sorry.
He works for the Secret Service.
I don't know what I meant.
And he testified for an entire day. And he had a lot of information. But he also really couldn't help himself from becoming emotional. And I know that you're going to remember this, but what an extraordinary thing that's just not seen very often. He sat right there and he took you through every single action of the shooter and every single death from his memory. And he told you that he could do that because it's burned in his brain. These are seasoned law enforcement. This isn't an act. They hate showing emotion. He probably will never forgive me. Lieutenant Willis tells me all the time how much he really hates me.
I would object.
It's really lovely. It's my closing.
What a witness tells her all the time, that's not evidence.
I'll move on. Nobody likes doing that. Nobody likes doing that. But it tells you something about what it was like that day. And despite what anybody will tell you, it is about the shooting. There are 4 counts of involuntary manslaughter. It's very much about the shooting because the shooter learned how to shoot and was given the murder weapon by his parents. And this parent is sitting here today on trial. Okay. You'll be able to review the evidence. It was a lot. But he talked about what cell phone extractions are. And because of the cell phone extractions, we have a mountain of evidence that you saw. And yes, it's a lot of data. But you know what else it is? It's telling you exactly where the defendant was, who she was talking to, what she did, what she didn't do. And you can't hide from that. She tried. There's a lot of deleted messages, which are not coincidental. I don't think any of you believe that, but I'm going to tell you why they're not coincidental. He also talked to us about and showed you the messages between Jennifer Crumbley and her son. The messages between her son and his only friend. He introduced the voicemail that Jennifer Crumbley received the night before the shooting about looking up bullets. True. Pam Fine didn't tell her to call back. That's true. And she didn't call back because she didn't ask for a call back. We all know what she did do with that information. What she did do with that information is she texted her son, searching bullets. And we all know the phrases that we'll never forget. Did you show him your gun? This is the day before the shooting. Did you show him your gun? And the shooter responds, no, my God. LOL, I'm not mad. You just have to learn not to get caught. Kira Pennick testified that she knew Jennifer Crumbley. She testified about the amount of time that Jennifer Crumbley and James Crumbley spent at the barn. She testified about all the money they spent at the barn. Why is this important, ladies and gentlemen? It's not to show you that somebody's a bad person for liking horses or spending a lot of money on horses. It isn't. And it's not to say that somebody should spend every waking hour that they're not at work at home with their teenager. That's not the purpose of this evidence. The purpose of this evidence is to show you what Jennifer Crumbley cared about the most and what she was doing and where she was when her son learned to be a killer. Kira will tell you that she referred to her son as an oopsie baby and said he was weird. She rarely saw him. And that even after the one friend was taken away abruptly with no notice, they still went to the barn even at night and left him by himself, which is absolutely normal to leave teenagers at home by themselves, unless that teenager is showing signs of mental crisis and that teenager has lost the only person in the world that he has. And then she told us that when she got the worksheet texted to her that day by Jennifer Crumbley, she was very concerned. She was alarmed. And in fact, she said, bring him to the barn. And you also heard from saw from the text messages that Jennifer Crumbley said, he can't be alone. We know now. That decision, that statement, she knew he couldn't be alone. She didn't decide to stay home with her son. That wasn't an option. She'd have to take him to the barn, where she herself testified he didn't want to go. You heard from two people who were at that meeting that day, Sean Hawkins and Nikki Jack. I'm going to tell you right now that this is not an argument that the school did everything they should have done. I'm not going to say that to you. I'm not going to tell you that I like everything they testified to. I'm not going to tell you that I think it was okay they didn't look in the backpack. I don't think it was. But this is about Jennifer Crumbley's actions. And any attempt to make it about what these two individuals did or didn't do, like it or not, who did not have any of the information that was so jarring, it's about what she knew and what she didn't say. Sean Hopkins testified that he was concerned enough that he called Jennifer Crumbley. And her first response is, can you call his dad? Eventually, he emails her both copies of the worksheet, the original worksheet and the worksheet that was scribbled on. And she eventually comes to the school. But before she comes to the school, she texts her husband, emergency. Emergency. Along with, I'm very concerned. And James texts back, WTF. They're concerned. For the first time she testified ever, they're called to the school in the middle of the day, and they have that worksheet. Sean Hopkins is going to tell you that calling parents in the middle of the day and asking them to get a kid help is a pretty drastic action. And that he did in fact do that. and he gave them the list of places to call. He testified that when they entered the room, Jennifer Crumbley didn't greet her son. Jennifer Crumbley didn't hug her son. Jennifer Crumbley didn't engage with her son at all in the entire 11 minutes she was there. And we know she wasn't going to be in that school very long because she'd already told her boss she'll be back by 12 or 12:30. Doesn't leave a lot of time for the meeting at the school. It's a 20-minute drive. Sean Hopkins will tell you that what he felt mostly in that room for the shooter was compassion. He didn't want him to be alone, and he felt really bad. And he also knew mom and dad decided, no, we can't take, we have to go to work. They said that in front of their kid. He knows very well what they do. He knows his dad works for DoorDash. He knows his mom and her ability to work flexible hours. She worked at home. But they left. She did not hug him goodbye. She did not touch, or even acknowledge him. And we know now from her testimony, we know why. She was mad. She was mad at him. She did not think that he should have done that, and she thought this was a discipline thing, and she was very angry. We heard from Nick Ejek. He's the dean of students. He also testified and corroborated what Sean Hopkins told you, which is that the meeting was called. They were concerned about a mental health issue. They told mom and dad he needs services. Here's a list of the services, and Jennifer Crumbley seemed irritated by it. In fact, when she walks into the room, she doesn't sit next to her son. She goes back here and stands. And that meeting ended with her saying, "Are we done here?" They're consistent about that. Nick Ejek testified he didn't think there was any risk. I don't like what he said, and I knew he was going to say it. But it's not my job to put witnesses up here and only say things that I want them to say that helps my case. It's my job to present evidence that's the truth, because you have to know the truth. Sergeant Joseph Bryan is the first law enforcement that had contact with Jennifer Crumbley and her husband right after the shooting. And you saw the interview in the substation. And you saw the demeanor of the defendant. I want you to remember something. It wasn't even an hour. We were an hour after the shooting took place. She's on her cell phone. She's looking to see if it's on the news, she said. We also know that there were deleted messages. We don't know when she deleted them, but we know there were messages deleted after the time of the shooting, from the time that the phones were seized later that night. He asked about the gun, and you heard what she said, what they both said. It was hidden. It was hidden. She read the text message. Oh, he said he loved me. And she reads a text message. And then she said, I texted him, I love you back. It was 49 minutes later that she texted, I love you back. And it was after she already knew that he was the shooter. She doesn't say what the text after that is. She leaves that out. The text after that is, Ethan, don't do it. She doesn't say, well, we were at the school, but he was also caught searching bullets the night before. She doesn't say that, and I told him, don't worry about it, just don't get caught. She doesn't say that they had just purchased the weapon and it's not secure. What did they say? The very first time they are asked about what Jennifer Crumbley's asked, where was this gun? The very first time, what did she say? It was hidden. She does not say there was any locking mechanism at all, and neither does James. It was hidden. You're at the police station Your son's in the next room. You know the murder weapon was the weapon you just purchased for him. And when you're asked where it was, you say it was hidden. We also heard from Andy Smith, who was Jennifer's boss. He testified she could have absolutely gone home. She works from home, and there's flexibility, that they have kids that come to work, that the meeting that she wanted to get to was not in any way mandatory. And he testified about some very bizarre communications. He testified that as soon as she left, he got a text saying, my son, the bullets are gone, the gun is gone. He must be the shooter.
Podcastle.ai is
God.
an all-in-one online platform that helps
Well,
you make your
bah.
content like a pro. But you don't have to be one.
On
It says I'm
the meeting and what she knows, and the drawing, she thinks she's a failure of a parent. But
Jesus.
she sat right here and said, after all, she doesn't really think she was a failure as a parent. And that's after she knows everything that happened. Detective Adam Stoyak executed the search warrant at the defendant's home. I want to make it really clear. Jennifer Crumbley is not being charged with involuntary manslaughter because she has a dirty house. That's absurd. And you can see pictures so we can prove that she didn't have her house cleaned. I don't care if her house is clean or not, and I don't think you do either. Those pictures are shown to you because that is where the shooter lived and it's where she lived. And you saw his 2 bedrooms. There was barely a place for him to sleep. The testimony shows he had no person in his life after that friend left. He was not in a club. He was not in sports. He wasn't working. When I see those photos, what I think is, yeah, 2 rooms that were completely filthy, dusty, covered with clothes everywhere. But then I think, what? That is where he spent 99% of his time. It's where he ate Thanksgiving dinner, just days before the shooting. The search warrant photos were also shown to you so you could understand where these guns were stored. We have a pretty good idea that the Kel-Tec and the Derringer were in what's called a gun safe. The lock was 000, but we know that they were kept there. What do we know about the safe? The Jennifer Crumbley's son's gun. We know that there was a box on the bed and the ammunition next to it. This is the box. This is the box. I'm sorry, this is the thing. He's going to show you in a minute. This is the box of the Kel-Tec, which was found. This cable lock inside of it. Where she kept the other guns? No.
I'm sorry, is that the box for the cave? Is that the box for the safe?
This is the box.
That's the box.
It was in the kitchen. In a cupboard. In the
Oh,
cupboard.
the empty box was in the kitchen, right?
What is it?
Your Honor, this is my closing argument, and I would just like to finish, please.
Sure, can you tell us the number it is?
Yes.
While they do this, I gotta go pick up the kids and
This
then
is found
go
in the
out
kitchen.
there.
Inside.
Thanks so much for having me. Love you guys.
Love you, man.
Love you. Thank you.
This was found on the end of the defendant's bed. Special Agent Brandon showed you what it's like to open this up and close it. You hear that, Pat? It's not an easy thing. So what this is laid out on the defendant's bed, and the bullets are right next, the box of the ammunition is right next to it, empty. The story, one of these stories that is told by Jennifer Crumbley is he must have come in there when they were sleeping, because she was in that bed all night long, and they left after her. Except that the ammunition was in the box. Taking it out and leaving the box while your parents are sleeping doesn't make a lot of sense. And it doesn't make a lot of sense that this was taken out, the weapon was taken out of this case with no one hearing while they were sleeping. And you are allowed to use your own common sense. He also testified about the search warrant. He testified where this cable lock was found, and he testified where the case and the box was found. And he testified where the gun safe was found. It was not, unlike what Jennifer Crumbley alleged, stored separately from the ammunition. It was actually right next to the ammunition. In a gun safe, the other 2 guns with the combination 000. Sergeant Peschke arrives at the scene, doesn't know anything about the Crumbleys, doesn't know that they've already been to the substation, doesn't know that they were at the school that day. He's there and was ordered to be there to keep the house safe while they are waiting for the search warrant. And in doing so, he needs to keep the defendant out of the house. She goes in the back of the car, and you saw the video. She now tells Sergeant Peschke she actually never really looked closely at that worksheet. Now that she looks at it, it might be disturbing. We know that's not the truth. The question is why she lied. She says that the .45 caliber gun used at the school, and he asks if it was, and tells him no, it was a 9mm. The other is a 22, I think. She said that they had a fight the night before with her son over grades. And she says, so we told him, no gun rage, no phone. Those are his trigger points. Ladies and gentlemen, that phone was never taken away from her son. We know that. We know that because he had it the night before and he had it at the school. We know that because when Jennifer Crumbley was asked about it and asked, when did you take this phone away? We know that he made that video in that shed about the school shooting with his phone at 10 o'clock. The phone was never taken away. Why is he saying that? I don't know. Then she says, my biggest fear was that he turned the gun on himself. And when he asked her, do you ever keep guns in your car? Here's what she did. Here today. Next, we heard from Bob Patelis, who processed it. And you saw those pictures, and they were hard to see. He told you that there were 32 fired cartridge casings. He collected all that evidence, took all the photographs, and recovered the murder weapon. Lieutenant Marfan was also at the school that day, and he testified that he picked up the phone and saw the screen and saw that the last text was, Ethan, don't do it, from Mom. He executes search warrants for all of the devices and the home and sends a team, including Officer Peschke, to secure the house before the search warrant is executed, which is what they do. He testified that when he went into the house, he finally got there and he needed their phones. And he testified that Jennifer Crumbley said, no, I don't want to give you my phone. I'm not giving you my phone. She finally relents because her husband says they're going to get it either way. And then she doesn't want to give the passcode up. She doesn't want to give the phone up. But the most important thing that Lieutenant Marfan said is when he described how he had to identify the body of Hannah in Madison that day. Dave Hendrick is retired, but he's the former sergeant in charge of the fugitive apprehension team we call FAT. And his job, his only job, and he is doing that, is to find people who have felony warrants and haven't turned up. He has a lot of ways to figure that out. But he was asked to find Jennifer and James Crumbley to make sure they turn themselves in. But one of the other primary goals he has is that they turn themselves in safely. And she was given every opportunity to do that and she did not. I want to talk to you about something. The judge can instruct you that you can consider flight. It's not an element to the crime. I don't have to prove that they fled. The reason we introduce this evidence is she's going to instruct you that you can use that as a sign of consciousness of guilt. What do you do if you know you've done something wrong? You can use that to show consciousness of guilt. And we're going to get to it, but I believe we have shown that beyond a reasonable doubt. He's going to tell you that the defendant with her husband immediately began to avoid detection because they're pulling cash out. They're pulling cash out of their son's bank account. They're pulling cash out of their bank account. Where's their son during this time? He's at Children's Village being arraigned with his court-appointed lawyer, where they had the opportunity to go see him, where they had the opportunity to go to that arraignment, and they did not. Because they never even went, they fled their house and went to a hotel, and then they ended up at an extended stay, and that is where they ultimately left one of the Kias back into a parking space. He's going to tell you that he eventually did apprehend the defendant. You've heard a lot about that. And he's going to tell you that there were hundreds of law enforcement officials on the scene when she was apprehended. Luke Kirtley, I know you will not forget him, coincidentally knew a lot about cars and coincidentally pulled into that parking lot right about the time and coincidentally had just seen the wanted poster, he called it, with a description of the cars and a photo of the defendant. And coincidentally thought, maybe that's the car. And you watch the video where he goes around and he sees the license plate and he plays it cool and slowly walks into the building and then makes the call to 911. He describes to you how within minutes, police officers arrive and then swarms of law enforcement arrive, SWAT, the marshals, ATF, the sheriff's department, Detroit PD, all sorts of law enforcement show up immediately. He also testified that the unit where Jennifer Crumbley was actually found was very close to his, and it faced the parking lot, and the whole wall was windows, and it was on the first floor. And he's going to tell you that the whole parking lot was lit up with law enforcement, lights, sirens, all kinds of things. Next, we heard from Captain Corporal David Shaw, and he testified that once he got there, they took a 35-pound ram to breach the door, which was right outside the unit where the defendant was found. We heard from Brian Meloche. Also, didn't have a lot of things he has to say, but you deserve to know the truth. And the truth is, like it or not, this is who Jennifer Crumbley spent her time with. And she told him that morning, the gun's in my car. And I'm afraid my son's going to do something stupid. Before the shooting, the same day. You've also learned that although their Facebook thread in general was always deleted, after the shooting, it remained, except she deleted, not unsent. Rely on your own memory about what that testimony was. Those were not unsent messages, they were deleted. And you've heard Ed Growski tell you that. But these were the two that were deleted. On the run again, and were fucked. William Freer testified what was found in the building and the art studio where Jennifer Crumbley was found. You saw the photographs. You learned that there was a little over $6,000 in cash. You learned where the phones were found, and the cash, and the purse, in the plastic tub, in another plastic tub with a lid on it, feet away from where the mattress was, and there are other things where you learned all those phones were off. He also testified what else was found. Booze, orange juice, ice, and avocado, bananas, socks, blankets. And that is the room where Jennifer Crumbley was ultimately apprehended. You heard from Lieutenant Willis, who was the officer in charge. He told you what it was like in the school that day. He described the autopsy protocols that were done and how each of those kids died and where they were shot. He told you that both Justin Schilling and Madison Baldwin were shot in a contact wound, which means the gun was either very close or actually touching their head. He showed you the video of the shooting. And again, this is not to incite emotion. The video of the shooting shows Jennifer Crumbley's son taking a stance he clearly knew how to take and was trained to take. And you watched his demeanor and the calculated, cold way he proceeded through those hallways looking for people to shoot. You saw the surveillance of how he ultimately surrendered. Walked out after executing Justin Schilling, laid the gun on a waste paper basket, made it safe, took the magazine out, and surrendered. He showed you and introduced the bank records that show you what they were doing after charges were either very soon coming and after they were announced. And he showed you the in-car video of Jennifer Crumbley and her husband, who just a few hours after the shooting embraced, just whatever happens, I love you. Don't say anything to the police. One of the elements we have to prove is what a person using ordinary care would have known about whether or not there was a situation that they needed to exercise ordinary care. So the defendant's knowledge about her son matters, but it's two different stories. It's what she knew before the shooting, and it's what she said she knew after. Before the shooting, she tells Kira, my son's weird. She always refers to him as an oopsie baby. She tells Amanda Holland he's lonely. He's hearing things around the house sometimes. She says, I'm a failure as a parent. The message to her son's friend's mother, he's kind of depressed in April. She texts that. And then the messages from her son. The messages in March about these seeing things. Things are flying off the table. Now she wants to tell you that was just a joke, but I think you really need to consider whether a 15-year-old boy is going to text, could you at least answer me or reply to my text as a joke? And we know there were no replies. There were missed calls. He called her. There were no replies. And she told us why. He was just messing around. But after the shooting, in the in-car, we hear her say, he's never been in trouble. He's never done anything. He's never done anything wrong. He's a good kid. Also in the in-car, I never even thought like he would have any mental issues. Like he never exerted any type of anger. He's never exerted anything. He's just like one of those mellow, laid-back kids. In the substation, he's never done anything. He's never done anything bad. After the shooting to Brian Blow, she's never done anything wrong. Jennifer Crumbley has said a lot of things about that drawing in that meeting at school. She sent the drawing to James, as I said, Kira and Andrew, as I said before, with the call now, emergency. She told Kira he couldn't be left alone. She tells Andy she needs to get him counseling. And she tells Amanda that she the drawing was really scary. She agrees. After, this is what she says in the substation. Nobody didn't seem worried about it. And he said that my son's more than welcome to stay at the school or he could go home. And I really wish we had taken him home. In the in-car, she said, I didn't even look at that closely. Now that I do, when I was at the substation, I looked at it closely, which we know is not true. I looked at them closely and they're a little disturbing. Well, they're very disturbing because look what he just fucking did. And then to Milosh, she says, the school was very nonchalant, but the paper they showed me had all of the things scratched out. That's just not true. It's just not true. And you don't have to believe me because we have evidence it's not true. And you heard it. The statements about the gun are also numerous. He said, we've heard her testify the gun was in her car. We know that she's acknowledged that she drove to the gun range. There was no lock on the gun when she drove there. She returned with the gun. There was no lock on it, but she said James locked the gun when he got home. She didn't see him do it. She testifies at trial. James is responsible for the gun. In the substation, though, when asked where the gun was, hidden. In the in-car interview, James flew home and he's like, I had the gun hidden and I told him where I hid the bullets. He asked whether she kept the gun in her car. She shakes her head no. And she tells Milosh, after the next day, we had the string lock on it that came with in the case. Everything was secured, not loaded, bullets stored separately. Oh my God, oh my God, oh my God. That is not what she says in the substation. Jennifer Crumbley begins distancing herself from her own responsibility about the gun. You heard her testify that they wanted to get the gun. It was my son and my husband. My son did a lot of research on the gun. I guess when I was shopping. She doesn't say she didn't know. She doesn't say that she didn't approve. She said that it really interfered with going to get Christmas trees. That was what she was upset about. And she said it's James's responsibility. However, as I've shown over and over, at the substation and in the car, it's we. It's we take him to the range. It's our hobby. We go to the gun range. That's what we do. We just got him this gun. Sitting here today, it's all James' fault. No. And then, of course, the statement that we don't really have to question whose weapon it was. Jennifer Crumbley posts, Ethan and James Crumbley both got handguns this week, testing them out at the range. That's in June. The evidence really shows that the shooter owned 2 guns. But for sure, she acknowledges Mom and Sunday testing out his new Christmas present. You heard evidence that was presented to you about the journal that was found in the bathroom by the shooter's backpack, right? The bathroom that he exited and started shooting. I have zero help from my mental problems, and it's causing me to shoot up the fucking school. Next slide. First off, I got my gun. It's an SP-2022 Sig Sauer 9mm. The shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this. So yeah, I'm going to prison for the rest of my life, and many people have about 1 day to live. One of the things I want you to ask yourself when you go back in that room is why, after hearing that there's an active shooter situation and knowing that your son is involved, you are taking the time to delete text messages. and look at the messages that were deleted. We're on the run again. Helicopters, not sure where to, I'll message you, and we're fucked. Deletes, the gun is gone and so are the bullets. Oh my God, Andy, he's going to kill himself. He must be the shooter. Ethan did it. Those were deleted from her phone. She deletes all the things she says about the drawing to Kira, including making sure that she still was going to get her lesson that night. This is the timeline from when in March, which you've heard a lot of testimony starting in about March, was where we first had evidence that he was struggling, he was hallucinating, he was seeing things, and he wanted her to text back and she didn't. We know that he had some incident, and he said a mental breakdown in April. You saw text messages between James and Jennifer saying, did he say anything about last night? He woke up in our bed and didn't know where he was. We don't know what that was about, but we certainly know that that is not evidence of somebody who is completely fine and stable. In fact, lots of messages from Jennifer Crumbley saying, I'm worried. I'm worried he's going to do something stupid. In April, she texted her friend that she thinks he's depressed. The Caltech and the Derringer was purchased in June. They go to the shooting range in June. They go to the shooting range in August. They go to the shooting range in September. And then in November, they buy the Sig Sauer. And we see the shooting range that Jennifer Crumbley went to with her son testing out his new Christmas present. Here's what we learned Jennifer Crumbley did after the shooting. As soon as they took her phone, they bought burner phones in the pier at 8 o'clock the night of the shooting. They checked into a Holiday Inn Express that night in the pier. They then left and went to an extended stay in Auburn Hills, which Lieutenant Willis testified was almost across the street from the police department. Upon learning that charges were possibly coming, and the same day charges were announced, they leave that hotel and drive to Detroit. They withdrew $2,000 from a Flagstar Bank on December 2nd. They drive to Owasso, an hour away, she says, because we just didn't want anyone to recognize us, to buy replacement phones. She texts that she's on the run again. Helicopters are not sure where, I'll message you to, at 7:31 a.m. on December 2nd. She texts on December 2nd, we're fucked at 2 o'clock. On December 3rd at 4:59 a.m., she texts, I'd rather die than go to jail. Then she withdraws $4,000 from another Flagstar on December 3rd. She checks out of the extended stay on the 3rd and drives down and arrives at Bellevue at 10:58 on December 3rd. You heard what happened. You heard her testimony. The facts do not support the story that Jennifer Crumbley told you. They just don't. There is no possible way, and Luke told you that, and so did Corporal Shaw, that you could be in that building with that many law enforcement and not know that somebody was there. And we don't even have to use that place testimony, ladies and gentlemen, because she texted herself, I think we're caught, we're laying low. She texts that, we find out, and this is evidence we got this morning. She texts that after she's already said she took 4 Xanax and went to sleep. Now you saw that video. You saw that video. All those people for over 2 hours, they're sleeping, and even when they come into the room, they still don't even act like they get up. It's just not true. And we know it's not true because they'd already taken steps. She had hidden the phones, powered them down, separate from all the other things they had with the cash. Jennifer Crumbley wants you to believe that if only the school had done something different, we wouldn't be here. If only the school. But let's talk about what she knew that no school employee knew. She knew about the text messages in March that he was about a demon, throwing bowls, clothes flying off the shelf. She knew about the March 18th incident of waking up in his parents' bedroom and like he had way too much to drink and asking why he was in their room. She knew he had previously asked for help and to go to the doctor, and she laughed at him. She knew there were multiple guns in the home. She knew her son had been gifted a gun just a few days before the shooting. She had posted it on Instagram. But apparently, it's absolutely fine for all your Instagram friends to know that you got him a Christmas present with a 9mm handgun, but it's not okay or relevant to the people sitting in that room with that drum. She knew that that gun looked identical to the one in the drawing. She knew that the gun was accessible to him. She knew it wasn't stored properly. She knew that he was proficient with the gun. She knew he had access to ammunition. And she knew that her son was upset the night before. Now, that says he was locked out. She told Amanda Holland he got locked out. She doesn't acknowledge that. She does acknowledge that he did leave the house that night because he was upset. And we all know what he did. We all know what he did. He went to that shed and recorded that video.
I checked that video did not come into evidence.
Okay, it is in evidence.
Okay.
You're right.
That's true. Let's go back to the elements. Ordinary care. What ordinary care, the smallest, tragically smallest thing she could have done to prevent this. She could have stopped at home on the way back from the meeting. She goes right by her home to see where the gun was. She could have stopped on the way back to work. She could have searched the backpack. She could have asked her son where the gun was. She could have locked the ammunition. She could have locked the gun. She could have taken him home. She could have taken him to work. He could have gone with Dad. He was DoorDashing. She could have told the school that they just gifted him a gun. She could have embraced her son. She could have said, can we talk to him for a minute alone? She could have looked at him and said, I care about you, I love you. She could have at least acknowledged he was in the room. She could have told the school about her son being in crisis previously and asking for help. Ordinary care would have included all of those things. And the tragic part of it is none of it was hard. None of it. The smallest thing, just the smallest thing, could have saved Hannah and Tate and Justin and Madison. The smallest of things. I have to prove that there's reasonable foreseeability. And that worksheet right there that Jennifer Crumbley saw just hours before the shooting is reasonable foreseeability. And we're going to show you in the next slide. That's the picture of the gun. It's not just any gun, ladies and gentlemen. It's the gun that they just gave him. Blood everywhere. That's what he wrote with ammunition. I didn't show you the picture with the blood because I don't think you need to see it again. But we know what happened in that school and in that hallway. Here's a picture with 2 bullet holes and blood coming out of the figure's head. And look at that. That is where those shots went. Those are from the shooter's gun. The thoughts won't stop. Help me. These are all of the things that were texted to Jennifer Crumbley. This was in March. But he's writing it on a piece of paper and he's showing it to her. That is foreseeability. He's telling in that drawing, this is the gun that was purchased for me. Help me. Blood everywhere. The world is dead. I know you won't ever forget the video, but if you look at the defendant's son and see that there was no emotion, none. He was only concerned in a very calm manner for finding as many people as he could to kill, and he did. My life is useless. These statements from the defendant's son are just heartbreaking. I actually asked my dad to take me to the doctor yesterday, but he said, just give me some pills and told me to suck it up. Like, it's at the point that I'm asking to go to the doctor. My mom laughed when I told her, but I am having bad insomnia right now. I need help. I was thinking I could call 911 so I could go to the hospital, but then my parents would be really pissed. Like, I am mentally and physically dying. Let's talk about the cable lock. Jennifer Crumbley says that the weapon was used, but it was locked in a cable lock that came with the case. This cable lock that came is the cable lock that came in that case with the stick. It's never been opened and it's never been used. This is the last picture that we have of that gun until we see it murder 4 kids on November 30th. And the person holding it is Jennifer Crumbley. She's the last person that we see with that gun. She's the person that said it was in her car. Then she said it was in her house. It was her husband's responsibility. It wasn't hers. That's what she told you. She knew he was distraught the night before. He texted her, I love you. She told you that's never happened before. She did think it was abnormal or odd. She knew he was looking up bullets in the school. She knew he was watching violent videos. She knew he was proficient with guns. She knew he was previously in crisis. She knew his only friend that he talked to was just Vaughn. She knew all those things. And then her own statements, ladies and gentlemen, when she took the stand. She testified that when she's looking back, she still wouldn't do one thing different. Not one. Not any of those tragically small things. Even now, she told you she wouldn't do anything different. And then she also told you that we took his gun away. You heard her say it. And then she said she doesn't think of herself a victim, but she has lost everything. You're going to hear the instructions from the judge, and you're going to take the facts and the witnesses and the evidence and use what you promised to use, which is impartial, honest assessment, and find what you believe the facts are in this case. The flight, evidence of the flight and what they did after is not an element I have to prove. But what does it show? It shows the minute this shooting became public and ended up in the paper, in the media, Jennifer Crumbley started telling the story, and then she ran. And she didn't run just because she was selfish, ladies and gentlemen. She ran, and she started deleting text messages, and she started telling a different story, because she knew she had done something wrong. That's the only reason you start deleting text messages. It's the only reason that you start saying something that isn't true. It just isn't true. Jennifer Crumbley drove to Detroit with a bunch of cash and 6 cell phones powered off. You can consider that as consciousness of guilt. Everything she did from the time she found out that there was an active shooter and had the 10-minute call with her husband. They both say they went right. He called 911 right away. He did not. He talked to his wife for 10 minutes, over 10 minutes on the phone before he called 911. But the facts changed because it was the immediate attempt to misrepresent what actually happened. Why? Why is a mother whose son just killed 4 people thinking about deleting her text messages? Why is she saying things that are not true about her son? Why does she care about her job? Why does she care about her horse lesson? Why does she care about any of these things? Because she knew she did something wrong. And she's deleting all of those things because she wants you to believe that she's somebody she's not. And you know what she's not? She is not somebody that used ordinary care to prevent what was foreseeable, reasonably foreseeable, that could have happened. Injury or death. And it did. It did. Those words on that paper helped me. She walked out of that school within 11 minutes, didn't so much even address her son. She did not give him the help that he wanted. And you can argue about the months before and the weeks before, but if you just even look at what happened that day, she walked out of that school and she knew something bad might happen. What does she do when she gets back to work? She all of a sudden texts her son, "Are you okay? You know you can talk to us." These are the actions of somebody who was worried. She was worried and she was concerned and she was panicked until after. And then it's a different story. Why? Because she knew she had done something wrong. She walked out of that school when just the smallest of things could have saved, could have helped Hannah and Tate and Madison and Justin. Just the smallest of things. And not only did she not do it, she doesn't even regret it. We have proven beyond a reasonable doubt that she is guilty of 4 counts of involuntary manslaughter. It's a rare case. It takes some really egregious facts. It takes the unthinkable. And she has done the unthinkable. And because of that, 4 kids have died. So I'm asking you to go back when you hear the law, review the evidence, and find her guilty, because we have proven her. Thank you.
Thank you.
Your Honor, I'm ready to go, and I will, but I'm going to need to use the bathroom halfway through if I start now. Can I like a 3-minute back room break literally?
Do you guys want to break? Okay. So we're going to take about a 5-minute break, and then we'll take the defense counsel closing. Okay.
All right, for the jury.
All right. So what'd y'all think of that? I want to do another poll, but I think we should wait until
No one can see it.
I don't even see you. Oh, add yourself to the screen.
I thought I did.
Oh. Let's see. Hold on. Did you? Oh, I don't know. Stevie, can you get Allie up? Oh, there she is.
Oh, there I am.
Thank God Stevie's back here messing with things, trying to get stuff done. Yeah, I don't know what happened with the captions. They were up during the actual trial. At closings, they were down. Yeah, the case that never sleeps. I can't even take a day off to stream a trial without Delphi's head exploding. Apparently, Brad Rosie has now filed a motion for continuance, Allison, which I don't know if you are aware of what's going on. Are you aware that Fran
I'm not.
Gulls, she set the hearing for contempt hearing for February 12th without any regard to it in her courtroom in Allen County, with no regard to the pending motion to DQ, which means that she can't rule on shit. I
Are
don't know.
you sure? I mean, that makes sense, but do we know procedurally if that's the rule there?
Yeah, that's the rule there. So Brad filed a 4-page motion to continue where he lays out a lot. Interestingly, it's just Brad. It's not Brad and Andy. Like Brad didn't sign on behalf of Andrew. It's not both of them. Brad just prepared this motion
Wait,
for
but
himself.
Andy's the one who really didn't. There's nothing alleged against him, right?
No, Brad's the one that really. Andy's the one whose office like the leak came
Oh,
out
so
allegedly.
Brad filed. Okay.
Yeah. So which frankly I was thrilled because I was furious when I saw that she said it the day after the Super Bowl, because I'm in Tennessee with my Super Bowl buddies for our annual thing. And I'm like, oh, great. Now I've got to figure out how to fly from Tennessee
All right, but
to
let me ask
Indiana.
you this.
Yeah.
Did he say that it's because she hasn't ruled on the pending disqualification motion yet?
Amongst many other things.
Okay.
He cites law. It's pretty well written. If we had more than 5 minutes, I'd throw it up because I have it.
Well,
But
we'll do it later. We're on
yeah, y'all know
Dr.
if you
Crumbley.
follow our Delphi coverage that we'll 100% be doing that tonight. Like, it's just case never sleeps, never sleeps. There's not a day that goes. It's incredible, and it's like, and none of it's like insignificant. Everything that happens day after day is
So the
always
defense is people are asking, the defense is about to do their closing. They're going to she's using the bathroom. She's going to the bathroom.
She had to go potty break.
Yeah.
She had to make
Staying on topic
we'll,
because we don't have time to get off topic.
Yeah.
I mean, there were
look, the ad. I don't know why I'm getting ads. I'm premium law and crime, but I am streaming it through. Somebody said that those might be our ads, like my ad revenue ads coming through. Could that be true? I thought that you guys only got those like when you're watching the stream. Like, why would I be getting it if I'm just streaming it from? I don't know. It's one of the many technical things.
Well, there were many things that happened right there that I didn't know. And some that I think I missed. So I'm hoping they kind of redo it. But the message like, oh shit, the gun's gone and the bullets are gone. And was that the 10-minute delay with calling 911, or what was the 10-minute delay?
Well, I mean, she wasn't the one to call 911. I mean,
but they were
she
just
realizes that's when she gets home and realizes that he's got the gun. I mean, she's I agree with you. Allie was over here whispering in my ear through like half the closing. I'm like, go down and get on. What are you doing? I agree that was like an hour and change closing, and it could have been 3 minutes.
Literally, they need to say nothing more.
Throw that
nothing
picture
more other than the piece of paper and definitely the the text messages, and it's just.
I don't even think she needed. I think she needed that timeline. I think she needed the timeline of his mental issues, his mental health issues. That she I don't know if you saw it, but she put together a nice timeline, laying out the different things that have been going on in the months preceding, and the math test. Those two things. I'm sorry, you're going down.
Yeah. By
Like,
focusing on the things that they did about her spending too much time messaging people on this app and, going to
shit
horses,
doesn't matter. It doesn't matter.
to me, it undermines the entire thing because it puts the jurors, as parents on the defensive. Like, okay, so
Right, I agree.
I
I think it muddied the waters completely unnecessarily. She didn't have to have like, none of that shit matters. Like,
yeah.
none of like, you're right, it's gonna have that impact that every parent, it's like, well, like, now I can't be mad at my kid if he like, now I can't be texting, like, you know what I mean? Because like, parents will get defensive. Any parent that, happens to do the same shit, which a majority of us do. Like, taking out ignoring your child's
Right.
mental health issues, but, like, just
Spending too
operating
much time on
on a
our
daily
phones
basis.
and,
Right, I'm looking at
"Oh, she had a very active social life, and, where
and
was
she
her
likes
kid while she."
horses and, all
My
the
kid doesn't like rock concerts, but I go to a lot of them. Well,
true.
actually, they do, but I still go without them a lot of times.
Yeah, I agree, I agree. I agree
I just
completely.
think focusing on, like, her conduct after she got the letter and all of that would have been a much cleaner
Alright, we're
trial.
28 away from 12K. Can we make 12K today? Like, seriously?
What do you
Like,
mean?
we're 28 subs away from 12,000 subs. I mean, let's go.
Let's go.
I mean, we
28.
give pretty good content. Like, I think
All
we
310 of
deserve
you
it.
out there can't have already subscribed.
I
Just
know if you all
minimize your
haven't subbed
screen
yet, we'd really appreciate if you did.
and
We try to
subscribe.
come with just facts on every stream. We have really good content. We're both lawyers. We both
I think
understand
that she does
justice.
need to address on closing the
Thank
consciousness of
you.
guilt
Thank you,
stuff,
Mr. Crazy Swifty.
because from my perspective, there could be this is not like a consciousness of guilt case like you're dealing with a regular crime. They could
Right.
have been feeling guilt, you know, or something that it isn't legal. They'd have to legally recognize what their duty and the standard
Right,
was in this type of
exactly, which
case.
they wouldn't have known. Like, that
Right.
whole consciousness of guilt thing was stupid. Like,
But
it didn't.
I do think that the lawyer needs to address it in her closing, because it might be leaving the jurors, relying on that a little bit more heavily.
Right. I think it's placing an improper suggestion in the minds of the jurors that does matter, and it doesn't matter. I mean,
And I think
from
that
so how are you, Miss Powerhouse Defense Attorney? What's your closing? How are you getting like what is your strategy here? Because the situation exists with the math test in there the morning of 9 a.m. He's drawing that up. If she's placed in her hands, an hour and a half later, she leaves her kid at school. What is your approach? What is your approach?
well, I'd have to say my first approach would not have been to put her on the stand to say she wouldn't have done anything different. I mean, that's just
Ugh,
absurd.
God,
Why even ask the question if that's the answer? Wha
ugh,
are you kidding me? In
that's
retrospect, you would do nothing different?
right. I obviously would have taken my kid immediately out.
I mean,
Brought
just don't
him.
even ask the question if that's the like, I don't how could that have been a question asked that they didn't discuss? But in any event, I mean, like I said,
I
I
think that particular statement
came from her
is
lawyer.
what's gonna do her in. Like that,
I mean,
like what I must have missed that. Don Burke, 10 memberships. We love you, Don, so
we're
much.
definitely still live on that screen, right? Because it's been, I feel like,
Yeah,
5
no,
minutes.
we're
Okay.
definitely live on it. We're definitely live on it.
Um, you know, it's it's so it's so difficult because she doesn't even have that to work with, because,
Ugh,
she's just gonna have to focus on, you know, the like I said, I do think she needs to clear up. I'm surprised that wasn't an issue taken up with the judge beforehand, that they should not be able to argue. I don't think that they should have been allowed to argue consciousness of, um, I don't know,
guilt.
maybe it'll be in a jury instruction or something, because
I just think it's irrelevant to this fact. Like, and for exactly the reason you said, it looks like I see some rustling around in here, but it's exactly what you said. They don't understand. They don't understand, number one, what they were charged with, and number two, why they'd be fucked criminally. You know what I mean? Like,
Right.
it doesn't add up. Like I was trying to say, like, when your world collapses in a matter of 2 hours, like everything that is your
Yeah,
life
but
is
I
now
would have been
over. You need
interested to know
time
what the time.
to you need time to be able to gather your thoughts, you know? It's like I was telling, like, her lawyer was communicating with the state, like, "I'm turning them in." Like, they weren't on the lam.
That part's stupid. I'm wanting to get away from paparazzi and clear your mind and turn off your phones, like, that's not
No,
consciousness skills.
paparazzi, like, trying to, like, get their finances in order, everything was over. Like,
Alright,
they
put it
like,
up.
are trying to raise bond amount.
They're starting.
I know, I didn't turn it down. See how she yells at me? She's so sweet.
It's not on the screen.
What do you mean? Oh, Stevie, get it up. This is probably gonna screw something
Jennifer
up.
Crumbley, people versus Jennifer Crumbley, case number 22279-980
Stevie, like, you got to change that background. That background is what's blocking it out. There we go.
I did that. I mean, you can't
No,
click
no,
the
let
button.
Stevie do it because we got to block that law of crime.
Oh.
There we go. I wish we could make us a little smaller. Little bit smaller.
No, we're good there.
All day, Dom's mom. The show. Happy wife, happy life. Truth.
12 hours. So, I we're going to sit in another jury room. If we come back Monday, I'm still bringing the 5 sequestered jurors back. Right?
I think that's smart.
She's put on lipstick.
I know it's all for them, but if one of them goes down.
Okay, yeah, no, I'm concerned about.
Wait, what is she suggesting?
That's what we're gonna do. Right?
They're talking about
So,
alternate.
when they go out to the jury room before I pick the 5, I'm gonna have them bring their personal things out here because then they'll be separated. Right? Okay. All right, so I'm gonna bring that.
Yes.
It sounds choppy to me.
It didn't sound choppy to me.
Okay.
It might be because you're in the basement, right? Yeah, they should have mic'd the judge for sure. I don't know why they didn't mic her. She's very soft-spoken on top of her not being mic'd. So, Allie, one of the issues that the judge felt was an issue that I was trying to explain to our fine subscribers and viewers here, that there's nothing worse than a 3 to 4 p.m. Deliberation starting on a Friday. The judge asked if she thought she should just kick it to Monday, and they both said they wanted to start today. I don't know.
If they were going to do that, they should have kicked the closings.
All right, you need to see it.
Yeah, they should have kicked the closings. Charlotte thinks a little choppy for her too.
Yeah.
Yes, thank you. As the prosecutor finished, she said, "This is shocking, unthinkable." I believe there were other words used throughout trial. Unbelievable. Obviously, unbelievable, unthinkable, unfathomable. And the reason that's the case is because it was unforeseeable. No one expected this. No one could have expected this, including Mrs. Crumbley. Now, the first thing I want to do very quickly is talk to you about the burden of proof. In the state of Michigan, there are different burden of proofs depending on what kind of a case it is. When people sue for money and say, "I've been injured," or "I was failed by the school even," there will be civil lawsuits, and the burden of proof is a preponderance of evidence. That means it's about a 50-50 standard. And if you have 50% of the evidence, that's the burden of proof for civil. When the state thinks it's important to take away a person's children, the burden goes up, and the burden has to prove more evidence, and that specifically is clear and convincing evidence that it's correct for the state to be taking away a person's children. Now, the highest burden in this country is in a criminal case, and that is beyond a reasonable doubt. And the reason I'm telling you about the differences in the burdens is because in a criminal case, if you have just one reasonable doubt about the case, you must vote not guilty. And so this is my poster just showing beyond a reasonable doubt is guilty, but there's many, many other options. If you think it's likely, probable, possible, not likely, those are all not guilties.
Wow.
You have to be sure beyond a reasonable doubt. And later, as I go through my closing,
That's one
I am
hell of a
going to
chart,
tell
people.
you the reasonable doubts that the defense believes exist in this case for you to look at. The other thing I have to ask you to keep in mind is that in the jury instructions, and I think you've been told this throughout trial, the defense does not have to prove or do anything. Like Judge Matthews said, we could sit at the table and play chess the whole time, call no witnesses, cross-examine no witnesses, provide no evidence, because we have no burden to prove a thing. However, in this case, you obviously saw the defense present Mrs. Crumbley, who took the stand, so that she could give you some context beyond parts of the evidence that were confusing when the prosecutor was introducing in bits and pieces. And the problem in this case is that we can all agree everything can be seen different in two ways. First of all, when you look back in hindsight with 20/20 vision, when you look back in hindsight, it is easy to say, this could have been different, that could have been different, this would have changed. And the other circumstance, the second one that makes a huge difference, is when you get full context around the evidence that is being used. And in this case, the prosecutor has cherry-picked little bits of evidence out of mountains of evidence, put it in front of you with no context to explain what they're doing. And when you get cherry-picked bits of evidence, it's easy to reach wrong conclusions. Now, during jury selection, it felt like the prosecutor was asking you questions and giving more of a campaign speech than a jury selection proceeding. And I would suggest to you that at the end of the day, the only judge, although Ms. McDonald mentioned she's been a judge and was a judge several times during her jury selection, the only judge in this courtroom that matters is Judge Matthews. And the only other people whose judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Ms. McDonald's doesn't matter. The opinions of everyone in this audience doesn't matter. The media and all of the people who think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown. So during this case, it's obvious real life is messy and complicated. And during this trial, I will openly admit that I'm a lawyer who messes up. I get thrown off when I'm surprised by something. I feel like I get overwhelmed when information is coming at me quickly. I say I'm sorry a lot. Evidently, there's a TikTok channel of me saying I'm sorry through this whole trial. And all I'm saying is that I'm human. I'm a human being. And so is Mrs. Crumbley. And that's what this case is about. She's not a perfect person or a perfect parent. I'm certainly not a perfect person or a perfect parent. And I'm certainly, beyond a reasonable doubt, bad with technology, which is why you're not going to see me touch that laptop.
She's my girl. My tech sister.
So during this trial, I have stood before you and shown you all my flaws, and I embrace them, and they are a part of what makes me human. And so has Jennifer Crumbley. She got on the stand and talked about every nook and cranny of her life, things no one else in the world knew, in her family, among her friends. And she wanted you to see the whole truth, the entire truth, and nothing but the truth on everything, where she had to show you that she has made immoral decisions to have an affair, that she has made decisions you might not make to have another person involved in the affair. Now, we didn't get too far into the details, but it was enough for you to know that Mrs. Crumbley got up there and literally stripped off her armor, let the prosecution cross-examine her, and show you what happened in her messy life. And I say that with all kindness because I'm a mess too. I saw a meme about a week ago that said, I'm trying to be a mom, trying to get exercised, stay hydrated, get enough sleep, text everyone back, and not lose my shit. And I've got to be honest, as a mom, a working mom, on most days, I'm lucky if I'm fit for human contact. I'm lucky if I've taken a true shower and didn't just grab a handful of wipes and scrub off the best I can on my way running out the door, putting on my makeup as I drive to court in my car.
Allison, is this
because
you?
my life is not perfect and no
Did
one
you
is.
somehow morph into court?
And during this trial, you may have concluded that you don't like me, that you hate me. That's fine. I am just asking that your opinions about me as a person, and if you're one of the people who plans to make a TikTok about me, that you won't hold those opinions against Jennifer Crumbley and will judge Jennifer Crumbley's case based on the evidence about her and her family. And if you hate her or don't like her or agree with things she's done, that's okay too. You don't have to like her. You are not expected to go hang out with her when this is all over. After trial, you don't have to decide if you want to go to her house. You don't have to have Thanksgiving with her. But when you're looking at the evidence in this case, it's important to set aside your opinions of her or take your opinions of me and supplant them on Mrs. Crumbley. Now, when I took on this case pretty early on, I realized I am Jennifer Crumbley and I could be here accused and sitting in her spot very easily. Now, in my house, we don't have guns. I don't have guns, but I do have children. And actually, I have an oopsie baby, my fourth one. I did not want 4 in 4 years, but that's what I was blessed with. I say I'm abundantly blessed. And I have kids that seem to have no issues. And at the end of the day, they're good kids. They go to school. We have no discipline problems. We have arguments here and there, just like every family does. I have a son that wants to hang out with me very rarely, but I have no belief that any of my 4 children would ever harm anyone else. And while I don't have a gun, I have a large butcher block on my counter with big knives that I use when I cook, and I enjoy cooking. And at the end of the day, my kids could just as easily grab a knife without me knowing it and without me having it on my radar and walk out the door of my house and go play with their kids, the other kids on my block. Granted, they live farther down my block because I'm in the middle of nowhere. And my son could kill somebody with my butcher block knife that I would have never expected to happen. And if you saw the text messages that my husband and I exchanged on a daily basis throughout this past year and even years before, it would be so easy for me to be in her seat. With my kids, I don't monitor assignments. I don't look at their phones. I have no reason to. My son plays a lot of video games. My son's online talking to a bunch of people as he's playing a lot of video games. Even though he has a cell phone, I don't go through it and look at his messages every day. And as he gets older, I do know he's interested in girls. If he starts receiving nude pictures of a girl on the cell phone that I owned but let him use and gave him for his birthday when he turned 11, should I be held accountable for receiving child pornography if a girl sexts him over some inappropriate pictures? If my son decides he's going to send some pictures back and takes a nude picture of his bits and pieces, that's a 20-year felony. Am I then responsible because he sent a picture of his penis over to some girl? So not only taking the picture, a 20-year felony, but then we've got a 7-year felony for sending it over. Can every parent really be responsible for everything their children do? Especially when it's not foreseeable. And this clearly was not foreseeable to Mrs. Crumbley, because there's no one in the world, including Mrs. Crumbley, who would let a school shooting happen and let what happened on November 30th take place. Not only ruining the lives of so many families and victims and taking the lives of 4 young people, but also ruining her own son's life and ripping his life right from her as well. She would be the first person on the planet who would have never let that happen in a million years. So this case is a very dangerous one for parents out there. It just is. And it is one of the first of its kind.
She's been doing it.
Luckily, however, this is a case where the prosecution cannot meet its burden of proof. And thankfully, it's a case where truly Mrs. Crumbley does have a defense. And this isn't just one of those stretched cases where a parent is liable for what their child has done. Now, the judge is going to tell you that you have to, if you find reasonable doubt in this case, you must find the defendant not guilty. And the law says you must have a reasonable doubt, not 3 reasonable doubts, not 5 reasonable doubts, not 10. If you have a single reasonable doubt, you must vote not guilty for Mrs. Crumbley. And when it comes to reasonable doubt, each of you can have a separate reason to have doubt in this case. You don't have to agree on what the doubt is. And for that reason, what I am going to do is show you all of the doubts that the defense believes exist in this matter. Some of them may speak to one juror, some of them may speak to another, but at the end of the day, if you have just one, your vote in this case must be not guilty. So the first place the defense finds reasonable doubt is in the fact that the prosecution is so desperate to prosecute this case that they admitted a mountain of evidence that, quite frankly, was unnecessary. Now, they say to you, they needed to show you, they needed to prove the manner of death. We stipulated that 4 people died. We stipulated that it was the most horrific set of facts you could ever imagine. We stipulated that what happened to Molly Darnell and Christy Gibson Marshall was horrible. But this prosecution, putting that evidence on, was designed to inflame you and make you emotional, strike your sympathy, and get you to hate Mrs. Crumbley, which, by the way, has been very effective for most of the media, most of the public, and for anyone who has seen information put out by this prosecutor in this case.
I don't know what she's doing.
A second reasonable doubt comes from the fact that we know, and the evidence in this case showed, context is key. And that was clear when Detective Wygrowski took the stand and said, you get better decisions when you have more evidence, and testified that in a former hearing, he messed up because he didn't have the video from before the one he saw. So he believed the parents arrived at the school together, and subsequently, when given more context, showing more video from further beforehand, he could see they actually arrived in different cars, met, and walked in the building together. And at the end of the day, the more context you have, the more accurate you can be. When Brian Milosh testified, another example came about where the prosecution had him testify that Mrs. Crumbley said to delete his messages, clear your cache. And I'm so thankful that the rest of the world sent me emails that I don't know how to pronounce cache, because now I do. And when Brian ended up seeing the messages before clear your cache and after clear your cache, he realized, oh, she wasn't asking me to delete messages. She wanted me to refresh my web browser to see if the Facebook had actually deactivated. And so that was proof again that when you have more context, you're more accurate. And the problem the prosecutor has in this case is they have very little context for the very little evidence they've submitted. There's also no context around some of this little bits and pieces of useless evidence, like Jennifer Crumbley saying that her son was an oopsie baby. I call my son that, so what? Does that mean I hate my son? Does that mean I would be okay if he went and killed a bunch of people and or if he committed suicide? No. Calling your child an oopsie baby was designed to try to make her look bad with no context. Having Amanda Holland come in, a coworker who's not a friend to Jennifer Crumbley and has been interviewed by law enforcement to tell you her advice on she should go have a mother-son day with her teenager, so irrelevant when she's faced with raising toddlers every day. When I heard her advice, I thought, yeah, right. I have 3 teenagers. I almost have a 4th. And personally, not only would they rather do anything else than spend a day with me, I'd rather do anything else. And we do spend time together, but that's not their first priority when they get to pick what they're going to be doing. It does not mean she loved her son any less if she ever told a witness, my son is weird. And part of what made me realize I could be in Mrs. Crumbley's shoes is I've sent texts to my husband saying, our daughter is a psycho today. On the way to school last week, she's crying. She doesn't have people to sit with at lunch. I texted him, she's a nutcase. I don't know what to do. I don't know how to handle this. I don't have time for this. My other daughter is complaining about her lights flickering in her room. I texted my husband, this sounds like a case. The start of a case. My husband works for my office. He's actually my office manager, so he knows about the case. He went in her room and figured out in 5 minutes, it's because when she flips her blow dryer on, one of our plugs makes the lights flicker. So this ghost that you would read about in my text messages, which by the way, I did not respond to, despite the fact that it's on our 6-person group chat, would be taken out of context and make me look like I don't really care that my daughter is crazy. I also got text one day, we have no food in our house. I am absolutely starving. You are the worst mother ever. And you know what I did? I ignored it. She was mad we didn't have the right.
Oh my
Stop
God.
telling me that you need to stay with
Oh,
your
I
car
hate
insurance
it.
company longer.
I don't know what you did.
That doesn't work.
It's not me.
She can eat. And I knew she's not going to starve to death, but taken out of context,
Oh,
it makes me look like a neglectful mother. But if you know all the circumstances and you know the relationship I have with my daughter, I knew it was an overdramatic, stupid point. So when you see messages from Mrs. Crumbley's son saying, will you at least call back? Those are so out of context. And when I'm driving home from court every day, I'm getting messages, will you at least call back? And I don't, because I know what they want is for me to run through the McDonald's drive-through and bring everyone a Coke. I do stop and get myself a Coke, but I am not getting a round of drinks every day for everyone. And I've realized it's easier to not answer the phone. So you can find reasonable doubt from the text that the defense did actually provide. And when Mrs. Crumbley got on the stand and explained to you her understanding of ghosts and dishes flying and laundry flying, that is evidence. And that is something that can create reasonable doubt to hear what was really going on. Even if you believe the prosecution's dates about what was going on, it's not strong evidence. It's very misleading. And I'm going to go through what it does show. There are 3 sets of dates involving Mrs. Crumbley, all for March of 2021. The first time is March 8th and 9th. They introduced exhibits, including text messages on the 8th, where Mrs. Crumbley starts off asking, is he home yet? Is he home yet? I don't want him to do anything stupid. I'm sure you all remember those. Then they introduced evidence on March 9th that she went to the barn that day with her husband on the 9th. Then they introduced evidence, and I will give them credit. They put together quite a case, although it's really not important, that there was a picture of the horse taken at the barn that day, that the data supports there was a picture of the horse taken at the barn that day, and that there was GPS tracking information supporting that she was at the barn that day. Okay, fine. So on March 8th and 9th, there's concern that the shooter, Mrs. Crumbley's son, is making weird comments, and on the 9th, she goes to the barn and she takes some horse pictures. That's all that shows. Pretty minimal. Next, they went to March 16th through 19th, which was broken up into a million exhibits that, quite frankly, were out of order, threw me off my game, helped create these beautiful TikToks. And I'm going to tell you what they showed. Now, these ended up all being admitted as exhibits, but I'm going to go in order of what they showed. There was a text thread in Exhibit 85, which if you want to look at it, you can, where Jennifer Crumbley said, I'm going to get drunk and ride my horse. This was on March 17th, St. Patrick's Day. A lot of people have a cocktail on St. Patrick's Day. That does not make her a mother that would be negligent or grossly negligent to her child. There's text messages from the day before where Mrs. Crumbley's son is saying some things about, now the house is haunted. Some weird shit just happened, now I'm scared. I got some videos, a picture of a demon. It's throwing bowls. I'm not joking, it fucked up the kitchen. I'm going outside for a while. Can you at least text back? On that day, Mrs. Crumbley didn't text back, but their own exhibit, okay, which is Exhibit 83, so the numbers do bounce around. So we go from 85 to 86 to 83, show that within an hour of the shooter making these ghost comments, she did call him. Specifically, she called him back at 7:24, and they had a 19-second phone call. If it was 19 seconds, it most likely was, I'm on my way home, we'll talk when I get home. So then the state, in order to make it seem like they really, really got some proof here, they admitted exhibits 87, which show on the 17th on St. Patrick's Day, James was on a horse. They showed People's Exhibit 88, confirming the metadata that James was on a horse. They showed a picture, 89, of Jennifer on a horse that day. Metadata to prove she's on the horse that day. Another picture, number 91, of James on the horse, a different picture. The metadata to prove James is on the horse. A picture of Jennifer with her horse in Exhibit 93. And again, the metadata to support the picture was taken out of the barn and sent, and that these people talked about these horses. It's all fine. That's on the 17th of March. You're going to have access to all this evidence if you want to see it. Then they introduced exhibit number 86, which is where their son says the house is haunted. This is on the 17th. This is the day where he says, text back. This is the day where I already showed you the exhibit. She called him. She didn't text back, but she called him. And then they show a couple texts from a few days later on the 19th, where it's obvious from the messages, the Crumbleys had had an argument with their son the night before. He was upset to have his phone and things taken away. That Jennifer Crumbley gave him a melatonin to go to sleep. She should have only given him a half. It's in the messages, but she gave him the whole thing. And it knocked him out, and he slept in their bed that night. And when he woke up the next morning, James described him in the text messages as he woke up looking like he had way too much to drink last night, complaining about a headache. Jennifer says, well, he was really worked up and out of control, so I can see why, talking about his behavior during the fight. All I know, Jennifer says, he needs to eat, go to work hard, not complain, and he can get his stuff back. She testified that getting his stuff taken away is his trigger. It's what makes him get upset. She says, you respond and I didn't get it. James says, Jesus, yes. He said, let me ask you a question. Why am I in your room? That's when they talk about the melatonin. She says, oh my God. James says, I really thought you were giving him a Xanax last night. Jennifer says, does he seem better? No, melatonin. James says, I know. So obviously he's joking. Jennifer writes, but he hasn't had one before, so I should have only given him half. James writes, well, he's doing his school, says his head's hurt, so he took Tylenol. Jennifer asks, is he okay to work? James says, yeah. Does he remember what he did? James finally says, dude, I'm working. I'm on a demo right now. I haven't talked to him. He's doing school. And that's really the extent of the conversation. So fine. So one day they get in an argument. And I'll tell you what, those kind of arguments in a heartbeat could have me sitting in her chair. The final date that the state claims Mrs. Crumbley had knowledge about back from March of 2021 are exhibits 96 through 100. And 96 starts off with their son saying, I'm picking up the room. I cleaned until the clothes started flying off the wall. This stuff only happens when I'm home alone. I pick the clothes back up though. And that's the important part of those texts on the 20th. We know on that date, because the people proved it, no pun intended, but they beat a dead horse, that at 97, it's a picture of Jennifer at the barn. We've got the metadata showing Jennifer was at the barn. We've got another picture on 99 showing Jennifer was at the barn. And exhibit 100, Jennifer was at the barn. Big deal. Jennifer's at the barn. Their son is saying goofy stuff. Jennifer gave you the context. They had an Ouija board for a couple months. after Christmas of 2020, he and his friend are playing with the Ouija board. They ultimately lost interest. They stopped doing it. Jennifer admitted to you one day to mess with them. She turned the power off in the house, turned the circuit off to mess with them. She mentioned a time where James pretended he was getting electrocuted. She didn't know what to do. He was screaming, trying to kick him, see if he's electrocuted. Ethan is laughing, taking a video of the whole thing. This family played together. They had fun. They did what families do. The prosecution just had zero context because they had tunnel vision that she was doing something wrong and was grossly negligent, and they were hell-bent on convincing you that was the case. So the other thing that you can find as a reasonable doubt in the case is the lack of evidence in the case as a whole. The prosecution has made very serious claims. And when you really look at it, they have very little evidence. So what they've shown to you, and I have it in these folders, are these dates in March 2021, which, by the way, are 10 months before the shooting even took place. They're before it would have, it's unreasonable to expect that things that happened in March of 2021 are an indicator that 10 months later their son's going to do something. It would be very different if every week there's something going on up until the shooting, but there's not. Because if there was, the prosecution would have brought that in and showed you every horrible thing that was happening to show you their son was being ignored, and they don't have the evidence. So what they did provide and what was admitted, this is exhibit, I believe, 423. These are all the Facebook messages between James and Jennifer. So when you look at those Facebook messages and consider, and this includes the photographs and the GPS stuff, that they're using this much compared to this much over the period between January 2021 and the shooting. This is a very little bits in time compared to the grand scheme of things. And while the officer testified and played games with me that he's not sure this is the best evidence against Mother, you better believe if they had better evidence, they'd be up here showing stronger and better evidence. This is it, ladies and gentlemen. It's obvious from the evidence in trial, and you may find it to be a reasonable doubt, that the Crumbley son was a skilled manipulator, and they didn't realize it. He's not sick. He doesn't have a mental illness. He's had no history of hallucinations. He has never shown his parents signs of mental illness. He certainly never showed signs of mental illness wanting to get a gun. No parent would purchase a weapon if they believed their child had mental illnesses. And these are people that had 2 other guns in the house for months where nothing ever happened with those guns. They had no reason to believe that somehow this third gun was the thing that was going to make the difference. The texts that the prosecution admitted as Exhibit 101 were texts between the shooter and his friend that we have not named. The extent of these text messages saying goofy things like, I told my dad to take me to the doctor, he gave me pills to suck it up. It's at the point I'm asking to go to the doctor. I'm having insomnia and paranoia. I'm calling 911. I thought about calling 911, but my parents would be pissed. I disagree with the prosecution that these are alarming messages. But clearly, the shooter's friend isn't that alarmed because he's not texting back. The shooter's friend knows there must be more going on because he doesn't tell Mrs. Crumbley, who is like and he's like a second child to her. And we have no other context about these messages, and if anything, the evidence does not show that Mrs. Crumbley ever saw these messages. Now, when she sees them now, she thinks that's crazy. She'd like to know more context. But you also have to know, and another reasonable doubt you may find in this case, is created when you compare these text messages that were sent that have alarming things between Ethan and his friend to all of the messages between them, which are over 20.
Hi, Mark Barden at Sandy Hook.
Oh my
Policy.
God.
Dude.
When the gunman,
Are you making the vote for people as though it's them?
They would have paraded it up.
What do you mean?
And we would have been
Read my-
Yes.
worthies.
Yes.
But instead,
hung.
they admitted, and you haven't heard the friend testify. You haven't heard any context about these. And all you can see, and really all the evidence shows, is that there's no reason to believe Mrs. Crumbley ever saw them. I don't want to have another leaning tower of Pisa situation. Move this out.
I'm watching.
I've taken your advice. Now, the other evidence the state has shown are little bits and pieces from the shooter's journal that are quite alarming and disturbing. But again, Mrs. Crumbley says the information in there about my parents won't listen to me for help is not true. And there is no evidence to show she ever saw that 22-page handwritten document. She never saw the little bits of evidence that the prosecution admitted. To evaluate this case, you have to look at it from the perspective of what she knew. So the journal information and the small amount of text compared to all the text with his friends are things she didn't know about. There's also 2 times where the state says that they have proved that Mrs. Crumbley's son was showing signs of depression or being sad or lonely. All right, those come from April 29th, 2001. This is when Jennifer Crumbley emails the friend, his mother, and all she says is that her son has been acting kind of depressed. She doesn't know what's going on. She's trying to find out what's going on, but he won't really tell her much. She's trying to find out if there's an issue between the 2 boys she should be aware of. She's trying to get down to the bottom of it. If anything, she's doing what a good mom does to try to figure it out. But the worst of what she says is that he's stressed by school. I don't want to get this wrong. He's been acting kind of depressed. And she's happy to hear it's not an issue between them. Then they go on to make plans for their son. This was admitted as Exhibit 104. If you put my text up there and showed every time I told my mom that one of my kids was acting depressed or weird, I guess my favorite word is moody these days, it would look like my kids were complete lunatics. I'm actually shocked Jennifer Crumbley doesn't have more texts about her son acting like a typical teenager. And Jennifer Crumbley testified that although she said that, she didn't think it was anything she needed to run to a doctor about or anything she needed to do anything more with. And this moment passed, because if it didn't, the prosecution would have brought in all the texts that went beyond this, and there'd be more evidence. They also run in text with the same parent of the friend from Exhibit 105, the friend's mother, when Jennifer Crumbley reaches out to her saying she had no clue what they were going through with their son, and she felt really bad about it, and asked how they're all doing and that they're thinking about them, that family, a lot. And ultimately, the worst that Jennifer Crumbley says about her son is, I know my son misses him. And if you need anything at all, don't hesitate to ask. That's it. It doesn't go on with wild depressions or hallucinations or mental health issues. That's it. That's it. I'm actually shocked there's not more instances of depression or moodiness where my kid is acting weird. The fact that there's this little evidence is shocking to me. However, it's a lack of evidence on the state's part. There's also a lack of evidence in Mrs. Crumbley saying he's depressed to really anyone else. Even after the shooting, when she's testified or when she's talking to her friend Kira, to other people, to Brian, all she keeps saying over and over is, I wish there had been signs. I wish there had been something. He's a normal kid. There's a complete lack of evidence of mental health concerns specifically. If you want to really spend some time digging into that, you can read all the messages between James and Jennifer Crumbley, all of them, and you will find that there are not texts that go on and on that their son was exhibiting anything close to a mental health concern. And again, my text would read worse because I say things like, I think my daughter's psychotic. When Mrs. Crumbley did have to evaluate what's going on with her son, and there was something alarming happening, she relied on people who spend day in and day out with kids, people she considers to have more expertise in kids than she does, including Pam Fine, who left her a very nonchalant voicemail that you've heard. It was Exhibit 115, if you want to hear it again, saying Ethan was looking up bullets in school today. It's not illegal. It's not wrong. He's not in any trouble. It's just like how teachers can't look up hops for beer. You don't need to call me back. She was relying on the representations by the school counselor, Sean Hopkins, who took the stand and has had a lot of training, hundreds of hours of training, and made it very clear this was just an issue where he needed some kind of therapy and didn't think it was necessary to suggest to the Crumbleys, go to Common Ground today, or serious enough that he called 911. And she relied on the assistant dean, who also has an abundance of experience Mrs. Crumbley doesn't have. And quite frankly, my kids didn't come with a handbook, and my guess is her son didn't either. And the assistant dean said the same thing in the meeting with Mr. Hopkins, that Ethan Crumbley that the son could remain in school that day, that he would probably be better off, according to Mr. Hopkins, around peers versus being alone. And that as long as they got him an appointment within 48 hours for some kind of counseling or therapist, that was sufficient.
That's a pretty big deal.
So it's absolutely not credible when a witness from the school, like Mr. Hopkins or Mr. Ejak, gets up on the stand and says, even if a kid is very sick, we cannot force them to go home. That's not true. And as parents with common sense, you should know that's not true. Because when my kids are puking, my kid's school will not let them be there. And when they have a temperature, not only can they not be there, but my children's school is always nice enough to remind me they can't be there for the next 24 hours, which means they can't be there the next day either. So reasonable doubt can be found in the fact that trained professionals told Mrs. Crumbley her son was not a risk, and Mrs. Crumbley relied upon it. This school also failed to even really look at the situation and tell her about things from the year before. They made it very clear that he was not in any kind of discipline issue, which is shocking to me and was shocking to Mrs. Crumbley, considering he's off topic looking at bullets in school. He's looking at a video in school of some kind of violent pictures. And then he draws a gun on his math paper instead of doing the math paper. So when school officials say, okay, this is really not a big deal, all we want is a counselor within 48 hours, Mrs. Crumbley took that as a very strong sign that things were fine. And reasonable doubt can come from the fact that those 3 people at the school, Fine, EJAC, and Hopkins, are mandatory reporters by CPS who would have reported if they thought Mrs. Crumbley or Mr. Crumbley were neglecting their son. Mrs. Crumbley even commented to others about the nonchalance that was at that meeting, that it was only 12 minutes long, which surprised her, that she was disappointed they didn't take it more seriously, that she was surprised there was no disciplinary action, and she left the school actually feeling better that maybe she had overreacted when she flew over to the school. Now, the people who are trained in these areas, they didn't just say, we're not trained in these areas. They gave specific examples. They said that kids who are really a threat, they would show nervous behavior. They would show anxiety about somebody else handling their belongings. In this case, the shooter was cool as a cucumber as Mr. Ejak went down, got his backpack with the gun in it, and brought it to him. And Mr. Hopkins and Ejak said they hoped they could get him into counseling today, but ultimately said he can stay at school and we'll give you 48 hours to get it situated. All right, so the prosecution keeps harping on the fact that Mrs. Crumbley knew they had bought a gun and that the people at the school didn't. This is Oxford Community Schools. These professionals testified about how common guns are at the school, so common, and this kind of blew me away, although I live out there, that students are known to go to the gun ranges often, that girls on homecoming wearing their short little party dresses they wear to the dance take photos before the dance holding their guns, that kids go hunting on late start Wednesday before they go to school, and the school has to give reminders to parents for people to leave their guns at home. So this school that obviously has a strong gun culture going on, that sees a student looking at bullets, looking at a video game type thing with violence, and seeing a gun drawn on a paper, that these school officials, knowing that community, that they didn't ask if he had a gun when they carried the backpack down and did make a comment about how heavy it was, although the comment evidently was made to a different teacher, and I misunderstood and thought it had been made to the shooter. So yeah, Mr. and Mrs. Crumbley, they didn't mention the gun, but they did mention that they had been at the shooting range with their son. And this is a community that is so into guns. I can't even believe that these girls, I always look at those pictures on Facebook and think, oh my God, how short are those dresses? And these are girls showing their dresses with their guns in their hand. They know this is a gun community. Reasonable doubt can be found from the fact that the biggest concern at the time was suicide and not homicide. The worst case scenario that was presented would lead a reasonable person to believe there was a possibility of suicide, not homicide. The prosecution seemed to also carry on about the amount of money and time that Mrs. Crumbley spent on horses. Just because she spends money and time on horses doesn't mean she doesn't love her son. And the fact that they have to stretch so much can create reasonable doubt. And if you actually look at the exhibits the defense submitted, you'll see that Mrs. Crumbley said she has to get a second job to pay for the braces, which are very expensive to put on her child's teeth. She paid for her son to be a part of a bowling team. She paid for him to do other sports. She cared about her son. Just because she cared about horses and bought medication from them and had a horse hobby, that's not any different than a dad who likes golf and buys new golf clubs and has a membership to a country club and spends time there and spends money at the bar there on days they go golfing. It's not any different. To try to suggest that it shows the priorities were on horses and not their son is just garbage. This is a son who had everything he needed and all kinds of opportunities in life. A son they take camping and on vacation to Cedar Point. Not only do they take him, they take a friend with them. These are parents that clearly love their child. They're sitting there playing board games with him, spending time doing that. That's all in the Facebook pictures that were admitted. Those are submitted to you as exhibits, and you can take a look at them if you want to. Brian's testimony in this case absolutely creates reasonable doubt. When Brian Meloche testified, there's no question he was inconsistent. And I would submit to you that after, there was no reason law enforcement needed to interview him for 2 hours, 1 hour, and then 3 hours. But over time, the police certainly caught on to the fact that the more you ask Brian the same question over and over, and he realizes he's not giving the answer you like, he changes it. And while the prosecution tries to make it sound like, well, he didn't want his affair outed, from the very beginning, he told them he was having the affair with Mrs. Crumbley. That was not something that ever changed. It wasn't until the third interview when they started talking about his pension, talking about his job, that he felt pressure. He agreed with the word pressure, and he agreed with the word veiled threats, although he did take it back later, that the police wanted him to say something bad about Mrs. Crumbley. And I would submit to you that they probably did that to all of the witnesses in the case. But Brian Meloche was the one who admitted to it. And when Mr. Keast got back up there and asked him more questions and asked him more questions, Brian got right back in line like he was supposed to and told them exactly what he knew they wanted to hear. Brian is a terrible witness. He said he had memory problems. And quite frankly, when he's testifying that he knows that the gun was in the car that day of the shooting, we all know no one thinks that's true. Mrs. Crumbley testified and explained the day the gun was in the car. Brian's just wrong. And when Brian testified that Brady was gone and he believed Brady died or committed suicide, I would submit to the jury that Brian is just an idiot and has no clue. And that the truth is, he didn't know the details about where the shooter's friend went. He just knew he went away. Wherever he got that suicide idea from, who knows? The prosecution didn't show any texts or anything to support that. But it's clear that Brian Meloche has been put on a mission, which is you're coming into court, you've got some things hanging over your head, and we want you to take a position against Mrs. Crumbley. And I would submit to you that if you read the 77-page exhibit that I got yesterday and went through in painstaking detail with you, you can see that Brian Meloche did not think of Mrs. Crumbley that way when he knew her and when he dealt with her. And he testified the only places he got new information about her that made him think differently about his answers were from law enforcement and were from the media. The media that we have talked about in this case repeatedly as being inaccurate. Brian admitted that when the prosecution asked him, and we've already talked about this, to delete his messages, when I went through the part about clear the cache, Jennifer telling him clear the cache, showed him the stuff before and after, he realized it was just to refresh the page to see if Facebook had deactivated. So giving him little bits of information is particularly dangerous because he's not the sharpest. And that's what the prosecution did. They used him to their advantage to try to make it sound like they have this case and all these horrible statements against Mrs. Crumbley. And by the way, when they presented evidence that Mrs. Crumbley is deleting texts and keep making it sound like she selects different texts here and there, it actually sounds like Mrs. Crumbley deletes all her texts, as she testified, that when people start flooding her with text, she deletes entire threads at a time. Who knows what she's deleting? We saw her on her phone flipping through them super fast. And the texts ultimately that she deleted, the prosecution did point out 2 of them in their closing. They pointed out the texts about "we're fucked" and "we're on the run again," but they didn't mention that she deleted 2 texts that are actually very exculpatory and helpful to her. Why would she delete some of the most helpful and exculpatory things she said? Those 2 texts are on page 42 and 44 if you want to see them in the 77-page exhibit. And those 2 texts confirm, she calls it the string lock was on the gun. She means the cable lock, but she doesn't know enough about guns to say cable lock. The string lock was on the gun. And the other deleted text that the prosecution didn't mention was when she said that the weapon had been locked, the ammunition had been stored separately, and that everything was not loaded. There's no reason she would delete 2 messages that are that helpful to her. She's just a person who deletes all of her messages, as she testified to. You can find reasonable doubt that Mrs. Crumbley's state of mind is very obvious in statements she made after the shooting. Right away, she's talking about how she had no signs to believe anything would happen. At the substation interview, it's on recording, we watched it. She tells the interviewer, "I had no signs, there were no signs." Then when they have her in the car, the squad car, and she's in the back, she says to them again, "I had no signs." In her text message with Kira, which was admitted, she says there were no signs. Kira says there probably were, you just missed them. With Brian Maloche, Mrs. Crumbley says again, there were no signs. I would submit to you, this is not some master plan where Mrs. Crumbley decides she's going to suddenly say there's no signs. First of all, there's no evidence of signs Mrs. Crumbley knew about. And second, all of her immediate fast statements in a time of stress, when right after she's had guns held to her face, walking out the front door of her house, she's saying there were no signs. You might find, and I know the prosecution takes issue with this one, Mrs. Crumbley was actually, in fact, a hypervigilant mother. She's the kind of mother who is going to the friend's mom to chase down why he's having a moody and kind of depressed day. She's on Power Schools on the app multiple times a day, checking for missing assignments. She's emailing teachers about grades. Christy Gibson Marshall, the assistant principal, who did do one of the bravest things I've ever seen. She testified she saw the shooter's face.
Babe, that stack of index cards still looks pretty thick.
And the reason she couldn't believe it was him is because it was so unforeseeable. Mrs. Crumbley's hypervigilance also comes when you look at how she takes him for medical appointments. They're in urgent care because some little mole on his back changed colors when she's applying sunscreen. I think of myself as a hypervigilant mother, and I've never noticed any moles on my kid's back, and I must need to go home and look. Because when I look at the actions of Mrs. Crumbley, she actually pays far more attention to that kind of thing and other things than I do. I could easily be sitting in her chair. When her son's experiencing headaches and medical issues, she's at the doctor or doing virtual visits. There's no reason to believe that's not true. With the headaches, they go through a whole process. She gets a whole x-ray done of his head. She takes him to the eye doctor to see if that's causing the issue. Ultimately, she pays and puts braces on his teeth. Then he's a bad brusher, so she's going to the extent of getting the braces off his teeth so he can get the cavities fixed, 13 cavities. I would go crazy on my kid. And she's just doing each thing she needs to do as a hypervigilant mother. And yes, a hypervigilant mother can have a drink once in a while. I'm a hypervigilant mother, and I not only have a drink once in a while, but sometimes I've been known to have 2 or 3 or maybe a bottle. Reasonable doubt can be found from the fact that Jennifer Crumbley did her best as a mother. While going to the shooting range is not her thing, she's trying to find a way to bond with her son, who has just had his best friend move away. She took him camping, took him on trips, brought the second son along, like I've already talked about. She let him have pets. He has the cutest little kitten you've ever seen in these Facebook pictures. Board game nights with him. She's not neglecting him in any way. And if anything, she's going to the gun range for him, not because she enjoys it. You can tell how much she loves it when she gets up there, shoots a couple shots, and then just stands there letting him enjoy the activity he likes. And I do the same thing for my kid. He likes to go to skate parks. I would rather do anything but go to the skate park. But I sit there and watch and say, oh, that was amazing. And all I hear is, Mom, watch this. Mom, watch this. Mom, watch this. And I would rather do anything else. But Mrs. Crumbley on that day is trying her best to bond with her child and have a relationship. Showing the pictures of the messy house was just not necessary. And the prosecution explained to you they weren't trying to prove she had a messy house, but much of it was just so unnecessary that I would suggest they are trying to make her look bad. They do kind of make her look a little bit like a hoarder. But if you saw pictures of my house right now, like a snapshot in time, you'd be just as horrified. I've been so busy getting ready for this trial, ready for all the fun we've had in the court and through these last few weeks. I still have my Christmas trees up. I was complaining to my husband the other day, oh my God, we still have our Christmas trees up. This is embarrassing. And he said, hey, Shannon.
Emily, keep quiet. Keep quiet.
ceramic
Don't say
pumpkins
anything.
up.
Don't say anything.
And I realized, oh yeah, all of our fall decorations are out too.
Kind of apparent that
And
those
right now,
are-
I have piles of laundry all over. My kids over Christmas break put together stacks of stuff I need to take to the Salvation Army. I have donations of my own that need to go. My house right now, if they did a search warrant today, would look just as bad as Mrs. Crumbley's. And it says nothing about me parenting my child. If anything, when I come home from work, I make a deliberate decision. All right, listen, I can run around this house for 3 hours and try to get as much as I can done. Or I can sit on my couch and watch old episodes of the Kardashians with my daughter. And I believe my time is better spent hanging out with her, watching trashy TV, than cleaning up my house because I get a chance to spend time with her. And Mrs. Crumbley was the same kind of mom. She was waiting until the holidays to have more time. She said she was going to clean her son's room. I would be screaming that I would make my son clean his room, but regardless, the project coming up was going to be to get those rooms in order. But at that point in the year when the holidays are coming up and you're getting ready for all of it and going through Thanksgiving, it does get to a point where you do have boxes piling up and you're just trying to get through those last days of school to get to Christmas break. There's reasonable doubt when you look at what Mrs. Crumbley thought after the
Man,
meeting
that
with
pile's still
Mr.
thick.
Hopkins
Still thick
and
pile.
Mr. Ejak.
Index cards.
The
pile.
state of mind
My
she was
comments
in
won't post. They text you gross negligence.
through her statements. She thought everything was way less of a big deal when she left that meeting. She thought leaving him in school with his friends was the better decision based on Hopkins saying peer support is a good thing. She thought making him an appointment was sufficient within an appointment within 48 hours was sufficient. That doesn't even mean the appointment was going to be within 48 hours. Reasonable doubt can be seen in the video when Mrs. Crumbley first sees her son at the substation. Her reaction to seeing him in this complete state of disbelief as to what's going on is to look at him and say, why? Why? She doesn't look at him and say, I knew you were going to do this. She doesn't look at him and say, see, I knew we shouldn't have bought that gun. She says, why?
Post as a
Why?
comment.
And when he says, take care of Dexter, she cannot believe that's her son and goes back into the other room with her husband and says, what the fuck? He didn't even care.
Man, they get to say
And
fuck
while
all
the
the time in court.
prosecution asked questions about, well, she's not sobbing, and we hear sobbing, and that's clearly
They've
James.
really
James is sobbing.
Gotten lax on that.
When you look at the video,
Yeah,
if you decide you need to see it, Mrs. Crumbley is dabbing her eyes and wiping her eyes. And fine, she's not the crier some other people are. Reasonable doubts can come from the statements in the heat of the moment at the substation when Jennifer Crumbley is in a state of shock trying to answer their questions. She says, he's never done anything bad. This is after she already has somebody saying, really should have a lawyer there. She's still just talking about what the truth is. He's never done anything bad. One of the parents says he's a perfect kid. Jennifer Crumbley tells them the most of an issue he ever has is anxiety over tests. Jennifer Crumbley tells them everything was fine this morning. In the statements Jennifer Crumbley made when she was in the car and doesn't even know yet if there has been fatalities, she says he's never done anything. She acknowledges he ruined lives today. She says, it's the first time I've ever seen him do anything. She says, he's a good kid. He's never angry. He's mellow. He's not what he looks like. He's not a monster. And she's not a monster either. She explains to them in detail when they ask, he's never had mental issues. In those moments, she can't even think straight about life around her. She's worrying about a horse and her job and all kinds of random stuff. And ladies and gentlemen, when emergencies happen, life doesn't just stop. So the fact that she's able to function and think, I still need a job, I need some money, I need a phone that works, that doesn't mean she thought her son would terrorize and kill people and shoot people at a school. Her reaction when she finds out there are fatalities was genuine and honest. And she broke down crying, although she does continue to keep answering their questions. She explains why she feels like fatalities are different. She explained that on the stand. If he had shot people and injured them, it was something they could at least deal with. But a fatality is a fatality and can never be changed. The prosecution's attempt to misconstrue Jennifer's entire demeanor is a reasonable doubt in this case to show they don't have a strong case. They keep saying she's not sad. Jennifer explained she went into what can I do mode. She did show sadness if you read the texts between her and Mr. Maloche. She showed sadness in the way that she showed sadness. And for these officers to get up on the stand and say she didn't behave like the mother of a school shooter should behave is nonsense. None of them have ever dealt with the mother of a child a teenager who has just killed people and shot many others. There isn't a right way in any handbook to say how you should or should not behave. Trying to make her look selfish and callous goes right with that same thing. How she reacts is how she reacts. You see it on the screen. It's really hard to pass judgment, although these police officers did, on how a person should react when for the first time in their lives they walk out of their house and are surrounded with guns in their face. Or how a person would react to be woken up in the middle of the night on a mattress with police around them and above them with guns in her face. So not only has anyone not been in the shoes of a school shooter and dealing with the kind of emotions that would come with that, they also don't know, and there isn't a standard reaction for how you behave when you're surrounded with guns in your face. Jennifer's own statement provides reasonable doubt that she didn't think he would hurt other people. She typed to him, "Ethan, don't do it." She didn't say, "Don't shoot people." She didn't say, "Don't hurt anyone." She thought the only thing on her radar that could be possible at that point, knowing there's an open shooter and he has a weapon, was that he would kill himself. Reasonable doubt can be found in Jennifer's testimony. Jennifer's testimony is evidence. And at the end of the day, whether you believe, like, hate, however you feel about her testimony, the defense didn't have to prove anything. You still have to evaluate the prosecution's case for what it was. However, Jennifer Crumbley did take the stand, and that was not easy for her, to give you additional context about what was going on in the shreds of evidence the prosecution cherry-picked and put before you. The only person who's actually been consistent in this case, and you can find reasonable doubt from this, is Jennifer. She's consistent in what she says to police, what she says to her husband about things, and what she says to other witnesses who testify. You can find reasonable doubt in the fact that the police officers are very, very biased in this case. There is no doubt this is one of the most awful situations any one of them have ever been involved in. But it's also very clear they have a narrative that Jennifer Crumbley is responsible. And when they came in here and took that witness stand, they were going to mess with me on questions that were so stupid. Like this ATF agent telling me he doesn't know if teenagers could lie. Everyone knows a teenager could lie. That was a low ball. Just answer the question. When you have an ATF agent that can't even get on the stand and answer a question that's common sense, that should speak volumes. That there's a narrative they've been directed to get out and they have an agenda. And that agenda, ladies and gentlemen, is not positive for Jennifer Crumbley. This big deal about money and cash that Mrs. Crumbley took out is another reasonable doubt in this case. Mrs. Crumbley explained her dad had accounts frozen. She didn't want her accounts to be frozen. Her dad put money in that day so she could take it out. Getting money out of the account that had her son's name on it wasn't done in any way to steal money from her son or show she doesn't care about him. She's the one that contributes every week from her paycheck into that account. And at the end of the day, she wants cash because everyone in the world absolutely hates her. She can't walk in places and hand them a credit card. Hey, Jennifer Crumbley's on that credit card. The only option she had was cash. She can't go in and start showing identification and things to get hotel rooms. And the more cash she can use, the better. The less she has to risk that people are going to figure out who she is. And remember, the world was essentially showing its colors against her as she was receiving threatening messages in the days that followed that shooting on Facebook from other people, in her emails, in her Instagram, everywhere. They're so threatening, her employer is making her shut down accounts. Her friends, people that have been her people for years, don't want anything to do with her and don't want to be by her because she's that dangerous at that point in time. So for her to want to have cash makes absolute perfect sense. That's not a sign she's trying to flee. And also, if you're trying to flee, you don't go around local Oakland County and areas surrounding it and carry around a syringe of horse medicine. If you're going to flee, you abort mission on the horses. At that point, you're fleeing. It's very obvious Jennifer Crumbley, her intent was not to flee. Her intent is to stay safe. Her intent is to avoid threats. Her intent is to get this horse medicine to this horse, which obviously can't happen if she flees. It's clear when she's at the art studio that she's not hidden very well. She's outside smoking. Her husband's outside smoking. We saw the evidence of the cigarette butts in the snow. There's commercial buildings around and businesses within that studio. She's walking around taking a tour of the studio with her friend who owns it. And there's cameras all over the building. Obviously, she's not trying to hide if she's going into a building where you can see security cameras right on the outside that would document everything that's happening that we ultimately got to see in this trial. It's clear she's trying to stay the night in Detroit on November 3rd and didn't know where to go. It's clear from the video she's dead asleep at 1 o'clock in the morning when they're ultimately found and woken up to guns in their face. She testified she took 4 Xanax and so did her husband. We also saw evidence there was a liquor bottle in the garbage and presumably she had a drink. After 4 days of no sleep and not really eating, one can only imagine how hard 4 Xanax and a cocktail might hit you. So they make this big deal that there's text messages after 11 o'clock saying we might have been found. Well, earlier in those text messages that were admitted by the prosecution as Exhibit 430, the first text says, Marielle, this is Jennifer's phone. And Marielle was the other attorney at the time. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. Next message. The other phone broke. And then there's a message to the Crumbleys, when you can, we'd like for you to call us. That's at 6:19. Then at 6:21, thank you, Shannon's calling you both shortly. Then at 7:02, I text, Marielle and I are going to come get you in the morning. We do not think it will help to make a statement that you're coming in or that it will be tomorrow morning. All we can say, as we've told everyone, is that you're coming back, and as of tomorrow, you'll be back. My next message says, we can show them that everything we've said was going to happen did happen. Because the Crumbleys weren't running. They just wanted to turn themselves in to a court. And law enforcement got on the stand and told you that's something people commonly do. It just didn't happen in this case. At 7:03, the Crumbleys write back, and we don't know if it's Jennifer or James because they're sharing his phone. Okay.
I smell an ad coming
Text
any
to the
second.
lawyers would say Marielle Shannon lawyers. Who knows why they sent that? I text, I am going to drive drive home from my office right now. I'll give you a call in about 45 minutes so I can get all of the bond factor information written down for you for Marielle and me. I'm asking for bond information so we can go to the court in the
Your Honor,
morning.
I'm gonna object. There's a prior ruling. She cannot be a witness. That was already dealt with.
Sorry, I thought I was arguing off the evidence they admitted.
Well, you kind of off the evidence.
Okay. So they say at 7:37, okay, we'll be waiting. I'm gonna call in 1 minute, okay? Then at 11:14 on the phone that both of them have been using, a text is sent to the lawyers. Think we might have been found, don't know, just a heads up, please check. It's not for a couple hours that they're actually found, but Mrs. Crumbley testified she didn't send that text and she was already asleep. Now, after those text messages, there's 2 more pages that are included in that exhibit. So if you do end up taking a closer look at 4:30, which is totally fine, just be aware that there's another thread that starts that's a repeat, and I don't know why that is. I just want to let you know that, and I'm not sure why that exhibit is like that. That was a new one we got, obviously, all today. In the days after Mrs. Crumbley and Mr. Crumbley are planning to turn themselves in, we know they're planning to turn themselves in because Exhibit A was admitted, which showed they were trying to find a hotel in Auburn Hills on Priceline for December 4th and 5th, in case they needed it for the weekend. There's no doubt, and I don't need to go on and on about this, they were getting threats. That was so clear at trial. They were afraid to go turn themselves into a police station where if they went, there would likely be other inmates or bad people there, and their faces would be up on a TV because it was all over the state at that point.
She should have handled
They were
this
terrified.
guilt shit in the beginning, not now.
They wanted to go in through a lawyer. Reasonable doubt can be inferred from the fact that they set an alarm clock, which was admitted by the prosecution, showing that on Saturday they were getting up at 6:30 or 6:45, completely consistent with their plan to go to Novi for an 8:30 hearing. This is also not James's trial. I am not standing here suggesting that James is guilty of involuntary manslaughter in any way, but it is important to point out that James was the parent responsible for all of the storage of the guns. Jennifer Crumbley barely knew a thing about them. She didn't object to them being in the house. She didn't object to buying the gun that James and Ethan were interested in. She didn't object to calling it Ethan's Christmas gift. She was not responsible at all for the storage of the weapon. It is misleading to suggest by the prosecution that that 6-hour case was open on the bed and that it sat open like that all day with the ammunition box next to it. It's very clear that when James and Jennifer Crumbley were on the phone during that 7-minute phone call, Mr. Crumbley was looking for the gun, found the gun was missing, asked Jennifer Crumbley, where's the ammunition, pulled it out, and set it on the bed. It's not like that gun box, that case, was just sitting out there open.
You're the guy with the gun.
Oh my
Person who
God.
would do anything to protect the ones you love.
God. I told you I could
Did you know you
sense
could
it.
go to jail for
It
simple?
won't let me post.
While this is not James's
I have
case,
to be like on a different YouTube account. That's what
it
I
is
have to be
fair
on.
that
like, 'cause
Jennifer Crumbley would expect that he would have more flexibility in
Can't
going
be
to handle an issue at the school. That is not unreasonable and does not make her a bad mom.
yeah, going.
He's out in the Oxford, Lake Orion, Rochester area door dashing. She's the one with a professional career supporting the family and paying all their bills and trying to keep her job, which they may need to add the family on for insurance in this open enrollment period. She shouldn't be diminished as a mother because she was going to let father go to the school and handle whatever issue there was. Now, ultimately, they went together, but he's a DoorDash driver. She's trying to pay the bills. She's the breadwinner. At that time, he's in between jobs. She shouldn't be dinged for that. It's misleading for the prosecution to suggest there's been evidence in this case. She keeps guns in the car. She didn't say she keeps guns in the car. When she was interviewed, and if you really want to watch the interview, you can. Jennifer told law enforcement there was one time that gun was in the back of her car. That one time was when James put it in the back of the car, and she drove the car to the range. Her son and her had a experience at the range, and she drove the car back home, left the car locked with the gun in it, so that when her husband got home, he could put it away. It is not true that she was driving around keeping guns in the car. That is not what she said to police. As far as Mrs. Crumbley knew, there was a cable lock on the gun at all times. She called it a string lock. She testified that the key was kept in a separate place in one of the many beer steins they had. She testified that she did know where the ammunition was. She hid it in her drawer of jeans. And she testified that things were locked and hidden separately, and that Mr. Crumbley was responsible for hiding the weapon. If you are upset with how the weapon was hidden, that's not your issue to decide. That's a future jury that will look at the case of James Crumbley. You're here to look at the case of Jennifer Crumbley and consider what she knew. She is not the person responsible for storing this weapon. I'm not trying to suggest she didn't know it was in the house, but she is not the person putting the cable lock on and off or doing anything with the gun. We saw her gun abilities when she went to the range and had to have her son show her everything about it. It's a gross overstatement to keep saying that the gun was his gift. It's very clear it was something bought for him to use at the shooting range, something that may one day ultimately be truly just his. But it's just like any of us giving our kids a laptop to use, a cell phone to use, a car to use, a jet ski. I have a friend that has kids, they have snowmobiles. Nothing different. It doesn't really mean the kids just have free access to all of that stuff. It comes with conditions, rules, and parameters. Unfortunately, this is a case where the prosecution made a charging decision way too fast. It was motivated by obvious reasons for political gain and media attention. And we know that because on 11/1, when the shooter was arraigned, the shooter was on Zoom, and so were the parents, and the media was aware. And when Mr. and Mrs. Crumbley were charged, and there was a swear to at the court, the media was all there, but guess who wasn't? Mr. or Mrs. Crumbley. Mrs. Crumbley testified she didn't even know there was going to be an arraignment, but the media knew. And then the prosecution came out with a big press conference, announcing it. I would submit that the plan was never to let the Crumbleys turn themselves in, but to turn them into a big charade of looking like they're trying to flee when they absolutely weren't. The prosecution and law enforcement have approached this case with tunnel vision from day one. Brian Maloche called it a witch hunt. I would submit to you it was. And once they charged these parents, and the ATF, Sheriff's Department, Border Patrol, Secret Service, all U.S. Marshals, not Secret Service, when all these agencies have gathered around and hundreds of people are looking for the Crumbleys, it's really hard to say, we made a charging decision a little too fast. And in this case, you heard evidence that much of the evidence in the case didn't roll in until after the parents were charged, arrested, and in jail. To try to suggest having multiple phones as a sign of fleeing is just garbage. I think everyone here clearly understands why they bought burner phones and why they went and bought replacement phones with their phone numbers so they could use factor authentication to get into their accounts. Jennifer Crumbley is seen in the police interview at the substation handing her phone to law enforcement when they're asking questions. When the police tell her they want to take her phone for a search warrant, she doesn't want to hand it over right away, but it's not because she's trying to hide things. It's because it's her only line of communication. She doesn't really understand how a search warrant works until her husband explains it. All of her contacts are in the phone. She doesn't carry around a little diary of all the numbers, although police do let her get the numbers out. And it's the only way people can get a hold of her. And she's been in touch with them nonstop, as we can see when she's in the police vehicles. And again, although she's on her phone and there is a substantial amount of time where she's looking things up, communicating with people, trying to get things done, that doesn't mean she believed her son was a school shooter and had no emotions over what was happening. The prosecution has painted her out to be a person who lacks remorse, and I would submit to you that she would change everything if she could. And when she looks back and says there's not a thing that she feels she could have changed that would have changed something, you have to keep in mind that the suggestions by the prosecution are just ridiculous. Giving him a hug that day in the counseling office was going to stop a mass shooting. That's just ridiculous. There is nothing to prove that anything could have stopped a mass shooting when you're dealing with someone who is so manipulative and is a criminal and was a shooter in cold blood and pled guilty and took responsibility as an adult for his crimes. Finally, my last reasonable doubt card is blank, because I've tried my hardest to come up with all the reasonable doubts the defense sees in this case. And like I said, each of you need only one to vote Mrs. Crumbley not guilty. But a lot of times jurors think of a reasonable doubt I miss because there's so much evidence.
I did look at your text.
And
What do
we've
you want me to
already
do? I can't
established,
put
and I've
my-
admitted I'm not a
your
perfect
chat-
person
what
and
are you
not a perfect
texting me on the
lawyer.
chat, dude?
So I put a blank card before you so that if you have a doubt I've missed, you know you're not limited to what
Type
I've suggested,
comment.
the defense suggested. You're welcome to come up with your own doubts on your own. And if you decide you want to dive in and read the truth between Mr. and Mrs. Crumbley and everything they talk about, you're totally more than welcome to. Those exhibits are all going back with you. And what I'll tell you is that you're going to find a lot of instances where Mrs. Crumbley is anxious, asking where her son is, where her husband is. You're going to see a lot of horse talk. You're going to see arguments between a married couple. When I read them, they read just like my husband and myself, yelling and swearing at each other at times. And then the next message says, hey, what do you want for dinner? And then we just move on, and that's just how life is. You'll see messages in here that will certainly make you blush when you read what Mr. and Mrs. Crumbley intend to do in bed that night. You will read a variety of messages that show real life and real life between two married people that have a child. And it should make no difference that they may use their horse's name more often than their son's. And I'd also submit that every time you see them talk about when is he going to be home and what are we going to eat for dinner, even if they don't use the words spelled ETHAN, that's who they're talking about, because there are only 3 of them in that house. At this point in the trial, I am asking that you find Jennifer Crumbley not guilty, not just for Jennifer Crumbley, but for every mother who's out there doing the best they can, who could easily be in her shoes, for every parent doing the best they can, who could easily be in their shoes, for every parent that has snippets of text messages that could be read and make them look like horrible monsters, for every parent that has fights with their kid on text message that also could make them look like terrible parents, for every parent that's ever had a hobby and has not spent 24/7 with their child That should not be held against parents. For any parent that's ever had an affair or spent time communicating on an affair, that says nothing about how much you care about your child or your expectation of whether or not they would commit a school shooting. Most people who have affairs would still not expect their child would do this. I do wish more than anything, this case could bring justice to the victims of the shooting, the victims of the terrorism that took place that day, and the victims of their families. I wish more than anything, it really could be a result that would be a Band-Aid to make everyone feel better, but it can't be. First of all, it brings back nothing for the people who have lost. It certainly doesn't bring back any lives. And if anything, this is not justice. This is not how justice works. This case does nothing for the people who have already lost everything. Many of the people sitting in this courtroom. And it does nothing to bring back the tragedy that unfolded on November 30th.
Depends.
At this point in time, the prosecution cannot prove that Mrs. Crumbley avoided exercising ordinary care that would have saved lives. The prosecution cannot prove that Mrs. Crumbley was aware there was a danger that existed by her son that required her to exercise reasonable care. They cannot prove that she was grossly negligent and that there was any way she could foresee that this would happen, as awful as it is, and we all stipulate it is. At this point in trial, I always have to sit down. This is how the court rules work. Prosecution gives a closing, I give a closing, they have an opportunity for rebuttal, and then I don't get to say anything else. And I'm sure you can see from my demeanor in trial, when the prosecution says something that I know I have an argument against, I get anxious, you can see a reaction, and I'm not going to do that. But I am going to tell you that as they argue, I will have many things that I wish I could get up and say, that's not true, and argue against. So what I would ask is that when you go back in the jury room and begin to deliberate, you think about it and ask yourselves, what would Shannon Smith have said in response to the rebuttal where they get the last word? I would just ask that you consider that in your deliberations, because I guarantee you I'll have a very hard time sitting here knowing that the prosecution gets the last word when I know the defense would disagree with it. And I am asking each of you to vote that Mrs. Crumbley is not guilty, because she is not guilty, and because a not guilty verdict is the only fair and just result in this case. Thank you.
Rebuttal?
Yes.
Somebody rang the doorbell
We did get the
at
last
our
word.
apartment doorbell.
Get the
So
last
I'm gonna go
Our
check it.
apartment.
And that's why we get the last word. And it's a burden I embrace. It's the burden to prove beyond a reasonable doubt that Jennifer Crumbley is guilty of involuntary manslaughter. It's not a burden that I have to prove every single fact about the case beyond a reasonable doubt. That's not the law. That's what she told you the law was. It's not the law. The law is I have to prove every element beyond a reasonable doubt.
Oh,
Beyond a reasonable doubt. Not any doubt. Beyond a reasonable doubt. The defense gets to decide how they present their case. They get to decide that. She gets to stand up and say what she said. But your job is to listen to the facts of the case. Your job is to listen to what the judge tells you the law is. Your job is to tell you to look at that evidence, the people sitting here, not what somebody else wants to have said that they said, but what they actually said. Your job is to consider not what lawyers say about their own life and their own circumstances and their opinion. Your job is to consider the facts and the evidence in this case. I have to address a couple things, and I'm going to be quick.
Just Scout.
There was absolutely no evidence at all presented
No
to you
girl cookie.
that anybody at that meeting
Just Scout.
told Jennifer Crumbley it was no big deal. There was no evidence of that. There was no evidence at all that Jennifer Crumbley was very surprised by how long the meeting lasted. Jennifer Crumbley didn't say that. That's not into evidence. I don't have to prove, the people do not have to prove that Jennifer Crumbley knew that there was going to be a homicide or a school shooting. As Lieutenant Willis pointed out correctly, if she knew exactly what was going to happen, she'd be charged with murder, ladies and gentlemen. She is not. She is charged with involuntary manslaughter. And the elements, you'll get them. I read them to you. The standard and what I have to prove is not that she knew that her son would go shoot up school and kill 4 kids. I have to prove that she had a legal duty. She negligently performed that legal duty. She negligently did not take steps to take care and protect the other children in that school when there was a reasonable foreseeability that ordinary care was required. The smallest of things. The smallest of things. I apologize to the law enforcement in this room and any listening that I have to stand here and to defend their integrity. But I do. Because if you believe that Special Agent Brandon and Lieutenant Willis and the other law enforcement that took the stand here, including
I'm objecting because I'm allowed to argue based on what's in evidence, and Miss McDonald is trying to make me sound like I've done something wrong. And I didn't. My argument was proper.
She's arguing. It's my rebuttal.
Do you remember you're not allowed to talk? You told everybody that.
Police officers argued about these statements from police officers. She needs to argue it.
The exact quote was, they probably did that to all the witnesses in the case. If you believe that, then you believe that the sheriff's office, Lieutenant Willis, Special Agent Brandon, the ATF, the federal marshals, the Detroit Police Department, anyone who the evidence tech, they were all in some sort of conspiracy. That's what you have to believe. And I know that that's not what you're going to find. Look at the evidence, apply the law, and decide what the truth is. That's all I've ever asked you to do. That's all the judge is going to ask you to do. Nothing here was designed. Nothing here was made up. And I don't have to convince you of that because I know that you're going to use your hearts and your minds and your sense of reason, and you're going to look at the evidence. The first statement Jennifer Crumbley makes about this gun, her son's gun, was at the substation after the shooting, and this is what she said. It was hidden. It was hidden. That's what she said. It was hidden, ammunition separately. It was hidden in a dresser. It was hidden. That's all she said about it. The school's actions or inactions do not excuse the culpable behavior by defendant. Ladies and gentlemen, he literally drew a picture of what he was going to do. He drew a picture. It says, "Help me." It has the drawing of the gun that he bought him, posted, and bragged about. Blood everywhere. The thoughts won't stop. The world is dead. He drew her a picture. Pretty egregious and unique circumstances. And in fact, it is absolutely not true that we have to worry that we'll all be sitting here. We agree on one thing. Her testimony is evidence. Jennifer Crumbley's testimony is evidence, and you should consider it. And when you consider it, I'm confident that you will agree it is not consistent at all. It wasn't even consistent from her direct examination to her cross-examination. She acknowledged sitting here when Mr. Keith asked her about, where's this phone? You said you took the phone. You heard what she said. We took his gun away. We took his gun away. I don't have to prove flight beyond a reasonable doubt. I already told you that. You can infer consciousness of mind. And what does that mean? You run, you delete text messages, and you lie because you know she knew she did something wrong. The question about why Jennifer Crumbley didn't take one of these small actions, secure the gun, find out where the gun is, it looms large in this courtroom. There is no one it looms larger for than the victims and the family members of those kids who were killed on that day. We don't have to prove why. But remember what she said. I wouldn't change a thing.
Ugh,
Just hours ago,
terrible.
she said, I
So
wouldn't
bad.
change a thing.
That's the one.
This prosecution is about nothing else except the facts of this case and what Jennifer Crumbley did and what she didn't do. If only I could look at the faces of these parents who are dealing with unspeakable darkness and grief. If only I could make that better. I could appease them, as defense counsel suggests, by charging Jennifer Crumbley. These are the parents of Hannah St. Juliana. These are the parents of Madison Baldwin. These are the parents of Tate Meir. These are the parents of Justin Schilling. And not just their parents, they are mothers and they are fathers and they are sisters and their brothers. And do not think for 1 second that this prosecution takes any of that pain away, because it doesn't. This isn't an effort to appease anybody. Your verdict means one thing. It means Jennifer Crumbley is guilty. 4 counts of involuntary manslaughter beyond a reasonable doubt. And I'm not going to stand here and tell you that that's going to take away this pain that these families feel, because it will not. I won't stand here and say that the pain will be gone for Molly Darnell or Christy Gibson Marshall or Special Agent Brandon, who ran out of that office so quickly that his chair was spinning, or Ed Rogrowski, who viewed the surveillance video to identify the path of the shooter, and it was burned in his brain forever. Or for Lieutenant Tim Willis, who answered the call to lead and maybe the biggest act of his entire career, but one he did not back away from. Don't render this verdict for the hundreds of kids in that school. It will not appease them. Nothing will. But you are now called upon. You are called upon. You are called upon to do your part as jurors, to keep the oath that you took, to be fair, to be honest, to be impartial. You are the ultimate fact finder of what happened that day. You are the ultimate fact finder of the truth. We have met our burden. We have proven beyond a reasonable doubt that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter for failing to exercise ordinary care when the smallest, tragically simple thing could have prevented it. It could have saved Hannah. It could have saved Madison. It could have saved Tate.
No. Why would I not include
And it
her?
could have saved Justin.
So they could vote like jurors.
And she sat here and she said she wouldn't do one thing different.
But I'm just, they're
And
hung.
lastly, I'm gonna address the question. I know that on
Not a
minds
prediction,
of a
their
lot of
vote.
people in this courtroom and a lot of people listening.
All right.
I'm gonna say, but I know they're all asking and they want to say. When she took the stand and she testified about her own loss, and she was asked the question, "You lost everything." She said, "Yes." She hasn't lost everything, ladies and gentlemen. Her son is still alive. Find her guilty of 4 counts of involuntary manslaughter. Thank you.
Thank you.
All right, finally. Whew.
I have to have you come back
All right.
Monday.
Let's
You know that, right? You knew that before I said it. You guys have been so terrific. You've been on time. I have not heard, I still have 5 alternates, right? Because no one, as far as I know, has violated any rule, has read a newspaper, has posted anything on Facebook, has talked to anyone who talked to someone else who repeated it to the court. We appreciate that. You know how hard it is. I'm gonna ask you to come back Monday.
Oh,
but I wanna
deliberations
instruct you
Monday.
that during the trial,
I
do
love
not
that.
read, listen
Love
to,
that.
or
It's the right
watch any news
move.
reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth. The
all
lawyers
right, you
must
can
be able
turn this part off.
to. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side.
Do y'all want to
So
hear
be
her
fair to
read the
both
jury
sides.
instructions?
You must follow this instruction. Do not go on social media.
Why would they
Do
want
not
to hear
post
that?
read Facebook.
I
Do
don't
not
know,
do research. Do not
lawyers are
discuss the
weird.
case with anyone.
But they can.
I'm going to ask you to come back on Monday.
You see
You'll
me, I
all come
pulled it
in.
from the stage.
You come back and we'll talk on that.
I saw
I'm
you.
going to do instruction.
I was really
All I'm
trying to.
doing is
No,
five
no
of
one
you will
wants
be-
to hear. Look, no one wants to hear jury
you will be
instructions.
discussing
No.
Yeah, no, I
And then someone
see. I
says
see.
keep
That's
it.
what
No,
you do.
just
Yeah, he
no.
does.
Gone. Oh,
Are we
fine.
schedule? Did you all order lunch? All right. No questions off the schedule. We have come this far. Please follow my instructions. It's very important to both sides.
Oh, she's going to do them in the morning.
Have
Yeah,
a good
she'll do it
weekend
Monday.
and stay healthy. All right?
All right.
Thank God.
Just kidding. Just kidding. I'm not important. All right.
Keep them down there at the
Interesting
bottom in
day.
case there's some argument, or mute it until. I just want to see if there's going to be any argument. Let's just see what they say.
And we'll let the jury go. Okay, you can be seated. We'll let the jury go. So we'll wait. I think I said this.
That's
before.
a Stevie
All
thing, not a
jurors
Bob
come back
thing.
on Monday morning. The captain graciously volunteered to have deputies here late into the evening, but it was late enough that that would be very difficult. So at 9 o'clock on Monday morning, I'm going to sit the jury. I'm going to have the 12 jurors deliberate, but I'm also going to sequester the 5 alternates. All right, any questions?
We
about
love
that?
you,
No,
Agent Scully wannabe.
Thank you. So can you wait till the jury's done? We're all here till. Okay.
All right, they're officially done. It sounds like.
All right. I thought that was something else.
Still got
Big
that
day in
playing
court.
there.
Big day in court. Closings. What did you think? Well, first, before we even get that, before we critique the closings, where are you at with this right now? And there's hold on, there's one thing I wanted to pop up. Let's do what we do, which makes us a little different than the other channels out there. I want to pull up what you were so furiously trying to get up on the
Well, but double check which statute she's charged under. Is it legal duty?
I think I got it here. I think Mandy screenshotted what she had up. So she being the prosecutor. Okay. Just bear with me, kids. Let me pull this up. Okay. Let me get this guy up right here. Okay, so this is what they're going to have to like. So what you're looking at, what they put up, what the state put up during the initial closing, were the actual jury instructions. So those panels were my big fat head was kind of blocking, and Jay's big fat head was blocking some of the screen. Those are the actual jury instructions that will be handed to the jurors that they will take back, and that they'll look at. All right, so
Wait, but this depends on if the one that is
these
not
are from
accurate.
the trial. What?
Oh, so they didn't charge her with lawful duty.
I believe Mandy confirm, or did you get these? Are these what they pulled, or is this what you pulled from my? That looks like it's actually from my thing with Sonny. So this
Yeah,
could be not the actual jury instructions.
Yeah, but they have two different statutes. So you need to know if she was charged
Well,
as under.
can you pull them?
I have the jury instruction. I need to know what she's charged with.
Okay. Dizzy, can you find what the actual? So it's under the involuntary statute, but Allie needs to know under what subsection.
I think it's
so while
lawful
we're-
duty, which would be different than that. I can send you the jury
Yeah, you
instruction.
sending me anything in text does not help. I can't get anything from my phone to my computer because of the whole Apple ID thing. Remember, like I'm using different. It's like a night. It's a little nightmare scenario. Dizzy will find it though. Duty was definitely mentioned in closing, so I don't know if that helps.
Legal duty, right?
Legal
that she had a
duty,
legal
yeah.
duty, then it's the
Yes.
legal duty one. So if you want to pull it up on your own, it's Michigan Criminal Jury Instruction 16.13.
Okay, let me see if I can find it. All right. Okay, so while I'm doing that, make words.
So
talk.
here's
your evaluation.
I
of the
don't know
closings.
if there was a discussion beforehand about whether or not the belief that he might commit suicide with that weapon was enough to satisfy the statute, because to based on what I'm reading,
What instruction was it? Babe? Sorry.
Well, just type in
16.
Michigan Criminal Jury Instructions, and then you're going to get all of them, and then type in search for involuntary manslaughter. It's
I thought you could just give me the number.
It's 16.13.
Okay.
I just don't know that that's easier to find it like that than.
Let's see. I guess we'll find out.
Command space bar, involuntary manslaughter.
Yeah, I got it. Okay. All right, so let's see here. Okay.
I just don't know if that would be considered foreseeable that other people would get hurt.
This is what we got. Okay.
Well, it looks a lot different than what I'm looking at. Okay, so go ahead, read it.
Okay, so involuntary manslaughter, failure to perform legal duty. 1, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. All right, you guys all understand that. You're all trial observers. You guys all know they have to prove each and every element of every statute, of every crime that's charged. Okay, so first, that the defendant had a legal duty to the victims. The legal duty charged here is state the legal duty, and a legal duty is one imposed by law or contract.
So
Okay.
being a parent, yes.
being a parent, right? The duty of being a parent. Second, the defendant knew of the facts that gave rise to the duty. Third, the defendant willfully neglected or refused to perform that duty, and his or her failure to perform that duty, to perform it was grossly negligent to human life.
Oh,
And
someone
fourth,
says they
that
did both.
they did both. Which one? The
Would be probably the regular one, which is the top. But finish this one.
Okay, so fourth, that the death of the named deceased was directly caused by the defendant's failure to perform this duty. That is, that the victims, obviously the kids, died as a result of her obviously neglecting her parental duties. I don't know, man. That fourth element.
That's what I'm saying is that her lawyer arguing, if anything, she had reason to believe that suicide was a possibility and not the unaliving of other people.
This is the straight instruction for involuntary.
So start with first.
So the defendant is charged with the crime of involuntary manslaughter. Wait, first what? That is the first. Oh, you mean first the defendant caused the death of the victim. That it is that is that the victim died as a result of state the alleged act causing death. Okay, and then you go to 3 because gross negligence is alleged here. So second, in doing the act that caused the victim's death, the defendant acted in a grossly negligent manner.
Because the defendant didn't perform an act in this scenario. So this statute doesn't.
I think they can consider an omission an act, can't they?
Well, so you'd have to fill in the blank. The defendant is charged with the crime of involuntary manslaughter. You may also, First, the defendant caused the death of students. That is, that student died as a result of what is the alleged act causing death? Gunfire. I mean,
shooting. Yeah, it's
right. That's when you're performing the act and you do it grossly negligent and you cause somebody's death. So
yeah, but you have to understand, like these are written because this is very unusual for somebody else to be charged with involuntary manslaughter for somebody else's actions.
That's
you know
what
what I
has
mean?
to be on the legal duty one. I don't know.
I know, like the duty has to been the failure to parent is the duty.
Yeah, and the failure to make sure that the gun wasn't there. Oof. No, buying her child a gun is not the act that caused these deaths. They're trying to put that as being all the things that she knew that would have given her reason to know that she needed to act as a parent in order to prevent these deaths.
Sorry, I had to get a sweatshirt. Did you turn the heat off? It's freezing in here.
No.
I think you did.
No.
Yeah, I wish we could get the actual instructions they used. Like I could probably.
Well, they're going to give them on Monday. I'm just looking for the statute right now. I mean, the indictment.
No, what I'm saying is during the opening or during the closing for the state, like when you weren't up here, she put them up on the screen.
Oh, then I'll just rewind it and find it.
Yeah, if you could find them. So, all right, if you're going to do that, so like, what did you think of the closings though? Like, did you think like let's start Shannon's? I thought the state's was fine. You know, I mean, nothing special. You know, kind of.
Well, I thought that, you know, typically you're not supposed to talk about I and me in this. I know why she did it because it's much more effective than saying this could happen to any one of you. She doesn't want to, she wants to make all of them think they do the same type of things by putting it on herself, but she could have sort of put it on other people out in the world, but there was no objection. So I thought like sort of throwing herself under the bus was effective, although annoying.
I didn't, she doesn't rub me wrong like she rubs other people. Like I like her. Like I think she's very like a person. It's like she reminds me, I hate to say it, babe, a lot of you.
I don't
She
get that at all because
she
she
just
said
does. Like she's
because she said
very
I'll
down
want
to
to jump up
very
and
down to earth. She's very down to earth. Like she does, like she's not going like she wasn't trying to be like overly prim and proper. She was very, she just kind of like lets her real shit hang out. Like I like her. No one's changing my mind. I
Right.
get that she irritates some people, but I found her to be very relatable, to be honest with you. And like people can't tell me I'm wrong to what I feel is relatable. Other people, she may be like, fingernails on a chalkboard. And I can see that. Like I can absolutely see that. Now, Allie's not a mess, and she wasn't a mess either. And I don't want to address this because I've seen people saying that. Shelby, I don't know if you saw that pile of files that was on her desk that she made the little leaning tower of Pisa comment. And Allison, and I'd like you to chime in. How hard would that trial have been to try that without a trial partner?
did she not have anyone?
She had no trial partner.
No,
No
I
one.
wouldn't have been
No
able
one
to
to
do
help
it.
her with the
No,
computers.
and
No
I
one to
would
help her
have been a mess. I would have had papers all over, but opening files and closing files, I would have gone.
It's
I
impossible
wouldn't have been able to
to like
keep it all
the
straight.
fact that she did that trial alone, which I do not know. I've already emailed her and asked her to come on as a guest because I want her on. But like, because I think it's a really important case. I'm curious as to what the verdict's going to be. But like, I wanted to address that. Like, people are just not understanding if you've never tried a case where you've got a
I
state that
found
is
it.
not telling you what witnesses are coming in what order, and they have like absolutely no responsibility to do that. They can put whoever they
Okay.
want and whatever they want. If they're going
It's
to
the
play
legal duty
nicely,
one.
okay, well, let's wait because I'm in the middle of talking about something.
Sorry,
We'll
sorry.
pull it up. And if you send it to me like email, I can pull it up. I mean, did you
It's the
find it? Is it
same thing
just
that
in
you're
this?
looking at. Yeah.
Oh, okay. All right. Well, it's tough when we don't see how they ended up wording it. You know what I mean? Like to have it like this is bare bones. So they've filled this in, like the jury's not getting it with blanks and name deceased and, act required to, all that stuff is all filled in. So, but like what I was saying, what I really want to talk about is, like I saw a lot of comments starting when the trial started, and I took umbrage with it just because I know how hard it is to try a case like this. And I'm talking organizationally speaking, just trying to keep your shit straight while your mind is racing, while you're trying to pay attention to a direct examination, while you're trying to take notes, while you're trying to look at the exhibits that they're referencing, when your client is saying something to you, like when you're trying to find shit on the computer. Imagine one person doing that. And maybe it'll give you a different frame of reference in terms of like where she was. Like, I just didn't think she was a mess. Did I think that she got lost at certain times? But yeah, but it was excusable. Like her biggest mistake was going to trial without a second chair. That's it. Like that is to me, that was the biggest mistake in terms of what she did. I mean, the woman knew the case forward and backward. And when you're hiring an attorney, that's what you want. You want an attorney that knows your case, for she knew every fact forward and backwards. If they surprised her with stuff, and that was an early thing, babe, she'd be like, oh, well, I didn't see that one. Or, I didn't read that one. Or, and the judge pushed back at her early on. She's like, you had this for 2 years. I think it was a video. And she's like, no, No, I had to go into the prosecutor's office and I had to view it. So I
Yeah,
didn't
that
have
was
access.
the video of the actual
The
kids
actual,
getting,
yeah,
yeah. But,
right. So like I just I like that part of it, her being a hot mess, I disagree with respectfully. I just think that if you had an understanding, if you ever tried a case, if I put you in that position to try a case and you understood how your mind is working, where you're trying to think on your feet at all times during a trial, as a trial lawyer, I mean, that thing is like, there's no other, there's nothing I can compare to it. It's like you're in a completely different place mentally. You're so just engrossed in what you're doing. And then to not have somebody, like, if we're a trial, Allie's like, I need this, and this. Like, she'll lean over, she's like, pull me this out. Like, I need this, is the, you know what I mean? It's like, to not have that person is a backup to help you get your shit right. It's tough. It's a tough gig. So as far as that goes, Mrs. Smith, today has been so great spending the entire trial with Bob and Allie in the mods and chat. Is this going to be a regular thing? I'd like to stream some trials. To me, y'all, this trial was so important, and it's for primarily the reason that Smith argued towards the end. It's like this verdict potentially changes everything in this country in terms of criminal liability for parents. It really does.
all right, so take
It
that
really,
thing down, and I'm gonna read you
okay.
the actual, and whichever viewer had said they charged both is accurate. They did charge both.
Okay.
And what they said for the causation, which is what's I was trying to figure out, is
Now wait a second. Is this true? Could
what?
somebody confirm this? That she had a trial partner and they quit, like, in the middle of the trial? Like, I saw a dude there, like, one day, like maybe on the first day. It was a guy, right? So, like, are we jumping, or did I have to bust out the jump to conclusions, Matt? Is that what just happened there, or do we know that that's fact, MJ? Like, if it's not facts, if you're guessing, that doesn't help me much. Oh, umbrage. Yeah, I don't talk about the Johnny Depp trial as much because, like, I just wasn't as fascinated with that as you guys were. Like, it was like a movie star fighting with his movie star girlfriend, and like, her calling him a shitty dude and him taking umbrage to it. I don't know. Like, I know the world loved it. I just didn't. I watched it, some of it. I didn't. It would, like, just the ramification. It was like two people airing their dirty laundry, and like, it was like a soap opera. Like, it's probably why the world loved it. This has a whole different significance in the world on all of us that are parents. And that's where I really wanted to like stream this today. And when I found out that it was going to be like fresh, starting with the cross, I was like, oh yeah.
Okay.
All right. So you want to go through that, Bay?
Yeah, it just goes on to say that there's, there can be more than one cause of death, and it's not enough that the defendant's acts made it possible for the deaths to occur in order to find the deaths of, and it lists all the kids' names, were caused by the defendant.
Send it to me so I can put it up? It'll be easier for our viewers.
No, it's blurry. It's a screenshot from a screen where you and Jay finally moved your heads for a hot second.
Oh, yeah.
You must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's acts. You have heard evidence that the defendant's son shot the victims. As previously noted, there may be more than one cause of death, and the defendant's actions or inactions need not be the sole cause of the harm. In order to find the death of these victims was caused by the defendant, you must also find beyond a reasonable doubt that that her son's act of shooting someone was reasonably foreseeable?
See, because you
I
strip
think
everything
shooting
away.
himself is someone. I mean, that if I was back there as the juror, I'd say,
Yeah, but to like that, are you relating that to the text, like "Don't do it," the "Don't do it" text?
when did
Because
that
that's after
text happen in time?
after she knew that he was shooting.
After she
Okay,
found the
so
guns missing. After she found the gun missing.
after she found out that the school shooting had occurred. So after she
Those
found out the guns were
two
gone,
different questions. Before if she finds out the school shooting,
it can't.
is it
I answered it.
before or after she looks for the guns? Okay, so after.
It's after she found out that there were people injured.
And
That there was a school.
after that she knew the gun was gone. That's the question I'm asking you.
I don't know. Like I'm
Wow.
assuming I think she went home. I don't know. And somebody in the chat, like if you know the answer to that, did she, in terms of when did that occur? When did she finally go home to find out that the guns were missing or that the gun was missing? And like, I know that text definitely came after the time in which she was told that a school shooting was taking place.
All right, I
And
sent you the
like, so
picture.
and I'm assuming that it went after she. All right, so wait, people are starting to answer.
And I also people wanted to read that again, so I sent you
She
the
texted that after she knew the gun was gone. Okay, so at
okay.
that point, she knows the school shooting is taking place, and after the gun is
And
gone.
she knows guns.
So, like, is that what you're arguing in terms of like that's after the fact? That doesn't mean shit to me.
Well, that's why I
You
was
know
asking.
But what I'm asking is that what you were referencing, like her knowing about the suicide or her potentially thinking he
I
was
just don't
suicidal?
well, if they find that there was enough to think after she read that she thought he might harm himself with the weapon, that was a reasonable assumption for her to make, I think that they could find that the elements have been satisfied.
But that's after the fact when she couldn't have
I
done anything.
understand. I'm just saying, if based on everything else that they knew, even though they couldn't in a million years imagine him going into the school and shooting people, if she could have imagined the possibility of her son hurting himself with that same firearm, it could satisfy the elements.
Yeah, but I at that point in time, like her rationale behind that is that most school shooters end up killing themselves. That's why she thought that. That wasn't her thought going in. As she
I
sat in the
know that's what
office and did the math sheet, I don't think that she thought that he was a school shooter or suicidal. Like,
right,
and
and
to
I
me,
think
that
it's
was
possible a jury could say that it was, well, I sent you the thing because people do want you to put it up, but that it
okay. Yeah,
was
and JD Coop, like I don't know why they did that. Like the fleeing was stupid. Like to me, it was completely irrelevant. It didn't show shit. They weren't fleeing. They turned themselves in the next day, and it's like fleeing from what? You have to
right.
know what you're fleeing from in order to flee. As Jay said, this is not Donna Adelson buying a one-way ticket to Vietnam. Like it was not that. It's like, I mean, it's so hard, and God forbid that anybody in our chat or anyone that we know is ever in this type of situation. But when your entire world collapses in on you, I mean, like I'd probably want a little time to try to figure out what in the fuck we're gonna do. Like I probably don't want to be put in custody immediately. Like, I probably want like some time, like a little bit of time to try to figure it out.
Right.
Yeah, I don't know. It's a really tough case. It's for me. All right, so did you send it to me?
Yes. You know what?
Okay.
Their
How did you
legal
say?
duty statute says that a parent has a legal duty to exercise reasonable care and control to control their minor child as to preventing the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others.
Oh, wait, hold on.
You couldn't
Sorry.
hear me?
I could. I had to turn I'm trying to do something special for I'm so incompetent tech wise. It's so ridiculous. All right, so hold on. I gotta get in here. It's gonna be worth it. It's gonna be worth my ignorance of all things tech. All right. You keep going. I'm gonna put that up in 1 second, but I want
Well,
to do
it
something in the intro.
just solved my problem because the legal duty is to prevent them from causing harm to others, not to
Oh my
themselves.
God. I can't mute it. I don't know how to mute it. Stevie, if you can gift the memberships, can you just gift them? Because I can't figure it. The host is
I muted you.
unmute. Oh,
I muted
no,
you.
it's picking up our YouTube stream because I wanted to every month I get to gift 10 memberships to like people that are in here. And I wanted to do it, and I have to open up the thing. And Stevie's like, "Well, mute it." And I tried to mute it whatever. Stevie, if you can do it, can you just do it for me, buddy? Thanks, man. Because I want to gift out some memberships to all our beautiful people that are with us today. All right. Let's see. How did you send that to me, darling?
Email, because
Text
that's
or-
what you asked for because you don't have access to.
Thank you. Okay. Okay. I'm not seeing it.
Yep.
Is it big?
It says screenshot.
Yeah, I haven't gotten it yet. It's weird.
So the actual statute that they're using here, again, your faces were over them, for gross negligence is not the same one that I had put up there. It just says that it's more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find the defendant was grossly negligent, you must find the following three things beyond a reasonable doubt. First, the defendant knew the danger to another. That is, she knew there was a situation that required her to take ordinary care to avoid injury to another. Second, that the defendant could have avoided the injury by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injury. I can't see because your face is there. It must have been apparent that the result was likely to be, it might say serious injury there. I don't know. But it's slightly different than the
Yeah, your
gross-
your email hasn't come through yet. I don't know what's going on. It's probably because you're in the basement. Probably didn't send. I don't know. I'll wait. It'll show up eventually.
All right. Well, let's start talking about something legally then.
Okay. Well, I think like while we're waiting for that to come through, I want to hear your critique of the closings. I've asked multiple times now, and you keep jumping back to the statute. So,
well, I thought that the arguments. I mean, yeah, it dragged on a bit, but her point was, look, you had somebody. She started with the stating that in the defense did that they had a witness on the stand that said more information provides more context, makes me more well informed, blah blah blah, with the example of how he thought the parents walked in together, then he watched the rest of the surveillance tape, and da 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 da. So that was like all of what she was doing after that was showing them they showed you this text out of context. Here's the context. They showed you this one. And I think that I do think that her, assertions about, because it's true, right? Like, our if one of our kids is acting like a psycho, we might text each other that, like, she is off the rails psycho, screaming her face off because, and for example, we'll do, um, I didn't get any food, but maybe, but what she says is like the food that you wanted, and like, do you know how many times that the kids are like, you don't love me if you don't walk over at this precise moment and do what I'm saying. Um, so I do think she scored some points with that. And I think they're gonna struggle, with
Oh,
the willfulness. I mean, to me,
aspiring, I got you. Thank you. All right. So, like, they were screaming at me to look at my Discord because, of course, my mods took care of us in here. All right, let me see.
parents are typically vicariously liable all the time. Like, I've always told all of our kids once they hit teenagers and they think they're having, friends over when we're not around. And I'm like, you realize that if you sneak in my house and you are letting your friends drink in my house and then they drive from my house, we will all lose this house. But it really does have to be that you had some knowledge. So if I had known that my teenager caught them on another occasion. It's like the first dog bite kind of scenario. But I caught them with the kids drinking when we weren't home. And then down the line, a kid leaves my house and gets in a drunken car accident. I am legally responsible. I knew of the possibility. And what did I do after I found my kid drinking? Did I take precautions to lock up all the drinks or never leave the kid home alone again? Or, so yeah, it's an issue in every state. I found it strange that they don't have a legal duty to prevent their child from hurting themselves.
Yeah. I know. All right, hold on. Keep talking. Like, I'm doing some like tech
Okay.
shit here. I'm trying to figure
Um,
this out.
on any event,
Everything's
I really did think that the state's case overall, maybe not necessarily the closing, but the state's case, it undermined all of the things that really did point to, her having some form of notice that her kid was struggling, and that when she saw that those notes on the test, that should have made her think that there either him or someone else is at harm from that gun. Let me make sure it's not here. Um, to me, the not checking for the gun after that, I do find, somewhat unreasonable. I feel like even if everything else was reasonable and you knew you didn't really think your kid's gonna shoot anybody and blah, 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 all the other things in your head would be like, "You know what? Let me just make sure the gun's actually even extra super secure right now." Because, you know, whatever. Like, you don't want him going out and doing something stupid with the gun, whether it's kill someone, like, it doesn't have to be that extreme, but, like, he's not in the right place. Guns are dangerous. I'm gonna check and make sure that my gun is extra secure because he drew a picture of a gun on a piece of paper that said, "I hear voices. I can't stop it. Help me." I mean, again, to me, just that, but does it rise to the level of willfully, you know, ignoring, which is why they put on all that stupid stuff. And no, none of that, none of going to work, none of talking to a friend, none of that amounts to willful. It was either she disregarded, a very clear sign that if I don't go do this thing, and I don't know that a suspicion is legally enough, but I know what I think morally reasonable is that if that happened and you didn't do any of the other things, you didn't, you guys all decided the kids stay in school, blah, blah, blah. You just go check and make sure A, the gun is home, and B, it's extra super secure during times when your child seems emotionally, uncertain, to say the very, very least. But
Yeah.
again, to take up base, because you're still doing that, the state's
I
whole
for hours.
no,
I
I'm
don't
fine.
know, like,
The state's whole thing about her background and her texting and her courses and her this and her that, it just it undermined everything, and I thought it was, like, that would make me on the jury feel more like what the defense was saying for every other parent at home that this could happen to. Um, you know,
all
can you
right, so
make that
let's see. I mean, I'll try. You're asking me to move mountains there. Let's see. I think
yeah,
I
you
don't
can.
know. I don't know that I can. So
Right.
I'll read it because this is coming right from the Discord. It says involuntary manslaughter theories and elements. Okay, so gross negligence in the performance of a lawful act. 1, defendant caused the death. 2, in doing the act that caused the death, the defendant acted in a grossly negligent manner. All right. And
To me,
then
that one's impossible, personally.
the defendant, for which part? That the defendant caused the death?
Yeah, that they
Or for
did even what
doing
I
the
don't even know which omission could have caused the act, could have been the act that caused the death. Like, it's still not, it would have to be something like, I packed the gun wrong, and then someone went and used the gun and shot someone, and it splurted out and it hit everybody on the sides. But, I mean, they clearly had, you know, a jury instruction conference, and the judge allowed both theories to be put forward to the judge.
Okay. All right. And so I agree. So the second theory is gross negligence in failing to perform a legal duty. Defendant had a legal duty to the victim.
We read this one, yeah.
I mean, did she? I don't know.
Well, you have a
Defend
legal. I just told you the statute says you have a legal duty to control your child to prevent harm from others. So yes, she had a legal duty.
Okay. All right. So defendant knew of the facts that gave rise to the duty.
That's kind of built in with, was it willful? Did she have enough information to make her know that her kid was posed a risk to others such that she needed to do something?
Okay.
So
3, defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life.
that's the question. Was she willful? And to me, the fact that the school let him stay, they were going to let him come back, I think, for the next 48 hours, like, as long as she got something in 48 hours, that they didn't check
Yeah,
the
3 is the element that's tough to, like, that's good. That's what they're going to be stuck on for sure, because it boils down to that. Like,
and two, did she know enough? If she knew enough, then it was willful, wasn't it?
I don't know. I don't know. Like, because it boils down to that thing that I keep saying. If somebody hands me that paper, I'm fucking taking my kid out of school, period. I don't give a shit what anybody's telling me. I don't give a shit what a counselor's saying. I don't give a shit what a principal's. I'm taking my kid out of school, and I'm immediately taking them to get help. Immediately. Like, no one's telling me otherwise. No one knows better than me when it's
I
regarding
want
my
you to
children.
scroll down to the
You know what I
next
mean?
picture.
Okay. But, like, that's what this thing is boiling down to. Which one? The causation?
Yeah, that's the one that I read, that I did email you separately, so you'd have it big, but
I just told you the email didn't come through, honey. I still don't have
all
your
right.
emails. Still. Like, did you email it to what? Like, no, I don't have it. I'm getting other emails. I didn't get
It
yours.
went to your law firm email.
I was looking at all the email, all the inboxes. I got it. Is it bigger?
Yeah, it's just the picture.
It looks the exact same as this one, like
We'll
identical.
crop
actually.
it, and then it'll be bigger.
Nah, well, I think we can just we can read it. Like people can just put their glasses on. Like that'll take me 10 minutes to do that. Are you kidding me? Cropping it. Like where am I cropping it? I'm gonna go into some program and crop it. Stevie, are you here? Can you crop things for me? All right, causation. There may be more than one cause of death. It is not enough that the defendant's act made it possible for the death to occur. Okay. In order to find that the deaths of Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. So, like Charlotte had asked about, like, kind of like there is an element of vicarious liability to this. You know what I mean? Because I mean, clearly she didn't do any of the deeds, right?
Yeah, that's what we just discussed, that there's most assuredly vicarious liability. You weren't listening. I went through the whole.
No, I
like,
wasn't. I was
kids-
trying to figure
right.
out tech things.
I gave them the example of kids drinking at the house, and then you're not home and someone leaves.
Yeah. All right. So you heard the evidence. Defendant's son shot Madison Baldwin, Tate, Hannah, and Justin. As previously noted, there may be more than one cause of death, and the defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting, this is where it is, was reasonably foreseeable. I think that's what it says. Like
shooting someone
was reasonably foreseeable. So that, all right. And then the third one is the negligence. JJ's head in my head. So gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three elements beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, that she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, the defendant could have avoided injury of another by using ordinary care. And three, the defendant failed to use ordinary care to prevent injuring another. What do you think that says? And it must have been apparent that the result was likely to be serious injury or death. So, like for all of our folks out there that like to like jump to verdicts and, you know, oh, guilty, guilty, guilty. We want you to put on your jury hats. All right. Because when you're a juror, you don't get to go on your gut. You don't get to go on your feelings. What you have to do is you have to go by the law. All right. Now we've read you the law. So first you have to be able to understand it. And do you guys feel like you understand it based on what those duties are?
Well, you've got 233 votes and 52% are not guilty. So,
wow. I mean, you know, because like I think the biggest like the only thing that moved the needle for me at all, because to me, this entire case is about that piece of paper and what happened in that office that morning. The rest of it is all white noise that I don't give a shit about. Like if I were sitting in that jury, if I were the foreperson of that jury, I'd be like, nah, I don't want to hear any of that. We need to talk about this document. And I would have taken a poll of everybody in there in the jury room. And I said, okay, if you're handed this, like pretend like this is us and you're in the principal's office and you're handed that with your kid sitting next to you. What are you doing?
And I think all the jurors would say we would take our kid home, we would check the gun, but then they'd go back to the jury instructions and they're going to say, was it willful? And they're going to talk about how it's bullshit. It's complete bullshit that the school told her to take the kid home and she didn't take the kid home. That's not, I've never in my life had a situation where I could tell the school I'm not taking my kid home. If I do that, the kid's either, if they're sick, sitting in the nurse's office, or if they were being disciplined, sitting in the office. They're not
Well,
returning to class.
Beyond that, it appears that the school with the trained counselor told her that they didn't think that there was an issue. I mean, that's what moved the needle for me. That statement, if true.
In the state's rebuttal, they said no one ever said anything like that. That there was no. I didn't get it. I was tried to put a comment and it wasn't letting me comment at that point.
Well, that is like huge to know whether or not that happened. Like either that happened or it didn't happen. Like, because like what I'm saying is I don't give a shit if they're telling me that there's nothing wrong and that it's fine. I'm like, I've got eyes. I know my kid's in peril. We're out of here. You know, like there's nothing that anybody would have been able to tell me to keep my kid there, period. It's not
So
debatable.
I was kind of thinking about it. Is it possible that she did just get angry, thinking he's screwing around, taking a test, drawing pictures and writing stupid stuff? But the topic of conversation seems to have been his mental health and that he needs to get his mental health evaluated within 48 hours. So for her to be left just thinking it was him, effing around, drawing pictures like he's a video game. But then again, is it so outside the realm of possibilities for her? And I'm going to stick with that he was going to kill himself. That he, that it didn't even occur to her. I think it's clear we're going to have a hung jury. That's what I think.
But for the words, I can't stop the thoughts and help me. I might buy the picture bullshit.
That's what I'm saying. I can't. I couldn't look at that and think anything else than, first of all, that what she really did is destroy. I mean, obviously, kids are dead as well, but she destroyed her son's life by just not getting him the help that he needs.
They're dead because she didn't do what she should have done.
And now he's spending the rest of his life in prison. He did it. It's his fault. And it all could have been avoided is all true.
I mean, temporarily, unless she takes him home, doesn't get him help, continues not to get him help, is just pissed off, is like, oh, you got me like I was at work, you little asshole, and now you dragged me over here drawing this stupid shit. Like, I mean, if that happens and she doesn't get him the help, then all you've done is postpone the inevitable because she's not getting him the help.
Right. And that's why I'm saying legally, I think I would have my doubts. Okay. Reasonable doubt. I think that part is clear, but morally, I kind of have no qualms with saying that she is responsible for both of those parents, and that school are responsible for those deaths and for the situation that the shooter found himself in. I'll say it. I've said it like 10 times and I will say it again. He could not have screamed louder. He could not have screamed for help any louder than he did. And it's just so sad that the justice system thinks that, well, we need to give these victims justice by putting him away for the rest of his life when he's clearly in need of I don't know if he pled out as a juvenile. I don't know if you know that. if he pled out as an adult, I mean,
he pled out as an adult. He got, you know,
it's
he got
just
life. He got life
you
without.
got life.
Fuck yeah, he got life.
It's not his fault. I'm sorry. I don't care how many people I'm upsetting right now. He was hearing voices. He was seeing demons. He screamed and begged and pleaded all on that piece of paper. I don't care about anything else for someone, anyone to help.
I look, man. Like I agree. Like I mean, he was like, but didn't Shannon argue that he was never he was never diagnosed with any mental illness, and then still she said it in closing, and still has not been diagnosed with any mental illness.
Well, clearly he had a mental illness that was being unaddressed by his parents, who thought that he was just being silly about that whole weird demon thing again.
I mean, look, you and I are hypersensitive to mental illness and how the state and prosecutors ignore that it is a thing in the world. It's like our biggest. Are you frozen?
You are too.
Oh, I am. I think
Yeah.
you're frozen. Am I frozen? We
You
frozen,
are.
y'all?
Yes, I'm looking. We're both
I mean,
frozen.
I'm not frozen for me, but you're
Right.
frozen.
I'm frozen for me and you're frozen for me. So maybe you're not frozen then. Maybe it is just me.
Maybe it's just you. I mean,
'Cause I
like,
can't see the comments either.
I don't mind if we're, yeah. So like he left a dead bird head in the bathroom at school. You know, I mean, everybody failed that kid. Everybody failed that kid. Everybody failed that kid. You know, that kid was left floating in the wind with just strife with mental illness.
I mean, in my heart of hearts, I feel like if that child under these circumstances did that to someone I loved, because I can't even put the words to say to, like, you know, but that I would be of the same mindset, that as much as I want vengeance and retribution, this kid doesn't deserve to be in prison for the rest of his life. He needed mental, you know, health treatment, and still needs mental health treatment.
I'll tell you what, like this freezing thing, like that's where our set's going to be for the morning drop is a real issue. Like I don't know how to fix it. Like you were on the,
We're gonna have to get a tech, somebody better than just we have to figure something out.
I mean, you're on the basement arrow. I'm looking at it. Your MacBook Pro 6 is on there.
No. I'm on Darren's.
Well, I don't know. I guess it's his. Why don't you bring yours down there?
Because he had this one all set up with all the
Probably all
equipment.
filled up. Nah, but his is filled with all kinds of like memory is gone. Like that causes that's an issue. It's the same thing that was going on with
He's
your
got the new computer that you just bought me, doesn't he?
Honey, we've had we bought that when we started the podcast 2.5 years ago. It's not a new computer, and it's filled with all of our 150 episodes of podcast stuff. It's like,
all right, let's move on because the people don't want to hear about this.
Well, you're still frozen. Is she still frozen for you guys?
That's all right. They can hear me. Click on the start and start asking people.
Okay.
Answering the questions that people have. Don't start thanking people yet. Save the thanking. Just
a pretty good picture though. Like you could have been frozen much worse.
I'm reloading this.
All right. All right. So Charlotte, $2 hollow. I think we answered that. So is that oh no, we didn't. The proximate cause. I mean, I think so. You know, I mean, like, it's just not an easy deliberation for these jurors back there. It's really not. Like, because it's not like your typical straightforward answer. Because we can't pretend for 1 minute that the reality and the weight of the decision that they're making in terms of how it affects all parents, and then factoring in like the whole reason, like Allie was saying, with respect to why Shannon was putting herself about all the shit that she doesn't do, and that, like, I could so easily be in that chair, was so that when the jurors are back in that room, that resonated with a couple of them, because a couple of them will say, you know what? I mean, she's not wrong. She, like, that could be like, if they were to look at my text, like, I mean, it's like it could be any of us to a certain extent, up until she's handed that paper. That the paper for me, oh man, I don't, like, I have to be honest, if I was in that jury room, I don't know what the hell I'd do. Because I'd be thinking about, am I ready to drop this bomb on the rest of the world? Is the rest of the world ready to have to deal with the fact that now every parent is potentially criminally liable for their actions of their children when they're out of their presence? And it's like, it's a very slippery slope, y'all. I'm just telling you. I mean, it's super easy to sit here now, when we have just the absolute tragedy that occurred in the immense loss of life in that situation, but it doesn't have to be that serious. Meaning that if this guilty verdict then sets a new precedent for prosecutors being able to prosecute under these types of statutes, not even for homicides, but just for other negligent acts, that are criminal by their kids, and you're now on the hook for everything that happens, and they're digging through every aspect of your life. And like, Shannon made a lot of good points, when they're pulling things out of context and just putting, like, cherry picking things out of 10,000 text messages. I mean, if Allie and I are texting, like she just got out of court, and I'm like, oh, will you pick up breakfast? And she's like, oh, yeah, what do you want? Oh, the regular vote. I mean, that's 75 texts right there. You know what I mean? It's like, to cherry pick. Did you just, are you still on Dee's computer?
Yeah.
Oh, okay. Is the mic plugged in? You sound muted to me.
It is.
Oh, no, you're good.
Yeah, I just had to lean in.
I don't know that there exists any, unless we just got a new question.
What are you talking about? Did you answer this one?
Which one? Is it the proximate cause?
No.
No, this one just came in. Charlotte Cross with another $5 holla. Well, that's why I'm asking about the vicarious liability. Civilly, I can understand it, but criminally is a much higher burden. What do you think, Allie?
Well, yeah, it definitely is a higher burden. Yeah, I don't know. I guess, I mean, if it were happening enough, then I guess in the same way that they just did, I mean, they have a legal duty statute. That's what their involuntary manslaughter is specifically based on. So, and I think that would carry over to anyone. It's definitely a higher burden, but it's doable. The question is, did they do it in this case?
Yeah, but I mean, civilly is preponderance of the evidence. It's a much, much lower burden.
Right.
I don't know. I don't know either. I don't, like, it's not
It's not vicarious liability. It's literally you're being liable for your own omission if you had a legal duty to act. So
right. It's like a form of vicarious liability. It's like it's not exactly that, but it's
Right.
like, yeah, it's like it's really the omission. It's like they're not the actor. They're not the one actually committing the crime. It's that same but for analysis. But for her not taking her kid out of school, those 4 kids.
I mean, but for her not checking on the gun. I mean, it could be multiple but fors.
But wait, like, checking on the gun after she's left the school and left her kid there?
I don't know how long did it take until he left that office until he started shooting.
I don't know. Like,
I don't think the leaving him at the school alone under the law was enough. That I don't think. To me, it's the not going home and checking on the gun.
Well, I can guarantee you that there are going to be jurors in that room that are going to be screaming and hollering about that school
Oh,
and how
yeah.
those MFers didn't do shit. Like, how could
Right.
this principal not open up that backpack? How are they, saying that it's okay for him to stay there? I mean, it's like she's
you'll have
taking all the heat, but in my world, they're equally at that moment in time as culpable. I can't
That
obviously.
was a very strong argument she made on in closing, was that they have all this knowledge, and she went through the knowledge they have. The girls in the dresses at the prom or whatever, taking pictures with their guns. The preschool whatever day shooting where they've had to remind parents, don't let your kid, come to school. That's why it's like, I was almost thinking, where does this prosecutor live? Because doesn't she live in an area where everyone takes their kid to the gun range? I mean, if that's the type of, like environment that I'm in, the way I live, whatever, now you're complaining that because she got her child a gun responsibly and that they took them to the gun range to train him and make sure he knew how to use a gun and use a gun safely and appropriately, that somehow meant she gave him a gun to be a killer. So I think that played their arguments, and as did the argument that, like, he was so excited when he shot the target in such a proficient way because now he knew he could be a really good killer, as opposed to, but I don't know if it was days before, maybe that was in his head, but why would anyone assume anything other than he's excited at how good he got? What about
Well, that definitely was in his head because they showed what his journal said. Like, he had planned it. He's like, I'm tomorrow's the day. Like, I'm committed to this. Like, this is going to be the last day for many people's, the last day of many people's lives. Like, he wrote that shit, some haunting, horrible shit, and it's like, Jedi with the $10 holla. Thank you. Mom and dad had more concerning info than just the math quiz the school had. His gun, audio and visual. But like, if we were to buy the defense's theory, the audio and visual hallucinations, depression, pleading for help, etc., like, they weren't feeling it like that. Like, I mean,
it seems likely, when we're not talking about a legal standard, okay, based on the kid putting in his diary, my parents won't get me help despite me asking. He at least felt that way,
he
and
texted buddy. Like, I think that was actually a text message to his little buddy that moved away.
right.
Like,
And the fact that he's telling them, like, these things only happen when you're not here, the demon's back. It does seem, right, counterintuitive that a parent is not going to, like, have that's not a discussion that has gone on outside of that. For him to be texting it so nonchalantly, like they are fully aware what he's referring to, leads me to believe that he has discussed that with them in the past, and she doesn't just think that it was some Ouija board demon in his head because she turned the lights off and he thought he saw a ghost, and has forever since been joking around about how this ghost is doing these things. Like, those things lead you to believe they did know, more information. But as far as legally, whether there's reasonable doubt, it's hard to say that there's not. And the reason, Joanne, I keep going back to the math quiz is because, to me, that was enough to tell a reasonable parent to, at a bare minimum, go check the gun. And I don't know if that would have been enough time or not, Bob, based on what you're saying. But, it's just,
well, I don't know. Yeah, that's a good question. I don't know what the time frame was from meeting to occurrence. I don't know. I would have to think that in Ethan's mind, he's thinking, "Oh my God, that was a close call. They almost thwarted me." That he might have gotten busy right away. You
I
know,
mean,
maybe
he's going to have
maybe
the possibility.
I don't know. Yeah, I don't know.
He'll have the possibility of parole. Did they say how long? Because you can't give a kid life. It has to be something years to life.
I want to say they gave him life, like we were just talking about the Supreme Court case. I know, like I'm telling you,
I mean, you
like
can't.
I'm telling you.
All right.
I'm gonna try to look it up.
It could be 20 years to life, 30 years to life, 40 years to
Annie.
life.
Let's see.
I mean, he's still a child. That they absolutely can't. No, somebody wrote no parole. It is unconstitutional. That.
No, that what I'm trying to tell you is like it was like I was stunned when I saw it. Oakland County Circuit Court Judge Kwame Rowe sentenced Ethan Crumbley, 17, on Friday to life in prison without the possibility of parole.
What?
Yep.
And has anyone discussed that? I don't understand how that's
Not violating.
possible.
I mean, the Supreme Court just came down on this thing.
I mean, that was years ago. It was like 10 years ago. Maybe before we moved here.
Just
Like,
no way.
I think it's Miller. I think the case is Miller.
No, we were here because like that's when that like Muti was texting us. Oh, they just got rid of that. Annie, $5 holla. Thank you very much. Excuse me. Boy, 8.5 hour stream. I mean, and like I'm gonna tell you right now, if we're not over 12K after 8.5 hours, I'm quitting the YouTube channel. That's it. Like, I mean, what does a guy have to do?
Somebody asked if like you want subscribers, and isn't that about money? No, subscribing is free.
Subscribing is free.
just
Liking,
a click.
sharing, subscribing, all free, all easy.
And it's not for because it translates into money for us. It translates into our show getting the
More
whole
traffic.
algorithm thing, right?
The algorithm. It gets us out there. It gets us like put in like in the algorithm. So like when people are scrolling through YouTube, we'll pop up. We like our content. We
In
think it's
2012, the Supreme, yes, in Miller versus Alabama.
I mean, no one's doubting your brilliance. I certainly wouldn't. But I mean, like I'm
29
saying,
states.
that was
29 states currently have the law.
oh,
I
Michigan,
mean,
Michigan ain't one of them. And just for the record, that was 6 years after he moved here. So, Annie,
I wasn't
$5
sure.
holla. I'm hung up on this, and many disagree. But what about minors in gangs that commit gun violence? Parents know they're in them, and they don't stop them. It's interesting.
I mean, it's the exact same argument.
Exact same
It is
argument.
the exact same. I mean,
It's identical. It's an identical argument.
identical. I mean, that would be all of the parents of all of the kids in gangs and all of the
Right.
world.
Right. And,
I'm sure there's some who surreptitiously, are it's like they're secretly doing it, but
I mean, yeah, I think it's like you're gonna know if your kid's banging, unless you're, single mom, 4 kids, working 3 shifts, just trying to survive. I could see how it might slip by, but I think that most parents are aware. It's a very valid point, Annie. I do not I'm not hung up on it, nor do I disagree either of those things. Oh my God. Oh, look who it is. One of our always givers, Shiraz, with a $50 holla. Man, you're too much. Like when you're in Chicago, let me know. We're taking you to dinner. I'm not kidding.
I'm not. I'm just kidding.
What a jerk.
Do I know you?
Oh, Stevie with our money sound effect. I got so many great sound bites, Stevie, if you're on that game that I've got for like the money things that like are next level that are so good. Charlotte,
Wow.
EC had a Miller hearing, still got about the possibility of parole. Huh. Interesting. I don't get it. How? How'd that happen? I don't get it. I don't get
There was
it.
another holding in 2021 where they said the court subsequently decided Miller, which held that the Eighth Amendment permits a life without parole sentence for defendants who committed homicide when he or she was under 18, but only if the sentence is not mandatory, and the sentencor therefore has the discretion to impose a different sentence.
Oh my God, we're 7 away. 7 away from 12,000. All right.
Come on, 7 of you, 301.
I mean, for real.
I'm sure all of these people that have been here this long, I mean, come on, have
Buddy, if you're here for 8.5 hours and you haven't hit the subscribe button,
I can't believe we're here. And now you wasted all these hours you could have split up with me, having me at your disposal while I'm sitting up there.
Oh man. All right. So the recent tally is 47% guilty, 53% not guilty. I mean, I almost want to do another poll.
All right, I'm done with these polls. We're saying our goodbyes.
Yes, ma'am. All right. Yeah, this has been phenomenal though. I had so much fun doing this, babe. I'm so thankful that you jumped on with me because I know you really are trying to get that thing done.
I had to earn some brownie points for.
I mean, it's not like you're sitting there picking your butt, man. You're working on a post-conviction relief act thing, so it's like, I know it still makes me sad though, because I miss you when you're doing that.
I really feel like
here, but you're not there.
I think we should tell the people in Michigan when their hearts calm down that they need to all call their local representative's office and email incessantly and call incessantly that a mentally ill juvenile should not get life without the possibility of parole.
It's so hard though. Man.
I mean,
it's like
I think that the families would have been equally satisfied with, 30 years to life, 40 years to life, or life with the possibility of parole.
I don't know. If it was my kid, I don't know. I mean, I don't know. I can't I always say it. I can't even put myself in that mindset of trying to imagine what that's like to be one of the victims.
Me neither, but I hope in my heart of hearts, I hope that when I calm down, if these were the facts I was presented with, that I was at least at the bare minimum asking for there to be the possibility of parole.
Yeah, no, I mean, I hear you. Right, his culpability in terms of him being the trigger man, obviously we all get that. But in terms of the circumstances surrounding it, it's like, how much can you put on the kid, man? I don't know. And I saw Stevie had commented deep in the chat, in terms of it, is it a nature or nurture thing? And it's like, I agree with them. I think it's a combination of both. I think it's both things. I don't know what makes us, why mental illness is so prevalent right now. It's just, it really is. It's like, I always think back, I'm like, all right, in the old West, when life expectancy was much shorter, but they just, that was for a myriad of reasons. Did they have,
I'm sure they did.
a rampant, why are you sure they didn't have this?
I don't know about rampant. I take it back.
these are little boxes of radiation. You understand that, right? Like when your phone is
Suffered
heating up,
from
literally,
schizophrenia. I mean, think about when they first started putting kids into like homes and insane asylums if they acted weird. You know, like this
or
been going.
burning women at the stake because they were getting a little feisty and they thought they were witches. You know what I mean? It's like I don't like. I like
Oh, I gotta
I
take
can't
this.
I can't trust history. All right, I love you.
Love you.
Dump off. All right, thanks, babe. All right, y'all. I'm gonna start shouting out. And you guys were so incredibly generous today, and we absolutely adore you. And thank you so much for the support. Lily B with the $20 holla. Subscribe. Yes, thank you. Ashley, you're the best. And we thank you for supporting us. It means everything to both of us. You know, because it's a lot of work, you know, between the podcast and the YouTube thing. It's a lot. I'm working more hours than I ever worked as an attorney. I'll just tell you that right now. That's facts. Like that is gospel. And you all know how much content we put out. Like I put out a lot of content. So your support is huge. Jen, $10 holla. Love you back, girl. Thank you so much. Shiraz, after she gifted $50, she then gifted 20 Defense Diaries memberships. You're unbelievable. Thank you so much. Like you're like on the pedestal of like the always giver queen. Because we got a bunch of always givers who always give. Jen's one of them. You are the queen of always giving. I mean, it's unbelievable. Thank you so much. Charlotte of Cross, like I adore you, Charlotte. She's plugging her way through in out there in California, soon to be. When's that bar coming up for you, girl? Soon? Seems like I think you said you're 3 L's. Are you guys 3 L's or 2 L's? But you're getting there. You're getting there. And I love the way your mind works. I hope you go defense side. I'm not gonna lie. We need folks like you on the defense bar. I'll tell you that. Annie for the $5 holla. And I think we covered all the questions. So I just want to give the thank yous. Thank you for your support. Jedi, I love you. And you're always, you're another always supporter. So we appreciate that beyond. Charlotte again with the love, with the $5 holla, the $2 holla. Debbie, another always supporter with the $10 holla. Charlotte, she's been in for a couple months. We appreciate that more than you know. Again, like I was saying, Jen's an always supporter, gifting out 10. And I hope you all got those gifts from us because we love you. I hope people that wanted to be members and might be a little tight on scratch got those because we love having you. And we're trying to build this community up so that it's gigantic and amazing because everybody in here, every single chat, whether it be Jay's, whether it be ours, whether it be Publicly Buzz, whether it be Joe's, whether it be Shannon's, like we've got the best community out there, and I'll die on that hill. Here's us. Okay. Jolene, $10 holla. Thank you so much. Ivy O'Neill, thank you so much for that $5 holla. Jen, the always give a $20 holla. MJ, thank you. And MJ, you were great in the chat today. I loved it. I love the interaction in there. And I love this chat so much today because y'all really flexed your civility muscles today because this is one of those topics where people could, like get upset and fly off the handle, and get, and get to the point where, like tempers rise, and you guys didn't do that. You guys were cool the whole way through, and we appreciate that. And we want the community to be where everybody can come in here and we don't have to agree on the same things. Cause like, that's not how life is. Like Allie and I don't agree on everything, but we're able to discuss it and, she usually wins. So I deal with it. Midnight Arts, Dalahalla, appreciate you. Thank you so much. Teresa, $5 holla, appreciate you so much. Oh, Truth and Transparency, you know I love you. I got to come back on your show if you're still hanging in here. I had a great time over there. Thank you so much for that generosity, that $10 holla. Teresa, member for a month, thank you for being with us at all times. We appreciate you. Flipping Hot Hands, new member. Aw, family hug. Dawn Burr, 10 family hugs for 10 lucky members now. And we're so happy y'all are here. And thank you so much for that generosity. New member, TTJO Tracy. What up? Welcome to the fam. Fam hug. Aw. Katrina, thank you so much for becoming a member. And I liked it. Katrina was in there. Katrina had a position in there, and I respected it, and I saw it. You were seen. I saw you. You know, I mean, you've got a high bar for parents, and I respect that. You know, I do. I think that we have the duty. I think that there's nothing more important than what we're doing on this planet than to parent our children. It's the purpose of why we're here. It sure the hell isn't going to some 9-to-5 job or some whenever the hell you work. It's not biding time to make money to buy shit. It's not the reason we're here. Like, there's no bigger responsibility than we have than to raise our children. That's my opinion on it, at least. Bonnie Bailey, member for 1 month. Thank you so much. And everybody loves you back. Ginger Snaps, thank you for that. Just continued support of 3 months in the books. So I'm assuming that the mods have gotten tiers for people. Like, the longer you are in, the cooler the emojis. Like, I like that. I think that's kind of a cool thing. Missy Mayhem, another, and you know we adore you, and you're one of our mods. Like, I love you for so many reasons. It's too many to list. And everybody go over to Kick, check out Missy Mayhem's stream. She's great. She's great. She's a digger. She's a digger. She's a true crime digger. So if that's your jam, go over there. Peep it. Debbie, $5 holla, super sticker. Joanne, always appreciate you with the $2 holla. Dom's mom, 725, gifted 5 out. Like, you guys giving out the memberships today was huge. That's so amazing because you're building the community. Not only you being generous, but your generosity is extended to other people. You know, that not everybody can afford $5 a month. I mean, that's the state of our world. It's just is. So I'm extremely grateful when you all do that for others. It's very kind. And Mama K Marquetto, thank you for becoming a new member. We hope that you hang around for years and years. Janet Studdard, thank you for that $5 holla. And I feel confident that we got to all the different questions. I feel pretty good about it. Fids, we read your comment and I concur with everything that you wrote. I am Team Allie myself, and she's amazing. And I'm a huge fan of women. I always vote for women. I want a woman. Women should be ruling the world. That's my opinion on it. No one's changing it. If you guys haven't figured out, no one changes my opinion on anything. Kristen, $5 holla. Appreciate you so much. Thank you for that generosity. Miss J, thank you so much for that $5 holla. Gypsy Soul, Gypsy was on for a long time. If you all have been on for as long as I've been on, you're heroes. Midway through, I actually did lose my voice. Thankfully Jay was there to pull me through. Thank you so much, Gypsy. Shelby, thank you so much. We appreciate you too. And I loved being able to address that, because you're kind of like her being a mess thing was something that was kind of nagging on me over the past 5 days. When I was in the law and crime chat, I'm like, oh my God, everybody was just hating on her. I'm like, man, there's it's you have to take into consideration just how tough that job is, and especially in a trial. But I still want to know the answer. If she did have a trial partner and that person actually did quit, that would be a thing. Then I'd be like, And I did ask her, I emailed her during the stream. I want to try to get her on. And you guys better be nice. Be nice. Missing and lost. Thank you for your question. $10 holla, Jeepsy Soul again. Maria, thank you for that $2 holla. Galen with the $20 holla. Thank you so much. Renee, $10 holla. $5 holla from the Royal We. And I'm assuming that comes from the Big Lebowski. I can just hope that's where that amazing moniker comes from, that handle. Stevie, you know I love you. Thank you, brother. Support with Steffa. Thank you so much for that $10 holler. You were super active. It seemed like you had to bounce, probably had real life stuff going on. Galen with 10 memberships gifted out. We got a ton of new members that were gifted memberships, so we're super excited about that. And thank you all for doing that. Pavitra P, $5 holla. Hopefully I'm not butchering it. I think I'm moderately better than Steve at reading names. But it's not to say that I don't butcher them sometimes. Donnie became a new member today, which was super exciting. Debbie with the $10 holla. Ricky Cougarback, which is, of course, Dan from Publicly Buzzed. And Feral Fridays tonight, y'all. Make sure you're going to check out Feral Friday. I'm sure they're going to be on kicking it down low. I don't know if they ended up deciding to do Groundhog Day, because today is Groundhog Day. The word on the street is Puxatawny Phil predicted it's going to be in early spring. So that's good news. Rick, let's see. All right, now I feel like Steve. Nekieta. I'm going to go with Nekieta. Seems right. Rick Nekieta, $5 holla. Appreciate you. Thank you so much. Meg P, an always giver. 5 gifted memberships. Appreciate you. Shannon, an always giver. Thank you so much for that. And I thank you for expanding the community as well. Dara, an always giver. Thank you so much. We appreciate you. You know this. And Meg P, again, another 10 coming through hard. And then Dara, 3-month member. So that'll do it, y'all. So look, you guys are amazing. There's obviously been Delphi news. I've been streaming for now 8 hours and 45 minutes. Scarlett has a softball tournament in a dome tomorrow. And believe it or not, believe when I tell you this, I have to have her to the field, which is 45 minutes from our house, by 5:45 a.m. for a 7 a.m. game. So I really do want to, like, y'all know I'm all up in the Delphi thing. Like, I'm sure the world's going. Yeah, exactly, Stevie. I'm sure that the world's going nuts on Twitter and everywhere else. And like I'll make a decision. If I go live, I'll of course give you guys 0 notice. But I'm going to have to eat. I haven't eaten all day. I didn't even take a lunch break. This is 8 hours solid. 8 hours solid. I put in the work today. So thank you guys so much for hanging with me and hanging with Jay and hanging with Allie for all this time. It's an unbelievable day. It was really my first day trial streaming. I hope it was good. Aside from my terrible tech skills and, my overall glitching and my commercials during my stream, all that stuff. Hopefully the content above and beyond that was great. And because we love doing it. We love talking to you guys. We love hearing from you guys. We love discussing issues from the true crime community that we all love so much, because it's everything for us. And Shannon and Jay, they should be snuggled up in a booth at a restaurant, gazing in each other's eyes lovingly, wishing each other a happy anniversary. I love you both. I hope you guys are having a great night out. And I'll see you guys when you get back. And just remember, y'all, without y'all, I'd just be an old man talking about an old case. Talk at you next time. See ya. Boop. Wait, my mods. I always forget to thank my mods. Mods, I love you. Thank you, thank you, thank you, thank you, thank you, thank you, thank you so much. Stevie, Mandy, Missy Mayhem. I know Amber was in here. Like everybody that was in here, Diz was in here. Everybody, Fofo was probably in here. I can't see like all of you guys that are in here. You know who you are. You know I love you. I appreciate every single one of you. You're amazing. Thank you so much for all you do for us. We beyond appreciate it. All right. Back to the outro.